Commissioners, let's start. Good morning, Mr. Brockman.
Good morning, ICG.
Did I pronounce your surname correctly?
I can't believe it. It's 100%.
Oh, thank you very much.
Thank
you very much. We welcome you to this session of the Commission's interviews, and we thank you for making yourself available for consideration for appointment as a judge of the High Court. Now, I haven't seen the, oh, there is the JP. We welcome the Judge President of the Mpumalanga Division, Judge President Lekhodi. Welcome, my brother. Thank you. I have been told that the Premier is also here. I want to welcome her. I'm assuming she's physical because I wasn't told. Oh, there she is. Yeah, okay. Welcome, Premier. Thank you for making time to be with us. Thank you very much. Mr. Brockman, you hold the degrees of B. Juris and LLB, which you obtained from the University of the Free State.
That is correct, CJ.
And you obtained the B. Juris degree in 1983.
It's correct, ICG.
And the LLB in 1985.
That is correct, ICG.
Yes. And you started, thereafter you worked for the South African Defense Force, is that right?
No, that was before ICJ, before
I
started
that was before
studying.
you obtained your degrees. Okay, all right. And then you worked for an insurance company. You became an academic assistant, then you served your articles of clerkship, and you were admitted as an attorney in 1987, is that right?
That is correct, I see.
Yes. And then you practiced as an attorney in a firm called Fester and Brockman from 1987 to 1995, is that right?
That is correct, ICJ.
And then after you were at, is it Roseau Kutsi?
That is correct.
Yes, 1996 to 2004. And then you had your own law firm established in 2004. And you had that law firm up to 2008.
That is correct, ICJ.
And then you became an advocate, is that right?
That is correct, ICJ.
That is from 2013.
In June 2013.
In June. What happened to you between 2009 and June 2013? There seems to be a gap here.
So I can just get there. I practiced, if there's a gap in my...
In the questionnaire.
In the questionnaire.
Yes, page 11 of the questionnaire, at the top, under question or paragraph 6.
I wasn't, that is a mistake. I wasn't attorney until 2013, ICJ. That is a mistake.
Oh,
There wasn't a gap. I was removed from the role of attorneys at
yeah.
my own instance, and a month later admitted as an advocate. This is a mistake.
Yes, okay. So where you were a sole practitioner, where it says 2004 to 2008, it should say 2004 to June 2013. Is that how it should read?
That is correct, ICJ. I was a sole practitioner until June 2013, when I was removed as an attorney
Yeah,
at my own request.
yes. When you started practicing as an advocate, had you done pupillage or not? I'm just looking at the time. It doesn't look like.
I became a member of the National Bar Council of South Africa. I applied, and when I applied to do pupillage, I was exempted. Due to the experience I had in litigation. I had a litigious practice my whole life.
Yes. Okay. And you have been practicing as an advocate since then, but I see that you've got Just Cole as you were head of legal.
I ventured into the mining at the insistence of a friend for a year, which I hold very dear at this stage, because it, especially for the environment in which we operate, our division or our local seat, I picked up a lot of experience in mining, coal mining and the relevant mining, and especially the labor around it. I worked there for a year, ICJ, as the head of legal, and then returned to the practice just after the local seat was established there.
And then after a year, you came back and continued with your practice as an advocate.
That is correct.
From June 2016 to date. And then in 2019, you got an opportunity to act.
That is correct.
In the High Court.
That is correct.
Was this in Mpumalanga?
That was in Mpumalanga, in Middelburg, I see.
Yes.
That was when Mpumalanga was still part of Gauteng.
Yes. Okay. So how long was that acting stint?
ICJ, I acted...
In terms of months or weeks?
Of weeks. ICJ, I can tell you, it was 98 weeks, of which 32 weeks were in the criminal court, and 69 weeks in the civil courts, which includes motion court, urgent court, civil trials, reviews, appeals, everything, bail applications, etc. And it was in Middelburg, but I also served in Bombela.
Okay. So it is the position that from 1987, when you were admitted as an attorney, up to now, you have practiced as an attorney and as an advocate, except for that interruption when you went to be head of legal at Just Cole.
That's correct.
And that was just 1 year.
That was 8 months.
8 months,
basically.
So that gives you how many years
it's about
experience in practice?
34.
34 years.
Yes.
Yes. Now, when you were practicing as an attorney, could you share with the commissioners what kind of cases, what types of cases you were doing in your practice?
Initially, ICJ, like any young attorney, you were thrown into the criminal courts, where you get very good experience, and where you actually formed as an attorney, a trial attorney. Thereafter, I became involved in insolvency law. A lot of insolvency law. I became known as an insolvency practitioner, if you can call it that, not an insolvency practitioner. I did liquidations and inquiries, insolvency inquiries. I did a lot of divorces, many divorces. I became also well known in that vicinity as a divorce lawyer for women. I did a lot of labor work eventually. Once you become a practitioner, and I initially wanted to specialize in customary law, but your clients don't allow you. They pick your forte for you, and they picked labor law for me, which I enjoyed tremendously. I did all my appearances in the labor court myself. ACJ appeared one day before you. I will never forget it.
Oh.
My documents were in Afrikaans, and you
What did I
addressed
say
me.
to you?
You addressed me in Zulu. And when I looked at you like a fool, you said to me, that is why we do things in English in this court. And from there, I loved the labor court. The labor law is very dynamic. And you can't, if you're out of it for a month, you miss out. I also eventually in my practice started doing, or not eventually, I did a lot of commercial litigation, commercial work, property transfer work, ACJ, estates, everything that an attorney does. As we call it, the platteland, you don't really have a choice. You do what. I was never fortunate enough to be on bank panels, to do bank work. I was always on the other side. But I think on the other side, you learn more about a bank than working for a bank. So I was fortunate. I did it. I was born in Ermelo, and I've done all my practice in Middelburg. So I am an indigenous, a person from Mpumalanga. Spent all my life there. My practice mostly. I also almost never used advocates. I did my own work because I love law.
So you must have acquired a lot of court experience because you did your own appearances, you argued matters yourself, you conducted trials yourself.
That is correct. I also drafted my own papers.
You drafted your own papers as well.
I did.
And did that include those cases which were going to the High Court?
That includes that.
Yes. So that would have given you enormous experience.
It did give me a lot of experience. But I must also say, ACJ, coming from there, from Middelburg, your experience in the High Court was really limited, and especially because I did a lot of labor work. My experience my experience in High Courts was mainly in the labor court, which is also a High Court. You've also got the butterflies every day you go there. I've got butterflies every day I go to a High Court but I've got reasonable lot of experience.
When you started practicing as an advocate, to what extent was there a change in the nature of cases that you did, or the nature did not change?
No, it changed. It became more. I've got more difficult matters. The moment I became an advocate, ACJ, it wasn't the run-of-the-mill things. Obviously, because you're an advocate, everybody thinks you know more now, but it's not really so. It's just that you specialize, but there was a difference. But I enjoyed it much more. Because you've now got time to read.
Yeah.
As an attorney, you don't have time to read. You've got time to read your administration. That's your time that you have.
And are there some cases that you did which got reported over time?
As an attorney,
As an attorney and as an advocate?
As an advocate, as an attorney, let me start there. There was one that I appeared in the Labour Court, and then as instructing attorney, about 3 that was reported in the Labour reports.
Yes. And you have done motion court in the High Court as an advocate.
Yes.
And probably you have done it also as an attorney in the High Court.
As an attorney in the High Court and as an advocate.
Yes.
I'm mainly briefed in motion work when I practice as an advocate.
Yes.
ACJ.
Okay. No, thank you. Judge President Lechodi.
Thanks, Chair. I thought I was pronouncing your surname correctly all the time, and it's only today that I realized that I was wrong, but you never told me.
Wise men keep quiet.
Okay. Okay. You. This is your second time. You were here in April.
That is correct, Mokone.
CJ, Chair, did you hear that one?
I didn't hear that one.
Well, he's referring to me as Mokone.
And is it out of place? Because
no, it's not out of place. I just wanted them to know that I'm Mokone, and that's how the people in my village they address me. And all the time when you do that, you see my smile. And thank you so much for that.
I'm in your village, Mokone.
Okay, thanks. Thanks. Now, how many judgments have you written so far?
Mokone, I have written...
Just a number, if you can, on an estimation.
I'm not going to give an estimation. I've written judgments 118,
okay,
which consists of 87 written civil judgments, that is motion and trials, criminal judgments 16, bail appeals 12, and criminal appeals 3. Then my extempore judgments are 83 that I did.
You are currently acting and you have been placed in the criminal court because we have a backlog. You are going to be there with us until the end of the term. Do you have any reserve judgments?
No reserve judgment, Makua.
What was your longest reserve judgment? What was the time frame?
I think it was just more than a month, Mokone. Most of my judgments in motion proceedings are ready the day I hear them. And please understand me correctly. It's when I receive my files to read, I start preparing my judgment already. So most of the commission or practitioner says that I prejudge motion court matters. You can't prejudge it. I've got the heads and I've got the papers. So once I've heard it, I normally hand down that judgment the next day in all opposed motion matters. Trials take a little bit longer. It'll take about a week. Bail appeals is same day that I receive it.
And what magic do you perform to be able to hand down your judgment so expeditiously?
I work. I love my work. Mokone, I didn't know when you asked me to act that I would love the job as much. This is what I want to do.
Okay. Now, the last time when you were here, you are aware that there was a concern which was raised, and that concern is still raised, and I think it's a concern that is actually justified. One should not underestimate the importance of that of that concern which has been raised, and this is in relation to the judgment that you handed down, and you'll see from the GCB as comment paragraph 4.3 and 3.1 that that concern is still raised even now. And you'll also see that Nadella, and fortunately the Honorable Commissioner is here next to me.
Yes.
They have raised it, and it's a concern that one should not take it lightly. Do you want to deal with this issue, or do you prefer to deal with it at a later stage when the commissioners ask you questions?
Mokoni, I can deal with it now, and I'll also deal with it later if they want to ask me questions about it. I've dealt with it. The transcript is I think.
I'm sorry. I think deal with it for transparency. Let people, let the public hear, because the public hears that a concern has been raised. They must know what the concern was and what your response is.
They
don't have the papers that we have.
ICJ, it was just that Mokoni asked me, do I want to deal with it now or later?
Yeah.
I will deal with it now.
Yeah, deal with it now. Yeah.
It was a matter that and Commissioner Madonsela knows about it. A matter that right at the beginning of the lockdown, the hard lockdown last year, where I wrote a judgment about practitioners that, amongst others, passed borders when the provincial borders when the hard lockdown was in place. What I did then is I made an order that none of the practitioners were allowed to charge their clients any fees for the work done, due to the fact that they crossed the borders. That judgment, the ink was still wet on that judgment, and I was flooded with applications for leave to appeal by the individual practitioners, saying I didn't afford them the opportunity to address me before I wrote the judgment and deprived them of their fees. They were correct. I addressed it last time. ICJ, fortunately, we've got checks and balances.
I think I've read somewhere that my younger brother was among people who had that.
I believe it was
that situation.
I believe it was your younger brother.
So you must tell me what you want me to do.
Actually, if I'm not mistaken, no, Mr. Madonsela didn't act for him. Mr. Willie Makare acted for him.
I may be acting for him actually. It's just for me today.
I can't remember, Mr. Madonsela. I know you acted for Mr. Ngongwane, very ably so as well.
But I was mentioning that so that you can tell me if you don't want me to sit here. I can let my sisters sit.
ICJ, I've watched the interviews and I've watched the State Capture Commission. If you are not beyond reproach and unbiased, I would have asked you. I think that is above. I don't know what the English is. It's above reprieve. It's not even in dispute.
Okay, no, that's fine.
Otherwise, I would have done that.
Yeah. Okay. All right.
What I did is there was an application for leave to appeal. I granted leave to appeal, and I tried my utmost best to have that appeal get heard. But you must understand, I didn't act since, I think it was April or May. I acted when Lutendo was very sick, Sigogo was very sick. I stood in for him. But I tried to have that appeal get heard as soon as possible, but it seems like the attorneys are dragging their feet. Be it as it may. I'm so glad. There are checks and balances in our country, ICJ, and it's fortunate that it is. After I did that, I went and read some judgments and found that there were two judges that also did the same thing and got big trouble. It was Judge Fisher, I think, is one, and the other one is the one that wrote the comments on the old MVA Act or RAF Act, Satchel. So I learned from it. Fortunately, I learned from it, and I will never do that again. And then that is only in respect, it's not only in respect of not giving a person an opportunity to talk, but I learned a lot from it in the sense it made me a better person, it made me a better lawyer, it made me a better judge. Within limits, I afford people more opportunity to address me now. So, if there's anything else on that, that is what happened, and it's unfortunate that it happened.
Okay, thank you.
Thanks, Chair. Thanks, Chair.
Continue, Judge President, unless you are done.
No, I'm done.
Oh, okay, all right. Premier, I now give you an opportunity to put questions to the candidate if you wish to.
Thank you very much, AC Chair. Good morning, Advocate.
Good morning, Premier.
You might just wish to speak up, Premier, so that we can hear you. Maybe bring closer, that's fine.
Okay.
And bring the mic closer to you.
No, thank you very much. And how are you, Advocate?
Premier,
I'm afraid to call your surname because I'm no longer sure how to pronounce it. Just to be safe.
Mokoni will tell you I prefer to be called by my name. My name is Hein. So I'm very well, thank you, and you, Premier.
No, thanks. Thank you very much.
Second time I see you, and it's always good to see you.
Thank you. I really appreciate that. Just one question from my side. I just want to check, in your views, of course, on the role the judiciary must play in leading the process of land restoration in light of, specifically in our province, especially in light of the fact that we do have quite a huge backlog.
Just hang on one sec, Premier. Can everybody hear? You're fine. Okay,
So,
all right.
So they can't hear me?
No, they say they can, so it must be my problems.
Oh, okay. No, I can repeat.
Oh, you're struggling. Okay, try and raise your voice.
I can repeat ACJ. Sorry, my apology. No, I just want to ask the question to Advocate. What would be his views on the role the judiciary must play in leading the process of land restoration in our province, especially in light of the fact that we do have quite a huge backlog that is being put before the High Court?
Thank you, Premier. The first thing I think should happen is that a land claims court, or at least, if I can call it a branch thereof, should come to Mbombela with, and the judges in our division should receive training to handle those matters. We should remember that the land claims court is in Randburg, as far as I know. It is really far for all these, the claimants to travel. The judges, as judges, we should actively then become involved. Also in Middelburg, there should be a land claims court. I also believe there must be a labor court in Mbombela and in Middelburg, ICJ and Premier. Judges are becoming involved in land restoration. In that sense, I think, Premier, is very important. The sooner that happens, the better for all the people in Mpumalanga. I know there's a very, very, very huge backlog of land claims there, and that will address it much faster. Even more than one judge should be allocated to that. That should become a priority in Mpumalanga, in both seats of the division. And you must remember that the judges, the land claims, the legislation surrounding land claims are to a large extent really specialized. But all the judges in Mpumalanga are very competent people. If you train them properly, and most of them are reasonably trained as far as that is concerned, a little bit of training will go a long way to alleviate the problem at this stage. That is what I think, Premier.
Now, thank you very much for your response, which then takes me to a follow-up question in light of what you've just alluded to earlier on. Now, what do you think, how best can the judiciary align equitable, transparent and cost-effective access to judiciary services with the need to effect purposeful transformation to reflect the socio-economic condition in our province?
Oh, you speak to my heart, Premier. You speak to my heart. I penned a judgment in my division without Makoni knowing it. Came as a surprise to them. Although it was overturned in the SCA about access to justice, my view was that matters within the jurisdiction of the magistrates' courts should not be instituted in the High Court at all. That's one. And then our people, I'm talking white, black, any people, all enter into credit agreements. And especially now when we fall in arrears, what happens is they run to the High Court to enforce those credit agreements. I made a judgment which was overturned, and correctly so, by the SCA. That my judgment wasn't overturned, other judgments were overturned, but mine was in line. To say that every judgment, every matter that is a credit agreement related matter should be instituted in magistrates' courts. There are many magistrates' courts in our province. There are only 2 high courts. The high courts are very busy. Further, I think my opinion and my view is criminal courts, high courts, should be established in more centers in Mpumalanga. We've got a massive problem with crime. I personally sat in many femicide matters. None of them went on appeal, and Premier, you can go and look. I'm not an easy judge when it comes to that. There should be, at this stage, we've got Graskop, Nelspruit, or Mbombela. We've also got Brighton. You know where it is. These people won't know. That's where Nasbota comes from. Middelburg, and we had Delmas. But due to the financial constraints, I hear they have to close either Middelburg or Brighton now. We've only got Graskop, Mbombela, Brighton, and Middelburg at this stage. It's not sufficient. I postponed personally 5 matters Monday to dates far away in 2022. The matter I'm sitting with now is going to take about, it's a horrible matter, it's going to take about 2 months. So my opinion is the High Court should be decentralized to different places in Mpumalanga to make access to people, for the people to the courts much easier. If that addresses your question, Premier.
Thank you very much for the response. I've got no further question, ACJ. Thank you very much.
Thank you, Premier. I'm now going to allow Commissioner Nyambi to ask one question. Before he does so, Mr. Brockman, I would advise you to try your best to not to give long answers, but in the end, I do want you to be satisfied that you have done justice to the question by answering. So just strike a balance.
I will do so.
If we have to try and manage the time better.
I will do so, ACJ. Thank you.
Okay. Commissioner Nyambi.
Thank you, ACJ. Morning, Advocate Brackman.
Morning, Commissioner.
Now, the first part has been correctly covered by the JP about the last interview. I think he has done justice to that. We can't keep discussing it as if it's new. But over and above that, my only question is in relation to your understanding of the challenges of the division that you think you'll come handy to assist the JP and the division to improve. As somebody that is from that province and you have acted, the immediate challenges that you think you can address. In doing that, also touch what you think has improved the last time you were here and now, so that we can seriously consider you this time around. Thank you.
Thank you, Commissioner Nyambi. The first portion of your question, I can assist the JP in that province. I come from Middelburg. My dad always said, you get your brains when you're 30. I got my brains there when I was 30. I practiced there. I know the people. I know all the towns around Middelburg. I know most of the courts. I know the court personnel. I know the court personnel in Middelburg. I know the culture in Mpumalanga. As far as the court is concerned, I live peak traffic, 2 minutes from the court. If there are urgent matters, I can attend to it immediately. I can be in court every day now in COVID. We don't know how long it's going to last, Commissioner Nyambi. I can be in court every day. I can assist the JP physically by being on the ground while he's in Mbombela, and the other judges are physically not there. What changed since the last time? I realized that a judge should never be arrogant. A judge should never think he's above the other people or above the practitioners. I also realized that you should always afford somebody the opportunity to speak, although you think he's wrong. Even if you know he's wrong, you should afford him the opportunity to speak. I also learned to become more humble as far as that is concerned. I also have more self-confidence since the last time, and the times that I acted since the last time, I really enjoyed it, Commissioner Nyambi.
Thank you, Advocate Bradman. Thank you, ACJ.
Thank you, Commissioner Nyambi. Commissioner Jesse.
Thank you, ACJ. Advocate, you were only here in April. That is when you were asked about this question. It was in April.
Would you please speak up?
Sorry. What I'm saying is, according to this record, I wasn't here. You appeared in this commission on 21st of April.
That is correct, yeah. Commission.
Now, the problem about that case that you were discussing with the JP is not about you granting orders or granting the order you have granted. Is your understanding of the Constitution. That's the biggest problem. And now, the apology, the acknowledgement that you talk about, it has something to do with you realizing the question that I want from you, which clearly I accept from here, that you have no basics of the Constitution. Have you now studied the Constitution, understand? If you did, which course did you attend? How can I be satisfied that you now know that if you are to make an adverse decision against anyone, you need to hear that person? Because that's a Constitution, is a fundamental principle of law, which you actually did not know from your own words, because you learn after that order, and that's why you regret.
Thank you, Commissioner Nyotesi. I did not attend any course. I discussed the matter with, I was acting at that stage with most of the judges that was with me. assisted me to understand exactly how how it should have worked. As far as the Constitution is concerned, Commissioner, I made it my personal aim to start studying the Constitution and judgments dealing with it. Since then, because I realized it was a problem. I also started reading a lot of judgment from the Constitutional Court dealing specifically with basic rights that I might miss. But I feel that I've, from my brothers and sisters on the bench, since then, the Deputy Judge President and other judges in the division, I sat and I had brotherly talks with them, and they assisted me and trained me and sensitized me as to that aspect of the Constitution, and even more than that. Because I realized at that stage I needed it. That is the training I had since then.
Chief Justice, if I may follow up, but I know
Yes.
you may.
Okay.
Look, I'm sorry, it's a follow up. My problem here, you seem not to differentiate. It's only 5 months from April up to now. Something that you never knew for the rest of your practice, that the fundamental principle of our law is audi alteram partem rule. That's what even at the university we're told. You only say, from April up to now, I consulted other judges, I look at the cases. Do you think that is enough? Because you simply have no basic understanding of the Constitution. That's what I'm putting to you. And lastly, as you answer this question, the judicial independence, do you accept that it is affected by the inability of a judge to understand basic principles of law? That's a threat against the independence of the judiciary. Thank you, Chief Justice.
I understand what you say, Commissioner. May I say to you that the basic tenets of the law, the audi alteram partem, I knew about it. I made a mistake at that stage. I knew about it. I didn't have to be retrained or trained about it. I had to be trained as far as the balance of the Constitution is concerned, applying the Constitution in other matters. And that's why I said initially when Makone asked me, when I said, I'm so glad there are checks and balances which can right the wrongs. If no judge made mistakes, and there was Judge Satchwell made the same mistake. Judge Fisher made the same mistake. Fortunately, we've got the system of appeals. If nobody made mistakes, there wouldn't have been lawyers or appeal courts. It is not that I do not know. I knew it, I made a mistake. And I owned up and I fell on my own sword during the April interviews. So I think I know, I wrote a couple of judgments on the Constitution as well, which I think are good judgments, even before that.
Thank you, Judge President Mlambo.
Thank you very much, Acting Chief Justice. Good morning, Mr. Brockman.
Good morning, Jay Malama.
Before I ask my questions, I just need clarity. Am I correct that the main division is, the main seat of the division is in Bombela, but the seat in Middelburg also has concurrent jurisdiction with that of the main seat? I think the JP can also correct me if I'm
No, we don't have concurrent. There's a small portion where we have concurrent jurisdiction, that is in Belfast. But we don't have concurrent jurisdiction, JP Malambo. JP can assist you there. But we don't have concurrent jurisdiction.
Okay. Now,
and that is exactly for the reason for access to justice, JP, that we do, that it is. How can a plaintiff be arrogant enough to issue a process out of Mbombela while the plaintiff lives in Delmas. How does that plaintiff, who's already financially distressed, get to Mbombela? Middelburg's much closer.
Okay. Let me ask my main question, Acting Chief Justice.
Okay.
You know, the court used to have circuits in Mkobola.
I know that.
Which is part of the old Kwandebele. You have a litigant being sued by, it's a foreclosure application for 100,000 rands in Mkobola, who is sued to come to Middelburg. That's the court that has jurisdiction, am I correct?
That is correct.
And he comes before you with the bank and its lawyers. He is unrepresented. How will you approach that matter? I've put a number of factors to you. Just make sure you understand what the factors are. The amount of the claim on which the foreclosure application is based is 100,000 rands.
Yes.
And he lives in Mkobola, where there's a magistrate there, a magistrate's court.
Yes.
And the bank institutes the application in Middelburg.
Yes.
He is unrepresented. How will you deal with that matter?
I'm going to be very brief. I normally do it. I transfer the matter to that court. I make an order transferring the matter to that court. And I'll also say to you, JP, where the contract stipulates that normally, in terms of the agreements, they would have agreed to the jurisdiction of the magistrate's court. What I do is I, out of my own, transfer that matter, will transfer it to Mkobola Magistrates Court. Because that is in the interest of justice.
One last question, Acting Chief Justice, but isn't that against what the SCA ruled, that the High Court has inherent jurisdiction over all matters, even matters that fall under the Magistrates Court? So on what basis would you then transfer the matter to Mkobola if the SCA, whose judgments bind us, by the way, has ruled that the High Court must hear that matter because it has been raised in the High Court?
I still have a jurisdiction, a discretion. For instance, matters, we get panel beaters or towing places that issue summons for 14,000 rand in the High Court. I normally transfer that to the Magistrates Court, the relevant Magistrates Court, and say, do the matter there. In the alternative, what I can do in that matter is, for only 100,000 rand, JP, if they come to the High Court for a person living in Mkobola, I would assist that plaintiff by telling him or defendant to go to the bank personally, not to attorneys. It only costs money. Go to the bank personally and attempt to make an arrangement. I would then postpone the matter to a later date for them to come back. And I will also institute an investigation into what was the initial debt. If it's the initial debt is a large amount and they've paid a lot, most probably I will not assist the bank because the amount is 100,000 is a minimal amount, JP Mlomba.
Thank you very much. Thank you, Acting Chief Justice.
Thank you, Judge President. Commissioner Shabangu Mdawe.
Thank you, ACJ. Good morning, Advocate.
Good morning, my sister.
Advocate, you are a Mpumalanga boy, right?
Thank you, pardon?
I'm saying you are a Mpumalanga boy.
Born and bred. Born and bred, my sister. Born and bred.
So you understand the challenges that women in Mpumalanga are facing. 1, the gender-based violence. 2, the domestic violence, where cases are very high. And the other one, the huge gap that exists between
women and men legal practitioners, where women most of the time are not exposed in other legal field. As an advocate, what is it that you have assisted in promoting transformation? And what is it that you have done to assist those women who are faced with these challenges of gender-based violence? And when you are considered in this position that you're applying for, what is it that you are going to do or assist women in dealing with these problems? Women legal practitioners and also women in general.
Thank you, my sister. I'm going to start with the last briefly. If I'm considered and appointed, I will proceed to do what I'm currently doing. I'm passionate about what you're saying about gender-based violence. I've got 3 daughters. The amount of gender-based violence matters in Mpumalanga is shocking. That is all I do in the criminal court. I haven't done any other case. I think through my judgment, I speak to the community. I keep it simple. My judgment are handed down the day after the trial. And my disapproval of gender-based violence is reflected in my judgment. What I did while I was an advocate, when I was an attorney still, I only had female candidate attorneys. I even had a female partner, and most of them weren't white. And it wasn't because I felt I wanted black partners. They were really the best. And most of the women that lived with me, I paid for her daughter's university that worked for us. And she died in my arms as well. At my home. They lived with us in the home. My wife and I regularly have women scholars that we pay their rent at boarding and lodging for, and school fees in Middelburg. But that is from long ago that we started doing that. Legal practitioners, all female legal practitioners are welcome to phone me for assistance and advice, free of charge. I never charge for that. And as far as possible, I would train them. I'm also a member of SOLA, and honored to be what do they call it? A friend of SOLA. Training of all persons, especially women in Mpumalanga, is very close to my heart. My own daughter is also studying now to become an attorney, and she's got a female attorney, a clerk, living with her. I regularly go for training sessions there. So that is very close to my heart. And it's always been, Commissioner.
Can I have a follow-up, JP?
Okay.
Advocate, can you just mention maybe a few women lawyers that you have maybe trained?
I will. I've trained, actually made a note, because I always say to people, I'm not like those preachers who remember everything out of their heads. I've trained Natasha Oret. She eventually took over my practice when I became an advocate. Before that, it was Farzana Juma. Before that, it was Renel Veldhagen. Before that, the one Indian lady, I can't remember her surname at all. There was so many, I really can't remember their names. The one's name is Jenny. I trained her, and most of them have gone far in the profession in Middelburg. I work with them daily as well. There was one, she passed away unfortunately. That was long ago when I was still in partnership at Rousseau Coetzee. It was the first black candidate attorney in Middelburg, was my candidate attorney. We also had the first black typist in a Boere town, which didn't sit well with most of our clients, but didn't bother us at all. Those are some of the names that I can recall, Commissioner.
Thank you, Advocate.
They're all admitted attorneys now, Commissioner.
Thank you, sir. Thank you, ACJ.
Thank you, Commissioner Tsepe.
Thank you, ACJ. Good morning, Advocate.
Good morning, Commissioner.
Mine is a bit of a follow-up from your earlier conversation with Commissioner Nochesi. My understanding from the comments from the GCB is that there is still no indication that the candidate is experienced in constitutional matters. Yes. So what I wanted to ask you is, over and above the activities you mentioned to us of what you did to immerse yourself in understanding of constitutional law, have you had any matters as a practicing advocate in this period where you dealt with constitutional matters, or that would have come before you when you are acting in Mpumalanga, that could help us deal with this concern that has been raised by the GCB? Thank you.
Thank you, Ms. Commissioner. I certainly had. One of the matters were a matter of Governor Mbeki municipality versus, just can't remember the defendant's name, or whether they're still litigating now. Where I declared the agreement unconstitutional. There was another case of Kaya Pixley municipality that involved a pipeline that was going to be laid and an interdict that was sought against it for non-compliance with the Constitution. I specifically had another matter where section, in terms of the Magistrates Courts Act, only a defendant can transfer a matter to the High Court. And the JP specifically had that matter separate or set down to be dealt with in terms, I think it's Rule 16, to find whether it's unconstitutional. I had to go through the whole motion just to find that I don't have to deal with it. I dealt with that matter. There are various matters that I actually dealt with while I was a judge or an acting judge, where the Constitution, and it comes in daily, like in the matter I'm involved in now. The Constitution plays a huge role as we are busy with confessions, admissions, pointings out, etc. So I have to deal with it. I deal with the Constitution, and while I was an attorney, I dealt with it a lot in the Labour Court.
Thank you, ACJ. I'm covered.
Thank you. Commissioner Slema will be the last one, and then I'll go to the commissioners who are on the virtual platform.
Thank you, ACJ. Good morning, sir.
Good morning, Professor.
Would you like to share your judicial philosophy with us?
My judicial philosophy, Professor, is a simple one. I believe in fairness. I also believe that justice must be done and not only must be done and not only be seen to be done. I believe that all people are fair and equal before the law and must be treated as such. I also believe that it doesn't matter what my personal beliefs are. I must deal with the problem that is before me, A, in terms of the Constitution, and B, in terms of the country's laws as it is.
May I follow up?
Okay.
You differentiate between the Constitution and the rules of law. Can you just explain that?
Maybe I expressed myself incorrectly. The Constitution is the overlay. All laws must be looked at through the Constitution. But when you apply, when you're busy dealing with something, there are certain rules of law that you have to apply. First of all, they must comply with they must be in compliance with the Constitution to apply them. But those rules of law must be applied, never mind what your personal belief is. Even what my personal beliefs are, the Constitution is overarching over that as well. I have to look at a problem through the prism of the Constitution and have to apply the law accordingly. But I'm talking now about, maybe I don't express myself correctly. I have to apply the law, which includes the Constitution, to every problem, no matter what my personal conviction is. I have to fight, Professor, for your rights, even if I don't believe in them. That is what I might do. Even if I think you're wrong, and in my view, I have to fight for your right to believe that.
Thank you, CJ.
Thank you. Commissioners on the virtual platform, any question?
Good morning, JPs and other commissioners, and of course the candidate. Good morning, Mr. Brockman.
Good morning, Mr. Barnard.
I'd like to speak to you about judicial temperament, simply that, is it something that one can improve over time, or is it something that you either have or you don't have? And then against that backdrop, if you can just discuss your judicial temperament.
Judicial temperament, Mr. Barnard, is something that I don't think you know you have it before you start acting. And it's something that your brothers and sisters on the bench help you with a lot. I'm a very patient man. I'm so patient that my wife always asks me, why don't you fight back when she fights with me? I don't like fighting or getting into scourges, and that's the way I treat people in court. I treat all counsel and unrepresented parties equally. I think that judicial temperament can be improved to a certain extent by, if you talk to your seniors, like the DJP and McCorney, they can teach you and they can develop your judicial temperament, but I think it's something that is born into you right from the word go. And it's coupled to your own patience, the patience that you have.
Thank you, ACJ. Thank you, Mr. Rothman.
Thank you very much.
Good morning, Acting Chief Justice. It's Glynis. May I ask a question?
Yes, please go ahead. Good morning to you.
Good morning, and good morning to everybody. Good morning, Mr. Brockman.
Good morning, Commissioner Breitmar.
I have a simple question. What, in your view, is the one most important attribute of a judge?
Independence. Independence, and that to me is the most important attribute.
Thank you very much, sir. Thank you, Acting Chief Justice.
Thank you very much. There is nothing further from the virtual platform. I think we have come to the end of the interview. Thank you very much, Mr. Brockman. We appreciate that you made yourself available. You are now excused.
Thank you, ICJ. Thank you, Commissioners.
Next candidate. Good morning, Ms. Freilin Kutze.
Good morning, CJ.
I have a suspicion that I didn't pronounce the part of your surname correctly.
No, you were quite correct. It's Freilin Kutze.
Yes, okay, all right. Welcome to this session of the Commission's interviews. Thank you for making yourself available for consideration for appointment to the Mpumalanga Division of the High Court.
Thank you, ACJ.
You hold the degree of LLB, is that correct?
That's correct.
And you got it in 2008.
That's correct.
You worked as a law research assistant from 2004 to 2005 in that same university.
That's correct.
Okay. And you got admitted as an advocate in 2010.
Yes.
Yes. And you have been practicing as an advocate from that date up to now without interruption.
That's correct.
What types of cases have you been handling in your practice for the past 10 or 11 years?
Initially, I started with criminal matters, some RAF matters and matrimonial work. That then evolved when I joined the Johannesburg bar to a more commercial practice, wherein I did a lot of banking, property, insolvency work, both opposed and unopposed motion work, and then trial work in addition to that in relation to contractual disputes. I still retained a portion of the matrimonial work that I have done before, and I continued with that. I also got exposure in labor disputes on various levels, from the CCMA through to the Labor Court, and that evolved to being exposed to administrative work and some environmental work as well. And all of that will be inclusive of motion, unopposed, opposed, as well as trial.
Yes. So there is environmental law involved, there is commercial law involved.
Correct.
And what were the other branches I may have missed?
Property, a lot of property work, some insolvency work,
yes.
Banking law, recoveries.
Yes. And have you done any constitutional litigation matters?
I have done limited constitutional litigation matters as an advocate. I've appeared once in the Constitutional Court as a junior, which related to the National Credit Act. And then I've done an extensive opinion a while back together with a senior on constitutional matters relating to environmental law. That was a balancing of the opinion we did was about the local mandate, or I beg your pardon, the constitutional mandate to local environmental inspectors.
Okay. Have you acted in the High Court?
I have indeed.
For how long?
Currently, it will be 55 weeks, but I am now continuing until the end of the year, so that will then add another full term.
Yes. Judge President.
Good morning, Acting Judge Freilin Kutze. You look like a true counsel or advocate, so to put it.
Thank you, Mokoni.
Thank you so much. Now, this is the first time.
It's the first time.
You can take comfort from the fact that you are in good hands.
Thank you, Mokoni.
These commissioners are here to perform a very important job, and as they engage you, take it in good spirit, knowing very well that they are more interested with what is good
for the judiciary and what is good for the people that we are meant to serve. How many judgments did you write since you started acting to date?
On my count, it's approximately 76 judgments. That would be excluding the extempore judgments which I have given.
May I ask you to speak up a bit so we can hear your answers?
Thank you,
Maybe
ACJ.
bring the mic closer to you. That might help.
Thank you. 76 written judgments.
Okay. And how many judgments are you having as outstanding presently?
I've got 2 judgments outstanding. Both of them were reserved in September. That was trials that I did during the last term.
What is the longest period that you ever took to complete judgment?
JP, if you could also speak up.
What is the longest period that you took to complete or hand down a judgment?
3 months.
3 months?
Yes.
Okay. Now, did you have the opportunity to go through the guidelines for appointment that was adopted by this body way back on the 10th September 2010?
Yes, I have.
Okay. One of the things that they are mentioning there is technical competence. I didn't know what is technical competence until I check on this. Have you gone through that? Did you see that?
I saw that.
Okay. Now, you are aware that there are comments that have been made, and let us just start with the one by Nadel. They're saying there is a room for you for improvement, but not quite ready for permanent appointment. And you would have seen that there is also a comment by the Law Society of South Africa. They recommend that you be given more appointments to act. Have you seen that?
I have seen that.
Do you want to deal with that?
Yes, please, Mokoni. I believe that in my 55 weeks, I have, in addition to my 11 years experience, which related purely to court work, have gained sufficient experience for permanent appointment. I have, in the 55 weeks, conducted myself in a manner where I have done the actual work. I've got no outstanding judgments other than the 2 of the last term. That for me displays the ability to effectively deal with the work. In our division, we get extensive exposure because we do everything. We don't only sit in trial court or only in motion court. We do, during a trial week, you would also have appeal matters, and during your motion court week, you'll do motion court as well as unopposed and opposed. In all the weeks that you act, you are exposed to the urgent court. So in my 55 weeks, I have done approximately 90 opposed motions, 900 unopposed motions, 108 trials, 36 appeals, and 48 urgents. So as I mentioned, the sums might not add up, but it's because we do, in the trial week, we also do the appeals, criminal as well as civil, full bench as well as full court. And then in the motion week, you'll do unopposed and opposed, and throughout you'll do urgents.
Speaking about doing everything, we were told earlier on that there are many criminal matters in the province. And the chair took you through your past experience. Now, the trials that you're talking about, would this include the criminal trials or is only in the civil work? And I'm just raising it because I'm sure that is also going to be a concern to the other members of the commission, because they might say that we need an all-rounder judge for the purpose of being able to deal with some of these issues, particularly as a new division. Do you want to deal with that aspect?
I would like to. Thank you, Mokoni. I have not acted in the criminal court within the 55 weeks, so my reference to trials will be civil trials. I am more than willing to act in the criminal court. I believe I've got sufficient experience and understanding of criminal process, and if not, then I know where to find whatever I find potentially might find as a stumble block. I can only imagine that, well, I did my acting stints in what I was given by yourself, Makoni, and I can only imagine that you utilized me where you needed me the most in the division. And that obviously will be informed by who else is there to attend to the other matters at the time.
Now, since last year, the division adopted principle that as judges, we should have meetings every Friday, and literally every Friday.
Correct.
Since that started, we have never missed any Friday.
No, we have not.
Even as in this morning and as we are here, there has been that meeting which took place this morning. Am I right?
Correct, that is so. I think today is my first that I have missed.
Do you want to say something about perhaps the value or non-value of these meetings?
I believe that these meetings are most valuable because it gives us an opportunity between the sitting judges and acting judges to interact, to share experiences in order to improve the division. We are a new division. We all grow together, and this gives us the platform to do it. It's a very informal meeting, and you can raise any issue that you would like at that platform. And it has certainly, for me, been a very good platform to develop myself where I thought I might have had a shortcoming or where I have thought that I needed assistance and guidance.
And it is also a meeting where colleagues from time to time they shed tears out of joy and sometimes out of sorrow. Am I right?
Indeed.
But I would not talk about that because it has happened quite very often.
Yes.
But do you think we should continue with this kind of meetings?
Definitely.
Okay. Thank you, Chair.
Thank you, Judge President. Premier, I give you the opportunity now.
Thank you very much, ACG. You can pass.
Thank you. And then I'll give Commissioner Matalo the opportunity.
Okay, thank you, Acting Chief Justice. Good morning, Ms. Freeland-Kutse.
Good morning, Commissioner.
We all know and we have heard that Mpumalanga has a lot of femicide, abuse against women, children, femicide offenses. I just want you to allay my fears in that I don't see any community participation from you, especially I expect judges from Mpumalanga to be championed that, to be able to, or practitioners in Mpumalanga to be champion going to the communities, at least to involve themselves, in the issues of gender-based violence and femicide. Can you just give us some examples, or do you do that, or I may be wrong?
Thank you very much, I beg your pardon, Commissioner. I have, my community in essence is the judicial community or the legal profession. I've spent the majority of my time, free time in that forum. In respect of, other than that, I have contributed to an organization called Meals on Wheels, which is not directly linked to domestic violence or femicide, which I have been contributing for 11 years to. In addition to that, I had a pet project, if I can call it that, in 2019, where I have collected matric farewell dresses to be distributed to Letty Fouchier School, which is a school in Bloemfontein where I was born. So other than that, I haven't done specific work in the community of Mpumalanga in respect of women. I have mentored female advocates. I have had 3 pupil advocates who are all female. I contribute in respect of the pupillage program at the Mpumalanga Bar, where we have, or the last 2 years, have had 6 black female pupils, assisting them with training. So the majority of my community-based work relates to the legal community as such.
Commissioner Moiman.
Thank you, Acting Chief Justice. Good morning, Advocate.
Good morning, Commissioner.
Just help me understand the order that you made in Mpumalanga Province, MEC of Education versus Majuba, on your interpretation of your Transvaal Ordinance Regulation 44.1 versus the Education Employment Act, because you ordered the declaratory relief there. Can you just help me understand that?
Sorry, Commissioner, which matter is that? Is it part of my bundle? Is it not?
It's a matter that that is cited as part of your contribution to the jurisprudence.
If I can just get there, I'm just not afraid with which matter you're referring to.
The MEC of Education versus Bonakele Amos Machuba, the other one.
I'm not sure where that is in my papers.
Are you able to give her the page number, Commissioner?
Yes, let me just then check it on the, because in that in that matter, she interpreted, yeah, on page. It's number 6 in your questionnaire. There's 1, there's 2, there's 3, 4, and then 5. Whether any of the candidates' judgments have been overturned or upheld on appeal. So there's on 6.
Chief Justice, can I help? It's at page 106 of the bundle. That
yes.
Okay.
6.1.1. Yes.
106.
Yeah.
Thank you very much.
Under 6.1.1.
Tebogo Malalela, that matter versus the state.
No, it's I think is it Francis Peter van Riet versus the MEC in Mpumalanga.
Oh.
And then also there's I think it will be one of those cases.
So in the matter of Van Riet, that matter related to whether the court had jurisdiction to entertain Mr. Van Riet's claim. I, in that matter, made the following order. Beg your pardon, if I can just have a moment to get there, to refresh my memory. I declared that the retirement date of Van Riet was 1 January 2021, and that the respondents were directed to re-register Van Riet as an employee as he was at 31 March 2020, as from 1 April 2020, with the same benefits, and backdate the benefits until the retirement date of 1 January. This matter relate to termination of, or not termination. Mr. Van Riet's contract came to an end, and then there was a dispute whether his retirement date was at the end of the month in which he turned 60 or 65, or was it at the end of the year? Originally, the legislation in terms of which he was appointed directed that it was at the end of the year. Since then, there was various amendments to the legislation which I then dealt with in my judgment, and I found that notwithstanding the original provision under which he was employed remained intact, and that justified the order that he would then retire at the end of the year in which he turned 60 or 65.
So the effect of the amendment by the Education Affairs Act And also the Educators Employment Act did not repeal this Transvaal Ordinance.
No, no, I found that it did not, especially if I recall correctly in terms of Section 12 of the Interpretations Act, which dictates that when there has been repealed acts, it would not be interpreted to the detriment of the party that relies on it, in respect of which he was appointed.
Is it on appeal or is it appealed or not?
No, it's not. It hasn't been appealed.
Thank you, Advocate. Thank you, Acting Chief Justice.
Thank you, Commissioner. Commissioner Notesi.
Thank you. You, in your curriculum vitae, in the list of things that you list, you say you have experience in customary law, and secondly, it reflects that you are a member of the Transformation Committee. Now, my understanding, correct me, is that if you are a member of the Transformation Committee, you must first be transformed. You must first be transformed.
Yes.
What language can you speak other than English and Afrikaans?
I only speak English and Afrikaans.
Now, when you deal with those matters, or when you say you understand customary law, what do you mean?
Well, I've done customary law matters such as dealing with marriages, customary marriages, or inheritance rights. So when I say I've done that, and what I understand is what the principles, and I rely heavily in that respect, I think like anybody else, on what the facts of the matter is and what is brought to the table. Thank you, Mr. Commissioner.
You simply mean you read the text and then it's what you then say you understand and you know about customary law.
No, obviously through engagement in this where we are in South Africa, it's that I personally grew up in the new South Africa, if I can call it that. So what I understand from it is I will utilize the facts that's placed before me. I'll do my own research. Obviously, the facts in respect of a specific custom might not be completely within my knowledge, but it will be within the knowledge of the party who is before me and who relays that to me. I'll then apply our constitution together with the facts and the arguments to come to a just conclusion in respect of what should happen. For instance, historically, customary law would dictate that a woman would play a lesser role or would have a lesser role than a man in respect of marriages. Now that obviously cannot, with today's constitution, exist.
Yeah, that's one question. I mean, I'm done. Look, the preamble to the South African Constitution direct that we must, we all recognize the injustice of the past.
Yes.
And advance for the establishment of a new society. Now, my point is, if you don't even seek to understand the African languages, do you accept that? What the Constitution tells us to do as citizens? Thank you.
Thank you, Commissioner. I wouldn't say that. I think the preamble says it's inclusive in respect of everybody, including Afrikaans and English and then the 9 African languages. I would have certainly wanted to be proficient in it. But when I relocated initially from Bloemfontein to Johannesburg, I had to not completely learn English, but I never practiced in English. So I think my time that I spent was to enable myself to better myself in speaking English, and that could have potentially been better utilized in also learning an African language, but it is what it is. I don't speak an African language. I just don't believe that makes me not to understand the community or not to have value in respect of the community issues that are faced before me. Thank you, Mr. Commissioner.
Thank you. I have Commissioner Dodovu, Judge President Mlambo, and Commissioner Mpofu. and I propose to stop here and after that and go to the commissioners who are on the virtual platform. Commissioner Dodovo.
Thank you very much. ACJ, good morning, Advocate.
Good morning, Mr. Commissioner.
I can see that you presided on several matters where the accused or the applicants applied for bail, especially on offenses related to Schedule 6 offenses. Now, my point is that under those circumstances, when you apply for bail, you must prove exceptional circumstances. Can you share with us, because we are all human, can you share with this commission the examples of the exceptional circumstances that must be proven?
So in exceptional circumstances would be, it's quite difficult because I think it's case specific, but they are listed within the Criminal Procedure Act. There's a list that goes what would constitute exceptional circumstances.
I want you to share with us those.
I don't think I can do that off the top of my head. I know where to find them. They're well written. They're in the statute. Himstra de Toy deals with them. It will be obviously need to be in the interest of justice, and that's the test that needs to be applied. But off the top of my head, I've now gone completely blank. And
I'm asking this question because I'm reading your judgment here of Mabunda.
Yes.
I'm sure you remember it, where
yes.
the appellant had killed the wife.
Yes.
In front of the children, and the magistrate court denied him bail.
Yes.
And he applied to you, and you released that accused or appellant on bail, and you demonstrated exceptional circumstances. That is why I'm asking you the question. Under the circumstances where this accused killed or murdered the wife in front of young kids in Mpumalanga, where GBV is rife, you gave the bail on the basis of those exceptional circumstances. That is why I wanted to test your knowledge on that particular aspect.
Thank you, Mr. Commissioner. In that specific matter, it was a Schedule 5 offence because it was not Schedule 6. So I concluded there that he need not show exceptional circumstances. He only needed to show that it was in the interest of justice for him to be released on bail.
But the state argued that this was a Schedule 6 offence, and even the representative of the accused also gave the benefit of doubt that even if that could be a Schedule 6 offence, and he moved from that particular point. At that point, did you determine that it is not Schedule 6, but it is Schedule 5?
Yes.
At that point?
Yes,
you did.
I did that.
Okay.
I did that.
All right, thank you very much.
Thank you, Mr. Chairman.
Thank you, Commissioner. Judge President Mlambo.
Thank you very much, Acting Chief Justice. Good morning, Counsel.
Good morning, Judge President.
You are sitting in Mbombela.
Correct.
And the bank seeks to foreclose on a property in Carolina. And the litigant whose property is meant to be foreclosed is not in court. The value of the claim is 100,000 rands. Could you tell us how you deal with that matter?
If the matter falls within the High Court's jurisdiction, I would deal with the matter subject to ensuring that all the procedural requirements have been met, such as personal service. Although there was a judgment, I think it might have been Tobajani, that initially said that the High Court should refer those matters, or those type of matters should only be dealt with in the Magistrates Court. That has since been overturned, and it conferred that there was jurisdiction in respect of the High Court to deal with those matters. So if that matter is before me, and it's properly before me in terms of I've got the necessary jurisdiction and there was personal service, I would deal with the matter. But that wouldn't mean that I will grant the order, because what would be relevant to consider is whether that 100,000 is that the complete amount that's sought, how many months there has been arrears, whether there has been an opportunity to the defendant to rectify the non-payment, and obviously considering whether it's a primary residence and what all the other factors. And if it is found that it is indeed justified procedurally to grant the matter or the order, and for instance, the 100,000 was accumulated over 24 months, then I would look at setting a reserve price to ensure that the order, when it is granted, is effective in expelling the debt, and that it is not of such a nature that it would merely take away somebody's home, but not even reduce the debt amount in terms of the property.
Follow up, Acting Chief Justice. The fact that the litigant is not there, the litigant who lives in, is it Slobela Township in Carolina, is not in front of you. Would that impel you to do anything about dealing with the matter?
JP, so if it has procedurally, if everything procedurally has been done to get the litigant there, then there's not a bar to granting the order. But if there is something that tells me that there is any chance that this defendant does not have notice of this, then I would obviously potentially postpone the matter and seek better service to ensure that that litigant is adequately informed about what stands to happen.
Thank you very much, Acting Chief Justice.
Thank you, Judge President. Commissioner Mpofu.
Thank you. Good morning.
Good morning, Mr. Commissioner.
Yes, thank you. Now, mine is almost like a follow-up on the same case that Commissioner Moyemang was asking you about. And it's more of a compliment than a question, but the question will come at the end. To say, yeah, I found your judgment writing very good and clear. But more specifically, I want to talk to you about the other issue that was in that matter of Van der Riet, which is a question of jurisdiction. And again, maybe to give you the last compliment for the day, most South African judges in the High Court do not understand the issue of concurrent jurisdiction. And I'd like you to explain that issue of, from the point of view of access to justice. In other words, what would happen if you had held, for example, in this case, that Mr. Van der Riet's retirement date should not be determined because it should go to the Labour Court. What that would do it would mean until today that issue has not been determined. And if he doesn't have money, then to appeal your judgment, well, that's the end. He must just stay where he is. Whereas the Constitution says that the High Court has inherent jurisdiction. In other words, another court may have jurisdiction, but that does not deprive the High Court of its own jurisdiction, depending on how the matter has been pleaded. Can you tell us what your understanding is of concurrent jurisdiction, as I say, in the context of access to justice?
Thank you, Mr. Commissioner. Mr. Commissioner, concurrent jurisdiction in respect of the access to justice would mean that you can go to the court that would be most convenient to you, where you, for instance, reside, or where the defendant resides, depending on the circumstances. And for instance, in Mpumalanga, we don't have concurrent jurisdiction with, the main seat does not have concurrent jurisdiction with the local seat, except for on appeal matters. So how that plays a role with access to justice is that you need to go where the matter can effectively be dealt with. But in the context of the Van der Riet judgment, that would have meant that I could do the matter. There's no point in finding where I've got inherent, or when I say I, where the court has inherent jurisdiction, that specific plaintiff or applicant needs to go somewhere else just because I don't want to exercise that discretion in respect of utilizing. I looked at the pleadings in the specific matter, and it granted me the necessary jurisdiction to deal with the matter. And on the issue further of access to justice is that it's sometimes used as a very loose term, access to justice. There's attorneys everywhere, so people say, well, what does that really mean? But access to justice can also mean that you are within a center where your, I beg your pardon, I think the nerves are getting the better of me. If I can just take a moment.
As you do that and taking a moment, perhaps that will also help you to recap.
Yes. Are you pausing to
I'm pausing
think?
just to take a breath because I think I'm losing the point in respect of the access or the direct question asked by Mr. Mpofu. Is that
Maybe I can clarify it. Yeah, it's fine. But I'm happy with what you have said. I think the only issue which I would like you to add is I hear you when it comes to geographic jurisdiction, and you've made a great point in respect of that. But I was talking also just broadly in terms of cause of action jurisdiction, which is what you were dealing with here. In other words, the example I made, you could have easily said, no, this must go to the labor court. And I'm saying in the context of South Africa, the cost of litigation and so on, would you agree that that would have meant that Mr. Van der Riet, that might have been the end of his case because he might not have been able to afford appealing against you, for example.
Correct.
And therefore, in that sense, would have been deprived access to justice.
Correct. And where?
Sorry, I'm sorry. So what I'm really saying is that South African judges in particular should exercise the inherent jurisdiction of the High Court for what it was meant for, which is to do literal everything, unless it is excluded.
Correct. When you've got the required jurisdiction, you need to deal with the matter. It would obviously have been, I would think, the easier order for me to make and say, well, go somewhere else and try again. But that would have had the effect, considering the time period, that he would not receive any relief. Not that that's the only relevant point, obviously, but where you can deal with the matter, you should deal with the matter and not merely pass the buck. If I may add something on access to justice, in the recent years, since we've gone virtual, and the Mpumalanga courts are almost exclusively, save for criminal matters, dealing virtual, we've experienced some difficulty in respect of unrepresented litigants. For instance, a proposal that we've made, that we've dealt with in our weekly meetings, as mentioned by my judge president, is that we've discussed to utilize an area at court with a computer where individual persons who are appearing in person can still attend the court and join on that platform, because we've seen that sometimes they're excluded. So now a link is distributed only to attorneys. You as the judge can't distribute to a layman where you don't know if the layman's going to attend or even what their details are for that matter, or whether they have the facilities to. So what we've discussed is to set up a room which will facilitate this process. So as they would normally have attended the unopposed motion court, for instance, and would have raised their hand and said, I'm here in person, they will attend to that specific room and utilize the virtual platform through that has been established by court in order to ensure that they continue to have that available to them to merely stand up and defend their matter.
Yes, thank you very much. Thank you, Mr. Chair.
Thank you. Commissioners on the virtual platform, are there any questions?
Thank you, ACJ. Good day, Advocate.
Good day, Mr. Commissioner.
You have a potentially volatile situation. There's difficult litigants before you, many parties, lots of tension in court. Parties and the lawyers are all very passionate about the dispute. How should the presiding officer deal with that situation, and have you experienced such a situation in your exposure thus far?
I think an attribute of a judge is to be in control of the court, but also to be patient and to understand that the majority of litigants and persons want a just hearing. They want to be heard. So by employing patience and being open-minded, that can be achieved together with being firm and ensuring that the decorum of the courtroom is still or the court is still maintained. I found that a lot of matters are appealed against in general, not because, if one reads the reasons, not because so specifically the law, but the parties feel they were not heard. They didn't get a just hearing. So where there is such a very litigious matter, like most of them are, and there is potential frustration in court, I will employ the principle of being firm, yet patient, and making sure that everybody feels heard and get the necessary opportunity to be heard in order to diffuse that.
Second part of the question, have you had such an experience?
I think I have had such an experience, especially in the urgent court.
Thank you. Thank you, ACJ.
Thank you, Commissioner Barnett. Ms. Freiling-Kutze.
ACJ.
When do we speak of a misdirection in the context of a judgment? When counsel appears before you, let's say in an appeal, and submits that the court misdirected itself, what kind of animal is that?
That would normally refer to a factual misdirection.
And when does that happen? How do you see a misdirection by a lower court or by a judge?
So, ACJ, that would generally, in the context of appeal, mean that when you as the appeal court consider the factual findings made by the court quo, that there was a misdirection in respect of a factual finding, that they were wrong in its approach on the facts that was before it. I'm not sure if that answers your question, ACJ.
Well, is it simply that they were wrong?
Well, wrong to the extent that it caused the wrong order to be made.
Mm-hmm. What does that mean?
I might not be,
they were wrong
following.
To cause with the result the order was made. Do you want to try and explain it maybe much better?
I will try. So in the context of an appeal, and you sit as an appeal court, and you find that the court quo misdirected itself in respect of that which it found to be the facts of the matter, and that resulted in that would obviously then constitute a misdirection on the part of the court quo, and you would only interfere therewith when it is of such a nature that it would cause an unjust result.
Is there one type of discretion, or are there different types of discretion that one finds in the exercise of statutory power?
I would think that there's one type of discretion. The discretion that's given to you in terms of statute, you need to exercise judicially depending on the facts and based on what is before you. Sometimes there's a wide and narrow discretion. So it depends on where that discretion that you are employing comes from, whether it would be wide or narrow.
Yes. And what's the significance of wide or narrow?
The significance would be where you have a wide discretion that there is, it's applicable to a wider range of circumstances. Where discretion is very narrow, it can only be applicable to, in a specific instance, that is the discretion which you need to exercise.
If you were, if councillor submitted before you that the quota core had, or a functionary, government functionary, had a narrow discretion, and another one said no, it was a wide discretion, would there be different approaches to the discretion depending on whether it was a narrow one or a wider one in terms of how you can interfere, or is the approach the same?
No, there would be a different approach in the sense that where it's wide, there's more circumstances in where you can interfere, but where it's narrow, it will only be specific instances where the court can interfere.
Yes. I don't know if this has been dealt with. Have you had a chance to deal with a constitutional matter where you were asked to declare legislation unconstitutional and decide on the appropriate remedy?
No, I have not. So
Yeah.
I'm aware of how it should be done in terms of Section 172 of the Constitution and what
Yes.
needs to be done, but I have not had that opportunity.
Yes. Okay, all right. We have come to the end of the interview. Oh, I'm sorry. I think Mlambo JP had a follow-up on Commissioner Bofu's question.
Thank you very much, Acting Chief Justice. It's on the language question. I think it was raised by, I'm not sure whether it's Commissioner Dodovu or Mnochis, I can't remember here. You said you speak only English and Afrikaans.
Correct.
If you have an unrepresented litigant in that foreclosure matter I mentioned to you, and he insists on speaking in Siswati, my understanding is that in civil matters, it is the responsibility of litigants to bring interpreters. How would you deal with that matter?
If that is the preference of the specific litigant, I will utilize the court interpreter and request the matter to stand down in order for a court interpreter to assist. Should a court interpreter not be available, we have a list of sworn-in interpreters who can assist us with that, and I would stand the matter down in order to obtain the assistance of that interpreter to interpret both what I am relaying to the litigant, to him, as well as what he is wanting to relay to the court.
Thank you, Acting Chief Justice.
Thank you very much. We've come to the end of the interview. Thank you once again for availing yourself for consideration. You are now excused.
Thank you very much, ACJ.
Thank you. Next candidate, please. Commissioners, can I read something to you? Commissioners, can I read something to you for your information? There's an email from Ms. Laminga, whom we interviewed a few days ago. She had applied also for Mpumalanga. She says As you are aware, it's addressed to Mr. Chilwane. I was interviewed yesterday, 6 October 2021, for the vacancy in the Limpopo Division of the High Court. I was confronted with the delays in a regional court matter under case number RC 104/2016 without proper prior notice to enable me to properly respond, even though I was able to access the information pertaining to reasons for the postponements of the matter. Obviously, I did not expect to be confronted with questions which could only be replied to with access to the full record of the case, which I did not have. I submit that due to the way the interview was conducted and the fact that this issue became the main issue during my interview, the process was not fair. I do not foresee that I would be better placed to respond to that issue tomorrow, since I'm not able to access and study that record today. Therefore, I hereby withdraw from the interview for the vacancy at the Mpumalanga Division of the High Court, scheduled for tomorrow, 8 October 2021. I trust that you find this in order. So I wanted you to be aware of that, but I just also place on record that we will all remember that when she started, I indicated to her that if she felt that she could not deal with this issue, she should indicate so that she could be given a chance, and she said she could deal with it. So I just mentioned that because we were aware that she might well think that she had not had enough time, and I said we would be willing to deal with the matter differently, but she said she was fine. Okay, all right, thank you. Yes, yes, yes. Exactly. Yes, yes. Yeah. Yes. Now she is accusing us.
ACJ, don't worry, she'll come again. She'll come again.
Sorry, commissioners. It may be that we'll discuss later about whether we should respond. President Meyer thinks we should respond, so we can talk later about it. Yeah, we can discuss it later.
Acting Chief Justice, yes, I think we can discuss it later because, if I may say, in Gauteng, anyone with part heads of more than 10 and who has a matter like this will never even be appointed to act, let alone being shortlisted to come here.
Okay, thank you. Let's start. Good morning, Mr. Langer.
Good morning, Acting Chief Justice and all the commissioners.
Thank you. Welcome to this session of the interviews of the Commission. We appreciate it very much that you have made yourself available for consideration for appointment. I see that you have a diploma juris that you obtained in 1981 from the then University of the North, is that right?
That is correct, Acting Chief Justice.
And in 2003, you obtained the LLB from UNISA, is that right?
That's correct.
And then the following year, 2004, you obtained LLM from UNISA.
That is correct, sir.
Did you take a break from work and studied the LLM full-time? I see it looks like you took 1 year.
No, it was while I was working, it was, I didn't take any break.
But you were able to finish it in 1 year as if you were full-time, you were working on it full-time?
Yes, I had to balance my work and my schoolwork.
Hey, that's quite commendable.
Thank you.
Well, you started your working career as an administrative clerk in the Department of Interior in 1978.
That is correct, Acting Chief Justice.
And in 1982, you became a public prosecutor.
Correct.
Is that right?
Correct.
That's up to 1983. And then in 1983, at some stage, you became an assistant magistrate.
That is correct.
That was quite a quick rise, isn't it? Because you started as a prosecutor in 1982. The following year, you were appointed as an assistant magistrate.
That's correct, yes.
Mm. And then in 1985, you became an additional magistrate. And then in 2004, you became a regional magistrate.
That's correct.
And 2013 to date, you became a regional president.
That is correct, Acting Chief Justice.
And during your years working as a magistrate, from assistant magistrate up to regional court president, how much exposure have you had, or did you have, to dealing with civil cases?
I had almost equal exposure to civil and criminal cases.
Yes. Well, I just needed to mention, I forgot to mention that you serve on the SAJA Council and EXCO with me.
That is correct,
yes.
Chief Justice.
So let me go back to my question because I didn't hear your answer. How much exposure have you had to deciding civil cases during your many years as a magistrate and regional court magistrate and as president of regional court?
Well, as additional magistrate, I was having full exposure to civil litigation,
yes,
as well as criminal, up until I was appointed to the regional court bench, where, as you know, the regional court then was dealing only with criminal cases,
yes,
up until 2010, when the law was changed and the civil jurisdiction was introduced in the regional court.
So, so how many years did you have as a magistrate during which you were exposed to the adjudication of civil matters?
That will be from essentially 1983 up until 2004.
That's about 20 years?
More or less,
more or less.
Chief Justice, yes.
Yes. Okay. And what types of civil matters did you deal with in the magistrate court terms of different branches of law and so on?
One would mainly deal with normal claims for damages, not much of contractual matters, especially given that the time that I spent during those years was spent in rural courts. So the litigation was not, you did not find a lot of commercial litigation, but normal claims for damages by the people in those rural areas.
Yes. And there would have been many judgments that you would have given in those civil matters.
Yes.
Yes. Would many of those judgments have been extempore judgments, or they would have been typed and written and can be found somewhere, or at least some of them?
Well, some were written or recorded judgments, but some were extempore, depending on the complexity and length of the matter, of course.
Yes. And you have sat as an acting judge as well on a number of occasions, is that right?
That is correct, Acting CJ.
How did you find acting in the High Court?
I found it very challenging, as it was just as challenging as it was stimulating. It's a completely different ball game compared to the lower courts, especially because of the responsibility that comes with the work, where you know that almost every decision that you make has the potential to become a precedent. So you're almost called upon to dig deep in terms of each matter that you write.
Yes. Thank you, Judge President.
Thank you, Chair. I must just declare, Judge Langa, whilst I was still having pitch black hair, I had the opportunity to appear before you on a number of occasions in Bushbuckridge and on a number of civil matters. Is that correct?
That is correct, JP.
And there was also an occasion, I'm not sure if you will remember, there was also an occasion where you made an order against me.
Yes, a court order, JP.
Okay.
Was that a Debonis property court order?
Yeah.
you claim the right to remain silent. Okay, Judge President.
Just Lang, I'm not going to ask you about your experience in judgment writing. I think to a certain extent, the chair dealt with that. You were here in April, am I right?
That is correct.
Yes. And there was an issue that became, and I think correctly so, of a great concern to the commissioners relating to an objection that was raised against you, am I right?
That is correct.
Please bring the mic closer to you, JP.
Yeah. Oh,
yes.
Sorry.
Yes, so we can hear.
We will deal with that later, but first, I note that you attended seminars and workshops dealing with diversity, culture, gender-based violence matters, HIV/AIDS pandemic, and you further obtained diploma in equal justice and rights of women from Lund University in Sweden. And you also acted as a facilitator, a trainer, a mentor at UCT Law, Race and Gender, Justice College, and also at Sajay, am I right?
That is correct, JP.
Now, you have been regional court president from 2013 till to date.
That is correct, except that I actually took over the position in an acting capacity from 2010.
Yes. Can you brief the commissioners what role did you play to date as RCP to advance the plight of women in the area where you are the regional court president?
In terms of what I call transformation of the regional court bench in the Western Cape, we had, and when I say we had, I'm referring to myself together with a group of people who act as coordinators for each court, as unlike the district courts where you have senior magistrates assisting the chief magistrates. In the regional court, the regional court president is just by himself in terms of administration of the division. So we have a system where we have roped in magistrates in different courts all over the Western Cape to assist. So they serve as sort of as a council, an advisory council to the regional court president's office, or the regional court president. But I just want to give just a brief history of where we come from as the Western Cape Regional Division. In the year 2000, for example, the Western Cape Regional Division consisted of a complement or staff complement of 21 males, 7 white males, that is, 21 white males, 7 white females, 4 colored males, and 1 colored female who was the regional court president then. So fast forward to 2014, after I was appointed, we had then, after I took over in 2010, we had by then the following figures in respect of the staff. We had 10 white males, 8 white females, 5 colored males, 5 colored females, 9 African males, 4 African females, and I'm stressing that 4 African females. That's all we had in 2014. And we had 0 males, Indian males, and only 2 Indian females. Now, fast forward again to the year 2020, almost that is a year or two ago. We had 3 white males, and this is as a result of many white males resigning or others unfortunately passing on. We had white females 7, colored males 9, colored females 7, African males 8, African females 14, and
14.
14, 1-4.
Really? As in when?
As in now,
Yes.
from 2020.
Now,
and just to finish off, and we also have 1 Indian male and 3 Indian females. So when one looks at the picture of the Western Cape today and compares it with what we have in the year 2000, it's a completely different picture. It's we have gone from an almost, I think I'll use that word, which people used to use when referring to that division, that it was lily white. But today we have a division that we can say is a rainbow division in terms of the racial breakdown, as well as, most importantly, the gender breakdown.
was that a deliberate move on your part to ensure that the region is transformed?
Yes, that was not only a deliberate move, but an aggressive one to get to this point, because we had a very aggressive recruitment. We recruited people from mainly the district courts and a few from the attorney's profession in order to come to these numbers. It was not an easy task, but I can say today that the Western Cape Regional Division looks much better than most divisions. In fact, I'm not sure if there's a division that has more females than males. We have more females. We currently have 33 females as opposed to 27 males in general.
Now, let us go back to the concerns which were raised, and correctly so, by the members of this commission during the last interviews. And I think, as correctly indicated by Commissioner Malema, perhaps you did not do enough to ensure that you obtain necessary documentations from the statutory body, the commission in particular, as to whether the colleague who lodged a complaint against you here or an objection, as to whether that colleague did lodge a formal complaint with the Ministerial Commission. Did you, after the interview, take steps to inquire with the Ministerial Commission as to whether a formal complaint was lodged? And if so, what has happened?
Yes, thanks, JP.
Why are you taking water at this stage?
No, those who live next to me, my registrars, for example, know that I drink hot water the whole day. So okay. I live on water, basically. I'm already addicted to hot water. When I drink the cold water, it doesn't actually taste nice to me.
Yes, but let us just go back to it.
Now, leaving the water story, I'll come back to, I just want to comment that yes, when I left this commission on the 21st of April, I was not a happy man, not because I was not considered for appointment, but I was not a happy person because I think I was projected in a manner that I am not. And the reason why I'm saying that is that I am naturally a very understanding, supportive person, and work generally very well with people. But having said that, coming back to the question, yes, because of that concern that the commissioners are worried that perhaps what was being said or what I said, that no complaints were laid against me, or I did not know of any. I immediately on the 30th of April directed a correspondence to the commission, that is the Magistrates Commission, seeking clarity, and actually pointedly asked the commission to comment as to whether the complaint, which was dealt with in this forum, I once again will not, out of sensitivity and respect, not mention the names, but I asked the commission to comment on that, and the response of the commission was that there was no record of any such complaint. No such complaint was made. And eventually, I got the confirmation to that effect, which I have made available to this body.
Yes, and you did that even without knowing as to whether there will be vacant posts for the division, and without even knowing whether or not, if there is any, you will be shortlisted. Am I right?
Yes, I actually wanted to clear my name because it was a problem. I was not happy, as I said, because the impression created not only in this body but outside is not correct, and hence I wanted to get the information in order to make sure that the record is set straight in that respect.
And you have now recently, as in this week, obtained a confirmation from the Ministerial Commission that there has not been any complaint laid against you. Am I right?
Yes, the Commission has confirmed that the specific complaint was not lodged, and no other complaint whatsoever was lodged against me, and there are no investigations or pending investigations or disciplinary matters against me.
Now, reading the general complaints by the incumbent in question, and I'm speaking for myself, it looks as if there is a cry for help. And I'm sure you are aware of this correspondence and also the newspaper reporting around this issue, and I think it was last week or 2 weeks ago. Now, I want to know, as a regional court president, or your colleagues, what steps were taken to assist this incumbent with this obvious cry for help, to ensure that in one way or the other, she is met halfway?
When the issue became known and it became clear that the incumbent was unhappy with the station or the court at which she was, an attempt was made to relocate her to another court, which she asked for. Even though I had reservations about the court that she asked for, and I'll say why. But the Wynberg court, which is the court that she asked for, was approached. The magistrates there were approached and asked whether they could not, whether there was anyone interested in a cross transfer with from Wynberg to Mitchell's Plain, so that she can be in Wynberg as she wanted to be in Wynberg. Unfortunately, none of the magistrates in Wynberg was interested in the move to Mitchell's Plain. Sorry. And that plan, therefore, could not work. When it failed, the matter was referred to the Magistrates Commission as the body responsible for transfers, because the transfer that we were trying to do on the ground was not really a transfer, but a redeployment for the purpose of getting her out of the space that she was complaining about. But the Magistrates Commission, after considering the issues and the fact that there were no posts available, both in Wynberg and Cape Town, decided not to approve the application for our recommendation for the matter of the transfer to be considered.
So you recommended for the transfer, but the ultimate decision was with the Magistrate Commission?
That's correct.
Okay, yes.
Now, coming back to Wynberg as a court, the incumbent was essentially afraid of or uncomfortable about working in Mitchell's Plain because of fear of the environment, amongst others, gang-related activity, criminality, and so on. But now, asking for a transfer to Wynberg would have, in my view, been the worst thing to do. I have sat in Wynberg court for many years. That court covers the hot spots areas of the Western Cape. I can just give you an example, Manenberg.
In my language, they say...
Sorry for drinking water.
In my language, they say,
I'll interpret later. Yeah. But it covers the Cape Flats. That's Manenberg, Hanover Park, Langa, Guguletu, Philippi, and those are Nyanga West, Nyanga East, sorry, and those are the most volatile places in South Africa, if not in the world, because Nyanga was recently said to be one of the meta capital of the world. So, and the gang-related activity in those places is just huge compared to Mitchell's Plain. Mitchell's Plain is, I think, a better place to be than Wynberg. That is why I say I had those reservations, but nevertheless still referred the matter to the commission to take a decision.
Thank you. Now,
and
yes.
Yes, secondly, when the incumbent complained about the threats, because there was a time when there was a complaint about threats having been made against her, and at some point also a complaint of a window crack. We decided together with the Department of Justice, or through the Department of Justice, to have a risk assessment done by the crime intelligence. And this was done, and a report was prepared and presented to the late Hisham Mohammed, who was the regional head, and it's dated, I think, the 25th of March 2019. So that risk assessment was done recently. The report should be in your files. But in short, what Lieutenant General Jula said in that report was that they have investigated, and the reports of threats could not be confirmed. The window was probably a crack from a pebble or something, but it was not a bullet, as the incumbent had reported to us, as well as the crime intelligence people investigating the matter. As a result, they recommended that she take certain measures in order to avoid putting herself in danger. That's also part of that report.
Okay.
Can I perhaps close by saying that now recently, as recent as last week, another complaint was made by the same colleague about a crack, the same window having a crack. And there was a newspaper report that you are referring to of last week Saturday, in the weekend August, where she had an exclusive interview with the journalist. And on the 4th, on Monday, we had a meeting with the director in the Department of Justice, and a decision was taken that another risk assessment must be conducted by the police, the crime intelligence, at the instance of the Department of Justice, and that is where we are.
Okay. Yeah. So something's been done to try and assist her.
Yes.
Now, you are aware that the local seat in Middelburg, which is almost as busy as the main seat and sometimes busier than the main seat, consists of 4 complements. In other words, we are supposed to have 4 judges in Middelburg. And 3 of these women, no, 3 of the judges are women in Middelburg. Am I right?
That is correct.
Yes. And the last term and this term, the last term you were based in Middelburg.
Yes, although I was on the road, I was based in Middelburg, but I went to Middelburg via Delmas and Mukobola in the former Kwandebele area.
What is your relationship with the 3 candidates, the 3 female judges that you are working with in Middelburg? How would you describe your relationship with them?
Well, I've got a very great relationship. It's a family relationship. It's collegiality that you can dream of, because a person would phone when they have a difficulty. Can't you help? I can phone anyone at any time to ask for assistance without doubting that I will get assistance. So it's one of the best places to be, to work in terms of relations. It's just fortunate to have such minded people in one place.
And you have applied for Middelburg, and that is where the DJP is stationed as well. Am I right?
That is correct.
Yes. I might disclose to you that all these colleagues they have given me a good feedback about you and the kind of relationship that you are having with them. And lastly, with your permission, Chair, and I'm sure the commissioners will bear with me. This is a very critical issue, and I thought perhaps it has to be dealt with quite very extensively.
Yeah.
And I'm aware why the chair also allowed me this opportunity to deal with this issue upfront.
Yeah.
Now, we have just received a document which suggests that you have been seized with a matter for more than 6 years, and I see that this matter was on the roll. I'm sure the commissioner have been given the roll. This matter was on the roll on the 16th July 2021. It was almost during like recess, and the matter is actually not ceased with you. It's ceased with acting judge Engelbrecht. Am I right?
That is correct. I don't have any apartheid matter in Mbombela, but most importantly, I don't have a apartheid matter that old, and it is not. I don't encourage that type of approach to matters because I always believe that there has to be efficient management of cases and the flow of cases, especially because I deal with the management of a division with about 60 people, where I have to ensure that things like this do not happen, even though we still have systemic problems which makes it impossible to make matters move. But the long and short of it all is that I was shocked when I saw that, and I asked the registrar to investigate, and eventually we managed to get the information that it's a matter that is being dealt with by another judge.
Do you have any reserved judgment for more than 3 months?
No.
Okay. And lastly, by the way, you are originally from Potgietersrust, Rust, which is some few kilos from Mettleburg, although you are now based in Western Cape by virtue of your work. Am I right? You are born and bred from Botis.
It's a Mukopane JP to correct you.
Oh, yes.
It used to be.
My apology. Chair, thank you so much for affording me this opportunity. I'm not taking it for granted. Thank you.
Thank you very much. Premier, I now give you the opportunity to put questions to the candidate if you have any.
No, thank you very much, ACJ, and good morning, Judge Langa.
Sorry, I didn't see Premier. Thank you. Good morning.
Morning. Judge Langa, I just want to touch on the matter that you were interrogated on earlier on by JP. When you appeared before us in the previous interview, were you aware of the allegations that were laid against you by this woman?
The complaint to the JSC?
No, the allegations. What was contained in that report that you received? Were you aware of that?
Yes, I was aware, and I also responded to that report.
Which then takes me to the next question. We view the matters serious, and of course, given the fact that Mpumalanga is quite prevalent.
Sorry, Premier.
Yes.
Okay, no, it's quiet now. Yes, you may proceed.
Thanks. I was saying that we view the matters that were raised quite serious, given the fact that Mpumalanga is quite prevalent with gender-based violence issues. Now, to me, the question then says, why did you have to leave this matter to a point such that it is escalated to a public domain, which creates an impression, whether correctly or wrongly so, that is unpleasant to most of us. We feel extremely uncomfortable with what we had previously. And I can hear that there were attempts afterwards to try and deal with the situation. And this matter, it has the potential of career limiting to yourself. Why were the matters not dealt with earlier on, given the fact that you are in charge of that magistrate court? If one of your employees alleges something of that serious nature, why was it not attended to earlier on, prior to you appearing before the previous interviews? Yes, you may not have been aware that we possibly would be having these interviews, you would be shortlisted. But that does not take away the fact that those allegations were raised against you, and continuously we're still reading things which is related to that. And to me, is if indeed this goes with a deformation of character, why are you not taking on this matter for a lawsuit as well?
With a lawsuit? No, I'm not sure if I understand the Premier well, but what my response is that the matter, as I said, was addressed before I came to this commission. 2017 was when the process of attempting to have a transfer were done, and the matter was actually referred to the Magistrate Commission in 2017 as well. So the newspaper report that we are talking about is a recent newspaper report of last week. And this is after we had had even the risk assessment done by the crime intelligence and so on. So the matter was dealt with before I came to this commission, if that answers the question, or if I understand your question correctly. But coming to defamation of character, I can say that boldly. I'm not going to do that because I do not think that it is the right thing to do. I personally feel that the incumbent is in a position where she needs help, not where she needs to be subjected to a lawsuit. For example, when there was a problem and she could not come to work for almost a year because of illness, the Magistrates Commission decided to investigate. They appointed an investigator. The investigator investigated and also asked for my recommendation. And the Magistrates Commission was investigating her for misconduct. So when I spoke to the investigator, I recommended that the right thing to do would be to investigate her capacity to continue working and not misconduct, because I realized that she has a problem. It was not a question of misconduct which warranted disciplinary steps, but the right thing to do was to investigate whether she is in a position to continue working.
Just a follow-up, ACJ. Are you saying that what was raised previously here, it was not supposed to have arisen because the matter was dealt with already around 2017?
No, I'm just saying to you that, as you say, I waited until I came here. I'm just correcting you, Commissioner, that I did not wait. When I came here, all these interventions had already been made. Fortunately, even the acting regional court president, who was assisting me, during my absence in 2017. I'm sure you'll have the opportunity to talk to him later on, as he has been shortlisted for the Western Cape, Dr. Lukuleni. All I'm saying now, he can confirm, but the point I'm making here is that interventions were made before, long before I came here. I did not even dream that one day I will be before this body.
Thank you very much. No follow-up question.
Thank you, Premier. Do you speak 9 languages? Do you speak 9 languages? I just saw in the question, it looks like you speak many languages.
Some fluently, some broken, but
you can converse in
I
all
can,
of them.
I can converse and
Okay.
Yeah.
No, that's fine. Commissioner Nyambi.
Thank you, SJ. Morning, Mr. Langa.
Good morning, Commissioner. Yeah, it's still morning.
Yeah. No, I'll ask just one question. Well, the first one is about a comment. Well, JP has done justice to the issue of last time. Probably you can comment. My view is that the advice that was given to you by the commission then has assisted us now to have you in front of us without a dark cloud in your head. And I think it's sending a very good message about standing of the judicial. But over and above that, if you'll comment about that one, what's your view about the advice you got from the JSC? And also add and touch issues that you think now we have to seriously consider that happened the last time and now in terms of development, and that will make you to be seriously a competitor to those that are coming still to be interviewed. Thank you, Mr. La.
Thanks, Commissioner Nyambi. To be honest, I was very concerned, as I said earlier on, and especially concerned that I didn't want to disappoint people like President Maya, who I know is a very cool, level-headed person, and she was worried about this issue, and hence I went out immediately. I left this place on the 30th of April. I went out to try and get information, at least just to show that what I was saying here is not false, as the impression was created. So I think the commission helped, and in fact I agree with the concerns raised by some of the commissioners, including President Maya, because I think we live at a time when there must be a heightened sense of concern when it comes to issues of women, and it is understandable when people become worried when issues like this are raised. But I hope that one has been able to at least allay the fears that this committee may have had about my person and my personality and my relation to the people that serve under me. So yes, the advice I got previously definitely positively helped. Thank you.
Issues that happen then and now, so that you can seriously consider your appointment?
I'm not sure about that.
I'm talking about the last time we interviewed you and now, probably things that you think are more relevant for you to be seriously considered for recommendation to be appointed as a judge. Anything that you think is significant that the commission must now consider?
Yeah, even if I have to say it myself, Commissioner Nyambi, I think I possess the necessary experience as a judicial officer. This is all I can do in my life. And I believe also I possess the necessary personality and temperament as a person. I believe that although it's a matter of learning every day, but I believe technically I can also be able to express myself in judgments. It's a learning process, I concede. Every day I write a judgment, the next day I look at it, I ask myself, did I write this judgment? I'm never satisfied about the judgment that I've written today. When I see it the next day, I feel like I could tear it apart and start from scratch. And I also believe that as a judicial officer, I have the necessary human relation skills when it comes to people. I don't struggle to work with people, whether in groups or small or big groups. So, yeah, even if I have to say that myself again, I think at this point, I am in a position where I deserve to be considered. I'm not saying I deserve to be appointed, but at least to be considered for appointment.
Thank you, Advocate Lang. I also thought that compliment of being level-headed was going to be given to all of us as commissioners, including the politicians. That was what I said. Thank you, ACJ.
No, in hindsight, I think it applies to everyone.
President Maya? You'll pass, okay, all right. Commissioners on the virtual platform? No questions from the virtual platform?
No questions. Thank you, Chief Justice.
Thank you very much. I don't see any hand here. It appears, therefore, that we have come to the end of this interview. Thank you very much, Ms. Langa. We once again appreciate the fact that you made yourself available. You are now excused.
Thank you, ACJ, and all the commissioners, and good luck with the rest of the work, which may take you right deep into the night, as it has happened. Thank you very much.
He's happy that we are releasing him so quickly. I think we should take the tea break now. It's 4 minutes past 12. No, I think let's take the tea break, 10 minutes, and then we come back and finish. Okay, let's do that. the commissioners in. Please bring the commissioners in. And the candidate. Yeah, it is Masango. Bring the candidate in. Let us start. Let's start. Good afternoon, Mr. Masango.
Good afternoon, ACJ.
How are you this morning?
I am good, ACJ.
This afternoon.
And how are you?
I'm all right, thank you.
Thanks.
We welcome you to this session of the Commission's interviews. Thank you for availing yourself for consideration for appointment as a judge of the Mpumalanga Division of the High Court. I see that you have a B.Juris and LLB degrees from the University of Zululand, is that correct?
Yes, ACJ.
And you got your B.Juris degree in 1990 and you got your LLB in 1992?
Yes, ACJ.
Yes. And paragraph 8 of the questionnaire says, please furnish particulars of your membership of any political organization, past and present. And you have responded, African National Congress. Is that correct?
That's correct, ACJ.
Is that past or present? Because you didn't indicate that it was past.
It is a past, past, not present.
From when up to when?
It was from 1990, I think it's 1990 to 1996.
Oh, but why didn't you put that in here? Because as it stands, it creates the impression that that is your current membership.
No. No, I might have made a mistake there.
Yeah, but you say no as if you're saying, I'm lying.
I might have made a mistake, ACJ. No, I'm not saying that.
Okay. I think for the future, you must always make it clear it's a past.
Yes.
And yeah.
Yes.
Okay. You started your career in the Department of Justice?
Yes, ACJ, I was a prosecutor from 1993 to 1996.
Yes. And then after that?
After that, I joined the bench in 1996.
Yes. As a magistrate?
Yes.
And you have been a magistrate at different levels up to now?
Yes.
And you have acted in the High Court?
Yes, I've acted in the High Court.
For how long have you acted in the High Court?
I acted for 22 weeks.
Yes.
Excluding the acting during recess.
Yes.
Yes.
And as a magistrate, did you adjudicate civil cases?
Yes, though not that much, but we were dealing with civil matters as a magistrate.
Yes.
But the senior magistrate in the office was actually seized with that work.
Yes. So how much exposure have you had outside acting in the High Court as an acting judge to the adjudication of civil cases?
ACJ, I must admit that it is not that much.
Yes.
Yes.
Yes. Okay. And how did you find acting in the High Court as an acting judge?
It was very much interesting.
It was very?
Much interesting.
Yes.
Yes.
And did you find any challenges?
Well, at first, yes, I found some challenges when I acted at first, but with time, I really developed interest in handling matters of the High Court.
Yes. I just saw now that in paragraph 6 of the questionnaire, it doesn't look like you gave a full answer. It said, please furnish chronological particulars of employment since leaving school or university, and you put manganese metal company and Genrec engineering and Department of Justice, but you didn't put any dates. Do you remember that part?
Yes, I worked, actually I joined Manganese Metal Company in 1980 and also from 1980 to 1981 and also from 1985 to 1987.
Yes. Yeah, but you hear the point I'm making?
Yes,
you did not indicate,
yes.
You didn't do what the paragraph required you to do, to say, this is basically my history or employment history. I work from that time to that time. This is where I was, and so on. You accept that?
You accept it.
Yes.
Accept it,
and then in paragraph 9, you were asked to furnish particulars of community and other organizations of which you are or have been a member in the past 10 years. You left that blank. You did not answer.
Community organization.
Yes, you left that blank. You did not answer. Why did you not answer? Paragraph 9 of the questionnaire.
I don't know whether I've got the questionnaires here with me.
Well, you should have, because obviously you knew you would be asked on it.
Oh yeah, I've got it. Paragraph 9.
Yes.
I think paragraph 9.
It's on page 6 of your bundle. Yeah, but paragraph 9 of the questionnaire.
Oh, okay.
Can you see that?
Yes, I can see that one.
Why did you leave it blank?
Maybe it's because I don't belong to any community organization.
But why didn't you give that answer? Because you left it blank,
yes.
which means effectively there's something that the commission wants to know about you, which you don't tell to the commission.
Oh, okay.
The commission wants, that question is there for a reason. So they want to know what community involvement you have got. So if you don't have any, you say, I don't have any.
Yes.
If you do, you give particulars.
Yes, yes.
But you don't just leave it blank.
Yes, I understand.
You understand?
Yes, yes.
Okay. In regard to the High Court matters that you have adjudicated, Have you dealt with civil trials and civil appeals?
I've dealt with civil trials, not civil appeals.
Have you dealt with criminal appeals?
Yes, I've dealt with criminal appeals.
Yes. And civil trials, do you have an idea how many you have dealt with?
I don't have any idea now, but because I dealt with some, I dealt with some, I believe, in 2013 when I acted in Gauteng. And also present the last time when I was in Mbombela, I dealt with some civil trials. I really don't have a number, a figure now, upright, up front to give you ACJ.
You see, one of the things we must satisfy ourselves about, particularly because for most of the years that you were a magistrate, as you have said, you did not deal with civil matters, is you indicated that it's limited exposure that you got in terms of civil matters, is whether the exposure that you have had through acting in the High Court, whether it is adequate. So that's why I asked you the question about how many civil trials you have done in the High Court. So if we don't have that picture, it makes it difficult for us to conclude that you have had enough exposure at the High Court, even though in the Magistrates Court you might not have had much. You understand?
Yes.
Yes. Would it have been 2 or 3 cases? Would it have been 10 cases? Would it have been 30 cases? Are you able to try and give us a reasonable estimate?
Yes, there are more than 10, but less than 20, I believe.
Yes.
Yes.
And did you give extempore judgments in some and gave written judgments in others?
No extempore judgment. All were written judgments.
Yes. Have you sat in motion court in the High Court?
Yes.
How much exposure, how many weeks have you spent on motion court?
I think, I don't remember now, but I think it was 2 weeks.
2 weeks?
I believe so. I don't remember quite well, but I think it was 2 weeks.
Yes.
Yes.
Yes. I think that would be quite limited motion court for somebody who hasn't had a lot of exposure to civil work in the court where they are, isn't it?
Yes.
Yes. Okay. And have you had exposure to dealing with, in the High Court, with matters where you are required to declare a piece of legislation as unconstitutional and to provide an appropriate remedy?
No.
You have not had that?
Yes.
In the matters that you have dealt with in the High Court, have you had any administrative law cases that you have dealt with?
I don't remember now up front. I don't remember.
Yes.
Yeah, but
I would imagine that at regional court or magistrate court, you wouldn't have had much of administrative law cases, isn't it?
Yes.
And therefore, if you had dealt with administrative law cases in the High Court, it would be easy to remember because it would have been something new.
It may be so that I dealt with some of the matters which include administrative law.
Yes.
But really
But you can't remember?
Yes, I can't remember.
Yes. Okay. In motion court, have you dealt with urgent applications?
Yes.
About how many, if you are able to remember? Or you can't remember?
I can't remember. Yes, I can't remember ECJ.
Yes. Okay. Thank you. Judge President?
Mr. Masango, the division is the last born division, is new. Would you agree?
Yes, I agree, JP.
And you might be aware that before we were properly established and we're still functioning as the Gauteng division, there were few permanent judges in the division.
Yes, I'm aware, JP.
And would you agree that as a new division, you are going to be forced to, or you will need fairly all-rounders judges, so that you should not be having a situation where, as the head of court, you feel a little bit uncomfortable to allocate certain matters to other colleagues. Would you agree with that?
I agree, JP.
And you would have seen from some of the comments, which I must tell you, I take them quite very seriously. The comments made by Nadel, the comments made by Law Society, where they indicate, amongst others, that perhaps you need much more time and perhaps more time to act before you could be considered for permanent appointment. You must have seen that.
Yes, I've seen that, JP.
Okay. And you are presently a regional court magistrate, and you are based at Mkondo, formerly Ermelo, am I right?
That's correct.
Yes. And I have approached you not very long time ago to come and act, but you could not be released by your regional court president, and you are supposed to come and act for the whole term, but your regional court president could not release you.
Yes, JP.
Okay. Thanks.
Thank you. Thank you, Judge President. Premier?
No question from my side, thank you.
Thank you, Premier. Commissioner Notesi?
Just one. You have noted the comment of the GCB where they say that your judgment lacked logic and that they are not well written up, and the reasoning, they criticize you. Did you see that?
Yes, I've seen that, Commissioner.
My question is, admittedly from yourself, don't you think that one, because you do not have much experience, exposure in civil litigation, that at least you need to be given more acting? You should have engaged the JP to allow more acting than to seek it by way of directly coming to have those comments such as made by the GCP.
The comment that has been made, which of course I welcome the criticism that has been leveled against me in that judgment, but that comment has been based only in that judgment. They did not, actually I've submitted more than 3 judgments, not all and the 2 judgments which were civil matters. And the other one is, the third one where I was criticized is the civil, which is it's also a civil matter. And I accept that one, I accept the criticism, but I feel that with the experience I have in the bench, I can still do better. And because the criticism is not only in all the cases I've handled in civil, but only one case which I handled in civil.
Thank you, Mr. Chair. But, you know, as I'm sitting, I mean, something is bothering me. You mentioned that you were a member of the ANC between 90 to 96.
Yes.
But you could not tell us when there is another, when you have to express other organization. You just leave it blank. Why is it not opportunistical that you just mentioned this ANC membership, which is even terminated long time ago? It was only for 4 years, it terminated. And then you just mention and then you tell us nothing more about you.
I actually terminated the membership of the ANC because during 1996, I was appointed in the bench and I could not have been a member of a political organization while also a presiding officer, a judicial presiding officer.
Thank you. I don't see any hand here. Commissioners on the virtual platform, any question?
No, thank you, ACJ.
Thank
you, Chief Justice.
Thank you. There are no questions. Oh, I think Commissioner Slema, did you have you are fine.
Thank you, ACJ.
Yes.
Mr. Longa, I would just like to know from you, also in relation to your the knowledge of civil law and the fact that you don't have much experience, how much extra do you read to gain more confidence in the civil law matters that you deal with? Because when I look at your judgments, Mr. Masango, my apologies, when I look at your judgments, they really lack more detail and they lack dealing with the legal principles. They basically deal with just setting out the facts and applying your intuition almost, it seems to me. Can you just help me with that?
I actually study a lot in civil because now I'm stationed in P3D from Kondo and I'm dealing with both criminal and civil matters in that regional court. And it's actually a call for me to study because I'm all by myself in that regional court and handling all the civil matters in Volkrust, Mkondo, and Amsterdam, all by myself. So that calls for me to study every day in my civil work.
Thank you, Mr. Masango. Thank you for availing yourself and for coming to the interview, but you are now excused.
Thank you.
Next candidate.
ACJ and the commissioners.
Good afternoon, Mr. Nkuna.
Good afternoon, Honorable ACJ and the Honorable Commissioners.
How are you this afternoon?
I'm good and very much happy that the day I've long been waiting for has finally come.
Thank you. Thank you. Welcome to this session of the Commission's interviews, and thank you for availing yourself for consideration for appointment as Judge of the Mpumalanga Division of the High Court. I see that you hold 3 degrees, B. Juris, LLB, and LLM. Is that correct?
It is correct, Acting Chief Justice.
And you got your first 2 degrees, namely B. Juris and LLB, from the University of Zululand, and you got your master's from the University of the North, and you wrote here in collaboration with Potchefstroom University.
It is correct, ACJ.
Yeah, what does in collaboration with the Potchefstroom University mean in the context of the degree?
The program was offered by both Pew for Chair and UNIN.
Yes. Okay, and your Bureau's degree was obtained in 1991, your LLB in 1996, and then your LLM 2002, is that right?
It is correct, ACG.
And you started your working career initially as an assistant teacher in 1981.
It is correct.
And in 1983, you became a clerk in the Department of Justice and a court interpreter and a clerk, is that right?
It is correct.
And then 1989 to 1993, you were a public prosecutor. And in 1993, April to July, you were acting magistrate, is that correct?
It is correct, ACJ.
And in July 1993, you were appointed as a magistrate, and that was up to 2004, is that correct?
It is correct, ACJ.
And from 2004 to date, you are a regional magistrate.
It is correct, ACJ.
Yes. Now, during the time that you have been at different levels of being a magistrate, have you adjudicated civil cases?
In fact, I've got a very solid foundation and background of civil law. When I joined the Department of Justice as a clerk interpreter, at the same time, I was also serving as a clerk of the civil court, where all civil processes begin. And when interpreting in the civil court, all those arguments, submissions, everything that was happening in that court did not get in through one ear and got out through the other ear.
Yes,
I
understand,
kept them
I understand that, Mr. Nkuna, but remember my question is adjudication, not interpretation.
Okay, thank you.
Whether you adjudicated civil cases during the time or when you were at different levels of being a magistrate.
After I was appointed as magistrate, I was later appointed as head of office at 2 different stations. During those days, there was an undocumented tradition or practice that civil matters were mainly done by the head of office only. I was the only one who was doing civil matters. Fast forward, now in the regional court as regional court magistrate, I'm doing both criminal and civil. I'm actually doing 2 courts alone. That is Palabora and Lulegan, without any assistant, not even a typist, nor a clerk, everything alone by myself. And when I was invited to do my acting stint in the Gauteng division, I was only allocated civil matters. So with civil matters, I don't have a problem at all.
So let's talk about the time before you were appointed to the regional court. Just when you were a magistrate, I just want to get an idea how much exposure you got to the adjudication of civil cases. Just talk about that period only.
In fact, even before I was head of office, at the time when I was additional magistrate, at our court where I was, we're doing everything. So I've been doing civil matters from 1993 to date.
Yes. Now, during that period, that is when you are still a magistrate, not regional magistrate, what types of civil matters were you adjudicating?
Although I cannot mention them one by one, I will generally say...
I don't want you to mention them. I want
the
types.
I did all civil matters which were justiciable in the district court.
Yeah, what branches of law? That's what I want to the exposure, Was it debt collection?
Debt collection, administration of estates, damages, a lot of them, credit agreements, mainly everything.
And at regional court level, how much exposure have you had to the adjudication of civil matters?
When the civil jurisdiction was introduced, I think it was 2015, was introduced in the regional court. I've been doing civil up to now.
Yeah, how much exposure has that given you to the adjudication of civil matters?
In terms of
volumes and in terms of different types of cases?
Well, although it seems I don't get the question well, but...
branches of law, I want to hear about branches of law, the cases
delict,
that come before you.
Contract, road accident funds, various court interdicts, divorces,
yes,
damages,
yes,
all of those.
Okay. Now, you became a magistrate from July 1993 and became a regional magistrate from 2004 to date. But I see that in paragraph 8 of the questionnaire, where you were asked to indicate particulars of your membership of any political organization, past or present, you have said African National Congress, and the position is member, and you say you have been a member of you were a member of the ANC from 1982 to 2015. Is that correct?
It is correct, ACG.
But how you were already a magistrate from 2004. Why did you keep membership of a political party while you were on the bench?
What happened was after I joined the ANC, every time again you have to renew your membership. I did not personally renew the membership myself. Well, a friend of mine, a relative of mine, used to do that. But then I wasn't even aware myself. So in 2015, because we're no longer staying in the same place, he came to me and said, Mzee, you must remember you owe me so much. I said, for what? He said, this and this and that. I've always been renewing your membership. I said, no, you shouldn't have done that. You have to stop it. So he did not renew it until 2015 when I became aware.
I'm sorry, just repeat. What are you saying?
In fact, a relative of mine who recruited me to join the ANC in 1982 is the one who, it was not only me alone. He used to renew our membership on our behalf. We are no longer staying in the same place because we moved to different places. Well, every time we used to continue, as a family, renew our memberships. So the only time I met him again, it was 2015, I think. So as we're talking and all this, he said to me, Mzimi's cousin, you must know that you're owing me so much. I said, what is it for? He said, no, you have not been renewing your membership. I've always been renewing your membership. So you have to pay me. I said, no. You shouldn't have done that. You did not even inform me. So please don't continue to do that. So he stopped doing it from 2015. He never renewed my membership.
But you never resigned from the ANC, did you?
Well, in terms of the ANC constitution, if you don't renew your membership within a particular period, you are total out. You don't need to officially.
Now, are you telling us that for about 10 years, every year, there was this person renewing your membership of the ANC without you knowing?
It's correct. I must tell the truth.
When you renew, you are not required to sign anything.
No.
Yeah, but he was paying his or her own money on your behalf.
Yes.
For 10 years.
Yes.
Without you knowing.
Exactly.
Judge President.
Thank you. Mr. Nkuna, I was not going to ask you any question if you were not a judicial officer, especially seen in the light of the interaction which you had with the acting Chief Justice. And I think, out of concern from my side, I feel obliged to ask you some few questions.
Thank you, JP.
Would you agree that as a judicial officer, you need to have integrity, character, and temperament?
It is correct.
Now, you are aware that NADEL, Law Society, BLA, and GCB made comments about you.
Yes.
And in your response to these comments, or some of these comments, in paragraph 3.5 of your letter dated 24 September 2021, you said the following: according to me and how I know myself, I am satisfied that that period of 4 weeks, and remember, they are all saying 4 weeks of acting is not enough and perhaps you need enough time to act. That period of 4 weeks was honestly more than enough for a person like me. Now, you have just made a statement when the Chief Justice asked you the first question, and you said this, and that was with reference to your experience regarding civil litigation. And this is what you said: I have a very solid background in civil litigation. Now, here's my concern. I have always thought that we need to allow our actions to speak for ourselves. Do you truly believe in that?
Yes, I do.
Now, are you worried by the statement that you have made this morning and the statement which you have made in your letter of the 24 September 2021, that perhaps that belief is not applicable to you, because you are saying, according to me and how I know myself, I am satisfied that the period of 4 weeks was honestly more than enough for a person like me. Do you?
It is true.
Yeah, it is true, but do you really, with this statement, believe that you believe in the principle that we should allow our actions to speak for us?
Well, maybe I may not be understanding the question, but I still stand by those words that as far as I know myself, I am ready.
And yes.
And I can do any civil matter. And during my acting stints, all the matters that I dealt with in the High Court were only civil matters. And as you may have seen, all my judgments were delivered within 10 days. In one matter, which I did at Toyando, when I checked the file, it had moved from one acting judge to another acting judge, from one acting judge to another permanent judge.
Okay.
It was a voluminous matter, but after having gone through the file, the very same file, I received it that morning for the first time. I did not get it a day before or what. Even the councils, in the morning, they came to me and said, we are sorry to understand you've just arrived and you are getting this file for the first time. We are prepared to have the matter postponed so that you can have a time to go through it. I said, give me just some few minutes, about 30 minutes. I'll come back to you. In these 30 minutes, I was able to go through the file and realize that no, I cannot be intimidated by the size of the file.
Okay.
There is actually nothing. Okay. I delivered the judgment in 30 days.
Okay, Mr. Gunnar, let us take it a step further, especially from what you're saying.
Thank you.
Paragraph 6.4.2 of the GCB's comments, they speak about you. They speak about a judgment which was on appeal handed down by Khanyago J and Paduli J. And listen to what they're saying about you. And that is in paragraph 31 of that judgment. And I note that in your letter of the 24th September, you did not respond to it. And I'm just raising to this because this is very critical, because you remain to be a judicial officer. And listen to what they're saying about you. Another area of concern in the proceedings in the Kotako is the unwarranted interruptions and unjustifiable entry into the arena by the presiding magistrate. It will therefore be prudent to quote a few examples to show the seriousness of the misdirection by the trial magistrate. Close quote. Now, this is very serious. Would you agree with me? And do you want to comment on this?
Well, first and foremost, I did respond in my letter dated 24 September 2021.
And what did you say?
I can again respond even now. First and foremost, the case referred to was a regional court matter. The question relates to cases which I did during my acting stint. Had I mentioned that case, a regional court matter, I would have been irrelevant to the question. But be that as it may, after I received those complaints, I had the opportunity to go through the case again. Well, with respect, I respect the comments indicated, but the truth is this. When you are a presiding officer or a magistrate, amongst other things, your responsibility is to see to it that justice is done. Justice means that you also cannot allow an injustice happening under your watch. In that matter, the defense was not cross-examining the state witness. He was, in fact, disorganizing him and harassing him. I couldn't fold my arms and watch as an umpire, and even an umpire. He's there to see to it that the rules of the games are followed. You would ask one question which was previously overruled 10 times in different ways. So I was trying to indicate to him, for the sake of time, that Mr. So-and-so, you have already asked this person. You can't keep on asking the same thing. I have never descended to the arena as far as the merits of the matter is concerned.
Chair, thank you.
Thank you. Premier.
Thank you very much, Chairperson. No questions.
Thank you. Commissioner Nyambi.
Morning, Mr. Nkun.
Morning, Honorable Commissioner.
One question from me. If you can share with us your understanding of the difference between judicial accountability and judicial independence.
Well, judicial independence, it means, because it stems from the doctrine of res politica, separation of powers. It means that whatever the judiciary does should not be interfered with by the other organs of the state. But judicial accountability, it means whatever you do, you must account to the Constitution of the Republic of South Africa. By the Constitution, amongst other things, it includes the citizens of the Republic of South Africa.
Thank you, Mr. Nkuna. Thank you, ACJ.
Thank you. Commissioner Matonsela.
Thank you, ACJ. Good afternoon. Dr. Paul Nkuna.
Good afternoon.
I just want to declare that you and I were in the same class for 3 years.
Exactly.
And when I saw your form, I remembered this handwriting, which was written in your left hand, because I used to have your notes where when you always attended lectures and I was busy somewhere. And I would, I would rely on your notes.
I see.
Yeah. I still remember those days.
We had good times. Yes. I thought I should disclose that upfront, and I can see that resilience in you even today, as you were even in those days. Tell me, I see you have gone on to do a master's in environmental law.
Yes.
Have you been able to deal with cases in your judicial experience having to do with the environmental law?
Oh, that is my passion. Even now as I'm speaking, I've got a marathon matter around environmental law. As now I'm stationed along the Kruger National Park, obviously on the day-to-day basis, we'll deal with a lot of environmental matters. And because of my passion in environmental law, this is even known. Sajay will from time to time request me to come and address district magistrates on the adjudication of environmental matters.
Thank you.
Thank you, Commissioner Matonsela. Commissioner Pofu.
Thank you. Good morning, afternoon.
Afternoon, Commissioner.
Thank you. I just wanted to say this, some things never change. Yes. We were here until 3 a.m. on Tuesday, and Commissioner Matonzalo was busy somewhere.
Preparing for an appeal in Namibia, yes.
Thank you. Yes, no, I just wanted to follow up on Commissioner Nyambi's issue on judicial independence, and to relate that to this issue of your membership of the ANC. You do understand, all right, let me put it this way. Why do you think in our form we ask that question, question 8, which says, please furnish your membership of any political organization, past and present?
Well, the reason is very clear. As a presiding officer, there are matters which may appear before you involving political organizations, and you'll have to deal with those matters. So if you retain a membership of a particular organization, whether at the end of the day you rule in favor or against, the public perception out there, they will always say it is because it belongs to this organization.
Good. So even if you exercise the best independence, your decision will be questioned, because justice must not just be done, it must also be seen to be done.
Exactly, Commissioner.
Right. Now, so you'd agree then, let's accept for now the story about somebody renewing your membership for you. You'd agree that for that period of those those renewals, then it means you were in breach of that principle.
Yes, I admit.
Yes. So how did you join the ANC in 1982?
Hey, I'm afraid to disclose that, but I will disclose, because when I joined the ANC in 1982, the ANC was still underground. So I don't have the permission of the person who recruited me to join the ANC to mention his name. Otherwise, I would mention it.
What will happen to him? Because the ANC is unbanned now.
I'm sorry?
I'm saying the ANC is unbanned now. What will happen to that person? I joined the ANC in 1980, and I can tell you how
what I'm
it.
saying is he did not give me permission to mention his name. But I joined the ANC when it was still underground. They used to go around and give us forms and lecture us about the ANC. That's the time I joined the ANC.
Okay. No, that's what I wanted to ask you about, because there was, I don't want you to mention anybody's name, but my question was how, and you've answered that question. You said they gave you forms. Forms, what kind of forms?
Just to complete your name, where do you stay, and all those kind of things. Your particulars, in short.
And a form, and say, I'm now joining the ANC in 1982.
Yes. Yes.
In the country.
You were living in South Africa at the time?
Inside South Africa. Eh?
Yes,
they gave you those forms.
South Africa.
You were inside South Africa.
Yes.
Okay. Right.
Can I just...
You are done?
No.
Oh.
No, I think, I'm done. Thank you.
Commissioner Traba.
Thanks, Commissioner Bofo SC has asked the questions I wanted to ask. Do you remember signing the ANC form in 1982?
Yes, it cost us something to sign.
How much did you pay?
No, we did not pay.
Did not pay anything?
No, we did not pay anything.
Do you remember receiving a membership card?
He gave us membership card in 1989. When we again signed the new forms, in 1989 again, when the ANC was still unbanned at the University of Zululand, that was the first time when I received the membership card.
Okay, thank you. I have no further question.
So, just follow up.
Yeah, okay.
I'm sorry.
Yeah.
So in 1989, you received a membership card?
Yes. at Zululand.
Yeah. And then the person who in 2015 said that he had been doing these renewals for you, how much did he say you owed him?
Well, I can't remember the exact amount as to how much he said. He only said you owe me some money, mentioned the figure, but I did not keep it in my head.
But
Because it was not a formal meeting. We had gathered as a family. It was a family ritual. So we just brought it in and said, you are from.
All right. No, that's fine. Let's leave that. Okay. Once you discovered that there had been this technical mishap, let's call it that, did you take any steps to inform the Department of Justice or the magistracy? I don't know how it works. To say, look, there has been this ethical breach. I was not aware of it, but I just want to report it. Did you do anything like that?
No, that I did not do. The only step I took was to revisit the constitution of the ANC to check if I should formally withdraw my membership. That's when I realized that it was not necessary, because if you did not renew it after a particular period when your membership is expired, you are automatically out. So as far as the commission, I must admit, I did not take it up. I did not take it up, I must be honest. I thought that.
No,
anyway,
fair enough. So, but that was in 2015.
Yes.
In other words, even when you became aware that there was this technical glitch, you remained a member of the ANC until the next payment was due, and then it lapsed.
No. The membership was supposed to have been renewed in 2015. And from 2015, it was not renewed.
Thank you, Mr.
I'm not going to take more questions really. I'm going to allow, sorry, Commissioner Nyambi. If
It was a follow-up about that issue.
I'll ask them to ask their questions, and then you can tell me afterwards whether you still feel that you need the follow-up. Just, Commissioner Makwanisha?
No, I think
You are covered.
Chief Justice, I'm covered. No, this matter has been
has been dealt with.
ventilated properly. Yes.
Thank you, Judge President Lambo.
Thank you very much, Acting Chief Justice. Good. Abshen Tata.
Hepfukile njani JP?
Awa, sihlayisekile. Sirila skona.
Naye akuna sirilo.
There are commissioners who don't believe I speak 11 languages, but anyway.
No, just like me, I speak all languages in South Africa.
I just want to move you back to your work, and it's only fair that I raise this with you because we've raised it with your colleague Laminga, and it was raised with your colleague Langa. I have to raise it with you. We received the Correctional Services tracking document about awaiting trial detainee parted trials. There's a Nkuna who appears on the document right at the top in Palabora. You would have been given that document yesterday.
Yes.
It's a trial that's been parted for over 6 years.
Yes.
Is that one of your cases?
Yes.
Right, and I just want you to explain to the Commission how come it's lasted so long. And I take cognizance of the fact that in the station where you are, you're the only regional magistrate. Am I correct?
In fact, I serve 2 stations being one.
Yes.
Palabora and Lulekan.
Yes, and as the only regional magistrate.
Yes, doing both criminal and civil.
Well, I think the members of parliament who are in charge of justice are listening. But can you explain to us how come this trial has taken so long, if all of it was under your watch?
I think whoever lodged this complaint did not go through the record properly.
There's no complaint. It's
Okay.
just an issue we are raising as a commission
Okay.
with you.
Thanks, JP. This accused, I think his name is case 53 of 2014. In this case, the accused referred to in the letter I received yesterday, he is not the only accused person. He's appearing with another accused. They have at all material times been released on their own recognizances. They have never been in custody. Now, accused number 2, they are referring to, whilst was on his own recognizance, he committed other offenses. And in those offenses, he was kept in custody in the district court, not in the regional court. Now, after one time he did not appear, he was in default in the regional court. That is when I picked it up that he had other matters in which he was now in custody in the district. I then asked the prosecutor if those cases which are still in the district will later be justiciable in the regional court. He said, yes, there will be regional court matters. I then suggested to the prosecutor, look, let us not proceed with this matter in which is now proceeding in the regional court. Because if I proceed with these 4 counts and at a later stage, they transfer the other counts to the regional court, it will mean I will have to recuse myself in respect of that matter. And it will be very difficult to get another regional court magistrate to come and do this matter. We waited for those cases. They were later transferred to the regional court. We joined the matters. In those matters was in custody, the ones which were transferred from the district. Because he had come to court on his own in the matter which was already in the regional court, we agreed it will only be fair to grant this gentleman bail. Indeed, on the 28th, in November 2018, he was granted bail. Thereafter, the trial began. When we were in the middle of the trial, I realized, he was having this strange behavior. I said, no, we cannot proceed if it's like this. I invoked Section 77. We referred him for mental observation. In Limpopo, there's only one institution that deals with that. If you can refer a psychiatric patient now, you will be lucky to get the earliest date anytime before June next year.
Mr. Kuna, let me just stop you there because you giving us a long-winded story. Are you trying to tell us that the 6 years awaiting trial there is in relation to other offenses, but it was not before you?
No, it was not.
That's what we expected you to tell us.
I wanted to clarify so that maybe it could be clear as to how it came about. Even now, as I'm speaking,
yes,
we have proceeded. The state has led the evidence of the last state witness, just last week.
Yes.
When the defense was about to cross-examine the last state witness, he changed and started behaving unusual. We stopped again. What do? We have now agreed that, okay, let us call the doctors who assessed him. Maybe they will come and tell us if it needs a reassessment, it will need to be reassessed again.
Mr. Nkuna, thank you very much.
Thank you very much.
I think, although what you're saying now is important for members of the Justice Portfolio Committee, the issue of one mental institution for Limpopo has been a problem. In fact, at some stage, it wasn't there in Mpumalanga. All those cases were being sent to Gauteng, hence Gauteng was overloaded. But I'm happy you brought it up. I didn't. But I take it you're saying it's not parted before you for 6 years.
No.
Thank you very much. Thanks, Acting Chief Justice.
Thank you. Commissioner Nyambi, do you feel strongly? You're fine. Okay, all right. Commissioners on the virtual platform, any question?
Nothing, thank you, Acting Chief Justice.
Acting Chief Justice, if I may raise one question.
Okay, go ahead.
Thank you. Good morning, sir. I would like you to deal with the question of jurisdiction once you're sitting as a High Court judge in a matter where a financial institution sues a person for a relatively small amount of money in your court. How would you deal with that situation?
I did not understand the question. May you repeat it?
Certainly.
Yeah, I think he's asking you to repeat the question.
Yes. A financial institution or bank sues a person for a relatively small amount of money and brings that matter before you as a High Court judge. I'd like to know how you approach that situation, please.
Well, I will proceed with the matter, but when it comes to course, I will grant the magistrate, I will grant a course on the magistrate scale.
Thank you, ACJ. Thank you.
Thank you. I think we have come to the end of this interview. Thank you for having availed yourself, Mr. Nkona. You are now excused.
Thank you very much, ACJ, and thank you, commissioners.
Mr. Nkuna, I thought you'll tell the commission, me and you used to play football many years ago in Namahale.
Yeah.
But you couldn't score when I was goalkeeper.
Next candidate.
Well, as I said, some things never change.
Commissioners, let's start. Commissioners, let's start. Yeah, okay. Good afternoon, Mr. Rolofse. Thank you. I think bring your mic closer to you so we can hear you.
Thank you.
Yes. How are you this afternoon?
Very well, thank you, Acting Chief Justice.
Thank you. Thank you for availing yourself for consideration for appointment as a judge of the Mpumalanga Division, and thank you for attending this interview session. I see that you hold the degrees BCom Law, BProc, and LLB, and then you have a Diploma Juris and a postgraduate diploma in financial planning.
That's correct, Acting Chief Justice.
Yes. And you got your BCom Law in 1987, is that correct?
That's correct.
Your Diploma Juris in 1991?
Yes.
Your BProc in 1993?
Yes.
And your postgraduate diploma in 2003?
And the LLB, it was in 1 year that I achieved both.
Or do you do the LLB and the
yes
financial planning diploma same time?
Same time, and only a few people passed that diploma. It's very difficult.
Oh, and the Diploma Juris, did the credits you got there, did they not get recognized for your BPROC?
It did, but they made a mistake. They made me do a private law twice, contract and dealing twice.
Yes.
So I know that by now.
Yes.
But it was a mistake.
Yes. Well, there is a candidate that we interviewed one of the days this week who had started with a diploma juris, and later on I think he had either a B juris or a BPROC, and I asked him whether the diploma juris survived or whether it got subsumed in the B juris or BPROC, and he said it got subsumed.
Yeah, I think
did this not happen with you?
I think it did, but I had to do dip juris at that time because I was a prosecutor. And I only was appointed as a justice clerk prosecuting in the regional court. So,
Yes.
so I had to do it to get a law diploma in order to continue prosecuting.
Yeah, but the point I'm raising is whether once you got BPROC, you are entitled to write both of them, or whether once you had BPROC, the courses that you had done for the diploma juris get subsumed in the BPROC, and whether you should just write BPROC, it never counts. It doesn't count anymore, or does still count?
Well, the certificate is on my wall. It was conferred upon me.
Sorry?
The certificate is on my wall. It was
Yes.
conferred upon me. BPROC was conferred upon me, LLP, and so on. So
Yes, no, but that's not the answer. They would always have been conferred. The question is whether the rules of the university concerned don't say that if you get a BPROC, then the diploma juris falls away.
I don't know. It was two universities. One was
It
UNISA
doesn't.
and one was Pretoria University.
Okay, no, I think we have an academic here and she says it doesn't, yeah. Okay.
Thank you,
But I ask
Professor.
you because earlier this week we had a candidate who said this is what happens with. Okay. All right. You started your working career as a warden in the Correctional Services Department, is that right?
Yes, I started at the tail end of the justice system.
Yes, and then you became a prosecutor.
Yes.
But then you left the Department of Justice and went to the private sector and became an insurance agent.
Yes.
And later a financial planner.
Yes.
And then in 2003, you started practicing as an advocate.
That's correct.
And have you continued practicing as an advocate without interruption up to now?
Yes.
Okay, tell us please about the types of cases that you have been doing as an advocate since 2003.
A wide variety, Chief Justice. Criminal work, all that came my way. I never perceived myself to be entitled to any brief. I worked for any brief, for my briefs. So it is a wide variety.
Yes, but I want that wide variety because I want to assess how much exposure in terms of different branches of law your practice has given you.
Criminal law I did first few years, like many people. Then it went to land issues. It also went to environmental law. It also went to contractual disputes. It went to a certain extent to construction disputes, insolvencies, and also the land issues. I did many land claims work.
Okay. Have you done? I see from your question you have only done one labor matter, is that right?
Yes, one labor matter, yes.
Yes, constitutional law, you said, often in respect of evictions and in respect of land claims, court matters.
I appeared once in the Constitutional Court to review a decision of the Constitutional Court. I think it was the first time I lost, but...
Yes. Okay. And you have acted in the High Court?
Yes, acting Chief Justice.
And for how long have you acted?
It will be 86 weeks by this time.
It will be
86 weeks.
Yes, yes. And how have you found acting in the High Court?
I enjoy it.
Yes. Okay. Judge President?
Thank you, Chair. Mpumalanga Division is a fairly new division.
That's correct, Judge President.
Despite being a new division, judges complained in a way which made me to be happy at the end of the last term that you have never had a busier term like the one which we had this year. Am I right?
It is so, Chief Judge President. It's because of case management. Cases are managed. So by the time you get a file, it's ready to be disposed of.
Yeah. And you are aware that the establishment for the division is only 9 judges.
Yes.
And up to now, there are 7 permanent judges.
Yes, Judge President.
3 were appointed in April this year.
Yes.
Out of the 7, we have 4 women judges and 3 male judges.
Yes.
Myself, Judge Mashile, and the newly appointed Judge Rachivumo.
That's correct.
Yes. Now, would you agree that as a new division, we would require fairly experienced judicial officers, almost like all-rounders?
That's correct.
I think it is now known that in the province we have so many criminal matters. And if we were having sufficient funds, we would actually be having 5 criminal courts running on daily basis.
It's absolutely necessary, Chief Justice, Judge President.
No, I will be Chief Justice one day, don't worry.
Well, somebody said 95% chance that somebody in this room will be.
Yeah,
I think it was Pofu who commissioned Pofu.
I'm due to retire, but I'm going to be Chief Justice one day.
Well, Judge President, now you run that division, it might be possible.
Yes. But I think we need to be thankful to the Minister for having tried to help us in dealing with some of this, despite the budgetary constraints that we are facing as a country. And for that, we need to be thankful to you. Now, you have written how many judgments since you acted in the division?
46. Judge President, some judgments I give extempore, where the issues are not difficult, and that way justice is dispensed faster, sooner. But 46 that I've recorded.
You are currently acting until the end of the term?
Yes.
And how many reserve judgments are you still having?
I did 4 very difficult opposed motions yesterday. I gave the parties my prima facie views. Senior counsel were involved in all of them. When I gave my prima facie views, subject to a change of mind or conviction otherwise, 1 settled, 1 was withdrawn. I was left with 2, which I finalized, and I have to write those judgments. So for all the time I've acted, the only judgments reserved is 2. I delivered a judgment which was difficult, which Judge Mashir and I sat in an application for admission, which raised constitutional issues, which was also delivered yesterday. So, judgments outstanding from yesterday.
And what magic are you performing? Perhaps you are going to a place called Mbuzini, and I'm sure Commissioner Nyambe will know that Mbuzini is where we get power, so to put it.
Well,
where do you get the energy, the magic to be able to finalize these matters as soon as possible?
JP, it is because every time I open a file, I look forward to the new journey. Because every file is a journey to somewhere. It's a journey on facts or the law, and both. So I'm filled with excitement by opening a court file. I can't wait to open it. Sometimes while it's still in the boot of my car, I check it. Then I, like people, binge drink and binge series, I binge judgments. I don't stop until I'm finished. And that is what I attribute to how I do it, Judge President. I do not stop. It's better to rest and know your work is done than to rest and worry that something still needs to be done.
And the beauty sometimes about affording people for a longer period of acting as the head of court, you become to know them better.
Yes, yes, Judge President.
And that is very important in every court setup.
Yes.
And you would agree with me. There is a saying which goes around like this, and I'm sure you'll agree because you're an advocate, that legal practitioners or advocates, they know judges better than the judges know themselves.
Yes, because they talk amongst each other.
Oh, well, we also, I suppose. But here's the thing. When you hear comments from these important bodies like NADEL, like BLA, like the Law Society, like the GCB, as a head of court, you need to take those comments quite very seriously because they're important and they know better.
Yes, because ultimately you are serving the people through the people that are part of those institutions, and that is the legal practitioners. So it's very, very important to take that into account.
And I'm not sure if you're aware of this. Sometimes as head of court, there are certain matters, and because you have got colleagues around you, you know their strengths, you know their weaknesses, and without disadvantaging the others, once you have matters and you have to allocate, you have to say first, to whom can I give this complicated matter? Would you agree?
Yes, that is so, Judge President.
Okay, and that can be done without disadvantaging other people because we teach each other all the time.
Yes.
And the beauty about having experienced judges sometimes is to ensure that those who come after them, they learn from the most senior judges or experienced judges.
That is correct. That is so.
Okay. Now, lastly, there is these Friday meetings, and those Friday meetings, they started last year and they've been done virtually every Friday. What is the beauty about it, if there is any? Or perhaps you should just stop them.
No, please. I attended this morning's meeting because others were here and I was still coming, so I had time to attend. Judge President, many things are discussed. Sometimes, like in Women's Month, there was an effort made to give tribute to women. And how proud we as men are of those women who are on the bench. We encourage each other because we have difficult roles sometimes. And we also speak about common issues. We speak about issues like that there should be uniformity without interfering with a judge's discretion. And that is important. So it must continue. And it's extremely valuable.
And in that meeting, now that you're reminding me, male colleagues spoke, and female colleagues were so overwhelmed that they were not even able to express themselves, just overwhelmed by what the male colleagues said.
Yes.
Okay.
JP, there is collegiality. This morning at 6 o'clock, I was working by a call from one of the female permanent judges who said she wants to pray for me.
Oh, really?
And she started praying for me. And that is the kind of collegiality that, Judge President, you're the leader. You created that, and
No.
we appreciate that.
There's nothing like that. I can't do without you. I think it is you. I am the one who need to be thankful for that cordiality. Now, you are, and I'm just raising it now because it's likely to come out. You are a male, white person who aspired to be a judge.
Yes.
In our division, as it is now, 7 judges, we do not have any judge of color mean white or even Indian for that matter. Now, this question is likely to arise. Do you want to deal with it now or you want to deal with it later?
Judge President, the bench must be representative of the wider society. We have many white people also in the province, Middelburg, and that is the Highveld and the Lowveld. And it is time that a white person should also be appointed to that bench in order to represent the diversity of the province. Subject thereto that person is capable to do the job.
Chair, thank you so much.
Thank you, Judge President. Premier?
No question, thanks.
Thank you, Premier. Commissioner Notesi?
It's just a follow-up to the JP's question.
Yes,
why do you say it's time for the white men should be appointed? Why it should be when they have been there for 365 years with no black people? Should we use the word should be appointed? Well, or we just say it must come?
It must come. I agree. The issue is this, that it's a new division.
Yeah, but we must not say they should.
Yeah.
We're not forced to do that.
Yeah, nobody's forced to do anything, but it's time.
Commissioner Motolo Lepu.
Thank you, TCJ. Good afternoon. Is it afternoon? Yeah. Good afternoon, Advocate.
Good afternoon, Commissioner.
Just remind me, you are the one who's doing a lot of work for the LSSA.
Yes, and no, not for LSSA. I'm a council member on the Mpumalanga Legal Practice Council.
Okay,
yes.
just I just wanted to verify because I thought I always see your name. Okay.
Yeah, you will see my name there.
All right, thanks.
Thank you, Commissioner Nyambi.
Thank you, SJ. Afternoon.
Afternoon, Commissioner.
It's one question from my side. When dealing with JP, we have touched the positive about the division. Probably if you can assist us to understand as a commission whether you are ready in terms of the immediate challenges facing the division of this rural province called Mpumalanga.
Commissioner, I'm ready. There's hardly no court in the whole province I have not yet appeared, from east to west, from north to south. I know the people, I know the courts, I know the challenges. I know the issues about gender-based violence. I've written many judgments on that. So I am ready to serve my province, and that is Mpumalanga.
I thought you were able to touch the positives. Yeah, I was expecting you to deal with the immediate challenges, not just say there are challenges.
Yeah.
Single them out and share with us and what might be the solution.
Well, the immediate challenge we succeeded in getting rid of was an initial adversity by legal practitioners against the practice directives and how it was run. But after courses were given and after the judiciary made its inputs, That has improved tremendously. So that helps with access to the courts. The legal practitioners now understand the practice directives and why they are strict. And we have gone strides in that regard. So that is what I would consider the positive thing. We see now on our rolls matters that are ready to proceed. There is no reason for a postponement. Previously, when the division just started, there were many postponements, many reasons, many objections, but that has now been rectified. So we are running well now.
Thank you, Advocate Rolofse. Thank you, SCJ.
Thank you, Commissioner Nyambi. Commissioner Madonsela.
Thank you, Acting Chief Justice, and good afternoon, Advocate Rolofse.
Good afternoon, Commissioner.
May I please find out, are you, at the moment when you are not acting, what are you doing?
Nothing. No, I'm joking. I'm.
Too many are truth are said in jest.
Yes, I try to run a practice, but if you act for long times, you have to restart your practice. But there are attorneys that are very, very, very kind to me, so they still keep me busy. But obviously, you cannot commit to long matters if you don't know when the telephone is going to ring and you've committed yourself to the Judge President.
Can I have a follow-up, Chief Justice, on that? Do you keep chambers?
I do not have chambers now because I don't know what the future will hold. If I'm not appointed, I will join the Pretoria Bar and I will keep chambers there.
I have to follow up on this question because it was leading to something else.
Okay.
On the last occasion when we were here, the Mpumalanga Bar, of Society of Advocates, had raised an issue that you were, as it were, suspectus de fuga.
Yeah,
in the sense that they were complaining that you had not paid bar fees for a long time, and they were looking for them. Then you, when they were trying to discipline you on that, then you resigned.
Yeah, but
with an outstanding debt.
Yes.
Still not paid to them.
It is now paid. It's now paid. It was during the same time that the issue.
Are you answering the question that I've asked?
Sorry?
Are you putting words in my mouth?
No, I'm not. You may continue. Sorry,
I noticed when other people were asking you questions, you answered them before they did.
All right, I'll wait.
And you even had the nerve to tell us that it is time for you to be appointed.
Not me. I said it's time.
Because you are white.
Yes.
Will you please listen to the question I intend?
I will, thank you.
No, you're even interrupting when I'm talking.
No, I said I will, thank you.
Well, I don't have any question.
Did you want to follow up, Commissioner?
Thank you, Acting CJ. The issue of Mpumalanga advocates, it was brought to the Legal Practice Council, it was dealt with, and it was finalized.
Okay. Commissioners on the virtual platform, any questions?
No questions, thank you, Acting Chief Justice.
Thank you, Acting Chief Justice. I have a question.
Okay.
Good afternoon. So I'd like you to
Good
answer
afternoon.
a question pertaining to the jurisdiction of a High Court judge. And it's one we've asked other candidates. I'd like to know your approach as well. The facts are that a financial institution sues a person for a relatively trivial amount of money and prefers to litigate the action in the High Court before you. What would your approach be?
My approach would be to finalize the matter, but not to grant costs on a High Court scale. Because the decision of the SCA is that the High Court must hear matters, even though it is within the jurisdiction of the lower courts.
you then seem to be unaware of the recent authority that in fact in an NCA context, the requirement is for the financial institution to bring the matter in the magistrate's court.
Yes.
You are aware of that?
I will check that up.
That would then mean that your initial response to me was not correct, though.
Yeah, then it was not correct.
But then you can't be aware of that authority.
No. I'm saying that there was an issue over whether or not the high courts must or should adjudicate matters of the lower court. And I understood the judgment of the SCA to be that, well, the high court must. I just did not mention the issue of the NCA Act.
Thank you. Oh, is that follow-up?
I won't take it any further. Thank you.
Thank you so much.
All right. Thank you. Judge President Lambo.
Thank you, Acting Chief Justice. I'm covered.
Okay, all right. There are no further hands. We've come to the end of this interview. Thank you once again for availing yourself, Mr. Rolofse. You are now excused.
Thank you, Acting Chief Justice.
Thank you. The room must be cleared of people who should not be here when we are deliberating, and then we are going to deliberate.
What I wanted to ask him, I still want a question, a comment. Can you be correct?
Oh, okay. I'm sorry, Mr. Chair.
Cooperation in assisting me establish the court, they all laughed at me and said I was dreaming.
Yes, I was part of that meeting.
Yeah. But what I wanted the commission to know is that you were one of those practitioners who raised their hands and say, JP, we will assist you.
That's correct.
And you had no problems in being posted to far-flung areas of the province, Mkobola, Brayton, you name it.
No.
Thank
No
you very
problem.
much, Acting Chief Justice.
Thank you.
Thank you. You are now...
Chair, second thought again. You were, with your permission.
I'm sorry, you want a follow-up?
Yes, yes, it's
Okay,
some sort
all
of a
right.
follow-up, but because it relates to it.
Mhm.
You are also one of the advocates who established the Mpumalanga Society of Advocates.
That's correct.
And when it started, you also invited some of the judges to address the peoples, and in one occasion I was one of them.
That is correct, Judge President.
Now, what role did you play in ensuring that the society, the Mpumalanga Society of Advocates, takes to the ground?
Well, Judge President, I arranged for chambers. I, with the help of my wife, who did the administration, ran those chambers for a number of months. We paid from our own pockets, sometimes the salaries. We bought the toilet paper and the milk and the paper. We arranged for telephone lines. We did all of that. When the first pupils came, I was the only person there to train the pupils. They were 6. I trained all of them alone. There were no furniture for them. I built tables for them with my own hands.
Are you a carpenter?
It's one of my hobbies.
Okay.
So they had tables and they had chairs. And that's how it got from the ground. Later, the chairperson came more often and the membership grew. But that is what we did.
Okay.
Thank you, thank you, thank you. You are excused now, Mr. Rolofson.
Thank you. Thank you.
Okay. joining us on this afternoon's session of the Commission's interviews, and thank you for making yourself available for consideration for appointment as a judge of the Western Cape Division of the High Court.
It is an enormous pleasure, ACJ.
Thank you, thank you. I see that in terms of academic qualifications, Ms. Andrews, you have a BProc degree and an LLM degree.
That is correct.
That right?
That is correct, ACJ.
And you obtained both of them at the University of the Western Cape.
That is correct, ACJ.
And you obtained the BProc in 1992 and the LLM in 2013.
That is correct, ACJ.
Yes. And you served articles from 1992 April to 1994 in May.
That is correct, ACJ.
And you were admitted as an attorney in May 1994.
That is correct, ACJ.
And have you practiced as an attorney for all this time?
No, ACJ. Straight after articles, I went into a partnership. And then after that, I practiced for my own account as an attorney until I joined the magistracy in 2002 December.
Yes.
I then progressed in the ranks as a magistrate to a senior magistrate and currently a regional court magistrate.
Yes. So how many years did you practice as an attorney?
ACJ, by my calculation, I calculated to be roughly 8 years and 6 months. If you add my articles, it would be roughly 10.5 years, ACJ.
Yes. And during that time when you were practicing as an attorney, what types of cases did you handle?
ACJ, it was a variety of cases that I was that I needed to deal with. It is perhaps just to give you some contextual background. When I started as a budding attorney, I was barely 22 years old. Mm-hmm. So I entered into, in other words, I jumped into the deep end. And I was just really hoping for the best. And so when I started, we started off very small, and I was literally prepared to do anything. So it was small beginnings, dealing mostly with people who were impecunious at the time. I really have a heart for the underprivileged, and so my niche client initially were those that were in dire need. Most of those clients I would have referred for legal aid assistance. And out of those matters would emanate a huge array of matters, ranging from criminal law to civil litigation to divorces and related matters. And then slowly my practice grew. It took a bit of time, but I was very patient. It grew to extend to a broader client base, a corporate base. I eventually got the Ferreira legal contract and attended to matters that then exposed me to labor law, not much, but labor law, contracts, leases, in other words, every and any type of litigation, damages, delictual claims, intellectual property law, material work.
Did you get commercial law as well?
Sorry?
Did you have commercial law as well?
Yes. As I say, I was then fortunate at some point to work for, do matters for Maynard Mall. and that was one of my biggest client bases. And so a lot of matters that emanated from them being managing agents of tenants and those types of disputes did cross my threshold. And so it was something that I grabbed hold of almost everything that came my way, because it was literally survival. You must understand that being not only a young female practitioner, but also a Black practitioner those years back, I was feeding off what I termed the scraps, because most of the larger clients were going to the bigger firms. But I had the tenacity and endurance until I was called, I believe, to the magistracy in 2002, ACJ.
So you have been working as a magistrate since 2002, is that correct?
That is correct,
You
ACJ.
simply have been at different levels of
I have at different
magistrates.
levels, that is
Yes.
correct.
Now, how many of those years did you spend in the district court?
Up until 2013, ACJ, I was in the district court. I was elevated to a senior position in an acting position around about 2011, and then a permanent senior position in 2013, and then on the regional court level intermittently, and then ever since 2016.
Now, when as a district court magistrate, did your work include adjudicating civil cases?
Initially, ACJ, I was tasked with criminal work, and when the need arose, I availed myself, but I never removed myself from doing civil work. I was always willing to assist until just prior to my acting appointment, I became more and more invested in the civil work, and then I did a lot more civil cases. And when I was elevated to the senior position at Wynberg Court in an acting position, I was in charge of the private law section. And so I was then immersed completely into civil work from then on going forward.
When would you say that was when you started being involved in civil work quite a lot, just as you say?
I would say any time from around 2010, 2011, then of course actively in 2013 upward. But as I say, intermittently, ACJ, prior to that, I was also doing matters as and when the need arose. So I was never really out of it, but when I was completely immersed would have been roughly at about 2010, 2011 going forward.
Yes, and in terms of civil cases, are you able to share with the commissioners what branches of law in civil work you encountered in adjudicating civil matters in the magistrates' court?
I can perhaps give you an overview of where I'm currently at, and maybe work backward from there, because at the moment, if you will allow me, ACJ.
Yeah, that is okay.
Thank you. I'm currently the coordinator of the civil component at the court that I serve at. So that entails that I not only manage the courts, but I run those courts effectively. And so every person in that division is allocated duties on the trial role, on the default judgment, motion court role, and the divorce role. And those roles will deal with a number of civil matters, opposed, unopposed civil applications, default judgments that would deal with bank-related foreclosures and contractual disputes and the like. In the divorce court, opposed, unopposed divorce matters, your Rule 58 in the regional court, but Rule 43 is in the High Court, all of those applications. So ACJ, I would say everything and anything that is civil related. It also bears mentioning, if I may, that in the court that I serve, we also have quite a number of matters that are of a serious nature and of a high standard, I would submit humbly, because often we would have senior counsel being briefed in matters because of the complexities of concepts that we have to deal with. So yes, and in addition to that, pre-trial matters, there's a whole range, ACJ, unlawful arrest and detentions, it's too many to name, but I can, with a certain amount of assurance, say that I'm comfortable to deal with whatever matter I'm given and tasked to do.
And you have acted in the High Court. How many weeks or months altogether have you spent acting in the High Court?
I had an enormous privilege of being invited to act on the Western Cape High Court bench. And initially, by my calculation, I think it was the first term was for 8 weeks, the second term was for 10 weeks. My third term was a 9-week stint, and the last one was 11 weeks. By my calculation, it would total roughly about 38 weeks, and then I returned to do partly heard matters, and altogether it would probably give me another week. So maybe 39 weeks in total, ACJ.
And have you done civil trials and criminal trials in the High Court?
Yes, I did. I did, ACJ.
And the motion court?
Yes, I did.
And how did you find motion court in the High Court?
ACJ, when I stepped into that position as an acting judge, I embraced every challenge that was thrown at me. Yes, it was daunting, but preparedness is the key to, I believe, success. So I think that I was quite prepared because I think I had conditioned my mind before the time that it would be a lot of work. I spent a lot of hours in preparing so that I could be equipped to do and call the role. I did additional research, especially in matters where I wasn't perhaps au fait or comfortable. Maybe it was matters that we don't deal with on a regional court level. But I can say with a certain amount of assurance that I think I was able to handle it, and where I did not, where I wasn't comfortable, I would reach out to colleagues and ask them to kindly just check whether I was on the right track. But I wouldn't go to them to give me the answers. I would say, this is how I see it. Is it right? And all I can say is, ACJ, that I enjoyed every moment of it. I invested myself into it. I sacrificed because I knew that when I stepped into that role, I wanted to do it with excellence. And I believe that I tried my best to do so, ACJ.
Thank you. I will now hand over to the Judge President to put questions to you. Judge President.
Thank you very much, Chairperson. Mrs. Andrews, let's go straight to the point. You acted in the Western Cape, but left under a huge cloud. And for the benefit of this commission, I will explain. I allocated you a matter involving the Democratic Alliance and the ANC. I had no idea that the leader of the Democratic Alliance in Beaufort West and the Central Karoo is in fact your cousin. You did not return the file to me. You sat in the matter and ruled in favor of the DA. I took an unprecedented step to write to the Minister of Justice
and asked him to cancel your appointment. Would you like to explain yourself why you sat in a matter where your cousin is a high-ranking politician of the DA in the Western Cape and ruled in favor of the DA thereafter?
Thank you for the question, JP. I would like to say the following in response to that. First of all, when the matter was allocated to myself, it was allocated after I had returned a previous file to you, JP, because of a conflict of interest. When the matter was given, when I received that matter, the matter had litigants by name and not by party. I think if my memory serves, it was, there were 5 applicants by name, and then there were 8 respondents, the last of which was the Beaufort West municipality. This matter concerned an administrative action where the applicants in the matter had applied to set aside some irregularities. To the best of my recollection, it had to do with the appointment and unseating of the executive. The executive, as I can recall, consisted of the mayor and the mayor, the deputy mayor, and the speaker was.
I'm sorry, Ms. Andrews,
Yes.
I'm interrupting you. Please try and give brief answers.
I will.
The question is a simple one. Why
Yes.
did you sit in a matter involving the DA when you knew that your cousin was a high-ranking DA official? That's the question.
Thank you. First of all, ACJ, maybe just to cut to the point, is first, I did not know that this matter had any relevance or bearing to my cousin. I'll tell you why I say this is because he was not.
No. The question is, you would have known this matter is about, it has been brought by the DA, isn't it?
No, I did not, ACJ. I did
okay.
not. So that is the point I'm making. No, I
Okay.
did not. That is why I'm saying. The
Okay.
parties were named in the individual capacities. It wasn't overtly, in my view, a politically weighted matter. For me, I took
But from the papers, was it not
it was
clear
not
that it
clear.
was-
No, it wasn't clear. Maybe it was my naivety, I'll call it that, because I adjudicated the matter on the strength of the papers that were before me. So what happened was that there was this unseating, and there was a plethora of irregularities that emanated from the processes leading up to that. And all that they wanted was for the status quo to return. I'm aware that every step, that I'm aware that they had taken internal steps, but they did not. So the point.
Okay, hang on, Ms.
Yes.
Andrews. I'm sorry if I'm interrupting you.
Yes.
I just want to make sure that we use the time.
Certainly,
we have
I'm,
optimally.
yes.
Is your answer to the judge president that you sat in the matter because you were not aware that it involved the DA? Is that what you are saying?
Yes, I was not aware, and then I think it is important for me to say the following. I am estranged from my cousin and was not following his political career at all. I have no relationship with him, and I do believe that I did bring an impartial mind to bear on the adjudication of that matter. So I did not do that intentionally, ACJ. I certainly would not have done so had I known, and I understand that I should have recused myself. I would have done so had I known.
Did you know your cousin to be a high-ranking DA official?
ACJ, yes, I knew that he was in politics. I knew that he was aligned to the DA. But that doesn't necessarily mean that by implication I align myself to what he's doing.
Okay, Judge President.
Can I just follow it up, Chief Justice? And this is my last question.
Yes.
Mrs. Andrews, you must have known that he is a high-ranking member of the DA. It was all over the newspapers. He was hailed as the youngest politician in the DA, aged 29 years. You must have read that.
I don't dispute that, JP. What I'm saying, what I'd like just to reiterate that I definitely did not do it with the intention of bolstering his career or to rule in favor of him simply because he was my cousin. I adjudicated the matter on the strength of the papers, and I believe that I needed to do so because the Constitution enjoins me to do so in terms of Section 160, because there was certainly, there was no accountability and the steps were unprocedural.
But the Judge President suggests that prior to you hearing the matter, his association with the DA was all over in the newspapers. Why would you not have been aware of that?
ACJ, I know that it may sound like I am disconnected, but I definitely do not particularly follow the news, and especially when it comes to him. I am not in the Western Cape, so I'm located in KZN, so I wouldn't have really looked at things like that. So I'm not entirely sure whether I was meant to follow his career, because that wasn't, he isn't part of my circle. So I understand it was perhaps with the benefit of hindsight that I should have maybe have looked at it through a different lens. I might have had to, I did probably lack discernment, but that wasn't how I viewed it at the time. And I did apologize to the JP for my error, and I didn't at all, it was never my intention to do that. I think in my zeal, I may have just been overzealous, but certainly it wasn't my intention to be biased in any way at all. I understand the standards that is expected of me and when to recuse.
I'm now going to give, Judge President, you are done? Yes, thank you very much. Thank you. I'm going to give the opportunity to the Premier's delegate, Ms. Stewart. If you have got any questions for the candidate, this is your opportunity.
Thank you, Acting Chief Justice. Can you hear me?
Yes, we can hear you.
Thank you. I have two questions. Just following on from Judge President's question, was your cousin mentioned in the papers at all?
Not at all. Not at all. Not at all. I wouldn't have known. I read the papers. Those names did not reflect his name, and it did not tell me that it was ANC versus the DA at the time. In fact, one of the persons unseated happened to be an ANC executive member. So there wasn't, in my view, it was about making sure that the status quo was returned. I was astute to inquire from the parties present, and this does not reflect what was reported, that I wanted, and I had the heart of the community as my uppermost barometer. I had engaged the parties and asked them, would this have any effect on that community? And they gave me the absolute assurance that it would not. My focus wasn't on a political, I believe maybe I'm a casualty of a political rivalry, and I just maybe didn't see it coming.
Thanks, Ms. Andrews. I do have another question for you. I noticed in the comments that were provided that both the General Counsel for the Bar and the Law Society have suggested that you are inexperienced and perhaps need some more time on the bench. I'd like to know your comment on those comments from both the counsels grouping and the Law Society? Thank you.
Thank you for the question. I think that I believe I'm ready, although judicial education is an ongoing attribute that I think everybody should be open to do. If I can perhaps just consider the General Council of the Bar's comments. They do say that I need extra time, but it's important for the Commission to understand that I have produced 5 reported judgments in that very brief acting stint. I believe that I have the ability to contribute to the jurisprudence. I have the ability to develop the law. I have the passion to serve my country. And so I don't think for one moment that the comments were fair, because had that been, then perhaps some of my judgments may have been overturned, but none were up to date. So all of them remained intact regardless. I am open to correction. I think that is one of the attributes of a judge. I'm teachable and I'm willing to learn. I'm willing to grow. I'm willing to be mentored.
Thank you, Acting Chief Justice. If I can just indulge with one more question.
Yes, okay.
I note in your CV that you say your proportion of administrative and constitutional law is 5% and 5% respectively. The Western Cape government and every other organ of state spends a lot of time litigating in court in terms of administrative law. And I'd like to just ask you if you can explain to me your understanding of the difference between a review under PAJA and a review for legality, and where those two concepts derive from, how we've ended up in the space we have with respect to reviews. Thanks.
Thank you. First of all, PAJA deals with the right of everyone to an administrative action that is lawful, reasonable, and procedurally fair. Now, this is born out of the pre-1994 constitutional dispensation, where Parliament was supreme, and Parliament and the executive, its decision could not be reviewed. With the advent of with the advent of democracy, that has changed through our constitution, and more specifically, Section 175, where a court can now declare any law or conduct that is inconsistent with the Constitution to be invalid, and then make an appropriate order thereafter. In terms of a judicial review, those reviews come in different forms, and those reviews come to the courts to essentially in different ways. The first of which that comes to mind is when there was a misdirection. So a misdirection could be where, for example, the outcomes were over lenient, or perhaps it was too harsh. There would be a shockingly inappropriate outcome. The other reviews could also be based on an outcome that was not in accordance with the law. And so I have done those reviews. I understand what those sentiments entail. I understand that we can't deal with factual or interfere or lightly interfere with a decision if the lightly interfere with the factual decision unless there is a misdirection. And then there are various permutations that flow from there. So I hope that answers the question.
Thanks, Acting Chief Justice. I'm fine. I'm good.
Thank you very much. Commissioner Matolo Lepu.
Thank you, Acting Chief Justice. And good afternoon, ma'am.
Sorry, good afternoon.
Okay.
Good afternoon.
All right, I'm this side. I just wanted to find out from you, in your questionnaire, because I'm looking at some of the comments made about how you packaged your submission to this commission. For instance, the LSSA that you put in everything, but most of them were not even relevant to.
May I ask you to speak up a bit?
Okay. The LSSA says you packaged your submission with documents which were not relevant to the commission. But one of the things that I saw when I don't know if I'm just trying to look where they say do you belong to which organizations? You put in one of them is NADEL, and you put in one of them is Saula, but at the same time you're not a member. So I'm trying to understand why did you put it
I think
in?
it was, thank you, Madam Commissioner, thank you for the question. I think I just wanted full disclosure of my connection to any one of those organizations. Perhaps it was misplaced. I might have needed to put it elsewhere on my submissions, but I'm certainly not a member.
Thank you. Commissioner Schlemmer.
Thank you, ACJ. Ma'am, I would just like to ask of you, also related to your application and the voluminous nature of it, but also it's just concerning to me that you typed everything in uppercase. It's very difficult to read. I hope you don't type, well, you don't type your judgments like that.
I'm
event...
sorry, Commissioner Schlemmer. I don't know whether it's the technology or it's my ears. Can you repeat your question and try and speak up? Maybe it's my ears.
Sorry, ACJ.
Thank you.
What I said was I'm concerned with the candidate's application, apart from the voluminous nature of it, is also the fact that everything was typed in uppercase, which makes it very difficult to read. But apart from that, what I do find a concern is that it seems as if you, although you spent a lot of time obviously in putting it together, that you didn't read it very carefully. I mean, when it's asked whether you have any publications in law, you indicate your mini thesis or your mini dissertation as a publication, which is not considered a publication. And then when you're asked about whether some of your publications have been considered in judicial judgments, you refer to your judgments that were cited by other judgments. Can you please allay my fears that, well, I don't know whether you will be able to, because my impression is that you don't really read things carefully, and that you don't look at things with enough detail.
Thank you for the question. With the benefit of hindsight, first of all, in terms of the response and my typing in uppercase, I wasn't sure whether there was a prerequisite in terms of how the font should have been. I probably could have typed it in lowercase. I do type all my judgments, and I can assure you they're not in uppercase. Then, in terms of answering those questions, once again, with the benefit of hindsight, maybe I could have responded in a different way, but it certainly does not, it should not be a reflection on my lack of attention to detail, simply because as I say, I think I have a demonstrated performance, I think, in terms of the type of matters that I can deal with and the type of judgments I can produce. Most of my judgments that I have written, if not all, have been typed by myself. And I can assure you that I do then, I am meticulous, and in fact, I pride myself in being overly pedantic, I think just in my zeal to get my application in there. There may have been a few oversights, but that is I don't believe it's an impression on who I am and the type of quality work that I can produce.
May I follow up?
Yes, thank you.
Thank you, ACJ. There's just one other concern that I also have with your application, and that is a lack of judgment, it seems, as to what is relevant and what not. I mean, the application is more than 1,000 pages long, and most of the attachments has nothing to do with what the Commission is interested in. Specifically also when it relates to that question where your publications have been cited. You give us the whole report of the Law Commission, or the reviewed. Was it reviewed by someone? And there you refer to the Law Commission, and that was not a review, that was a reference. So
yes,
it is as if, one, that you didn't understand what was asked, and secondly, that you lack judgment.
Thank you for the question. I think it was an oversight. I referenced certain pages out of the law reform report, and it probably attached the entire report inadvertently. It wasn't the intention to make it prolix or overburden the reading of my application. I do apologize for that oversight. It was never intended to distract from the request and requirements.
Commissioner Dodo.
Yes, thank you very much. ACJ, good afternoon, Madam.
Good afternoon, Mr. Commissioner.
I've listened to you throughout the interview. You've apologized about 4 times, and in most instances, you indicate that, sorry about that, it was a foresight. Now, my question is, do you think that you are fit and proper to be appointed as a judge at this stage? And why, if you think that you are fit and proper?
Thank you for the question. I believe that I do have the attributes to be a judge. There are many layers to becoming a judge. And in my view, those attributes also include your temperament. It includes your accountability. It includes diversity. It includes ability to do and perform and execute your functions. I think I have demonstrated that through various ways. I know that the application, after having been scrutinized, might have caused some concern, but I can assure you, if you look at the judgments that I've written and the work that I've produced, I have, over the period of the 38 weeks that I was serving on the High Court bench, delivered many written judgments in the region of 20 or more. In total, I've calculated, and I've gone through all of them quite meticulously, close unto about 60 written pieces of work that I have produced. I'm relentless. I work hard. I am invested. And regardless of those concerns that may have been highlighted, I think there are other things that could also be looked at in terms of determining whether or not I will be able to perform. And I believe I can and will. And I will give you that absolute assurance that whatever I am tasked to do will be done to the best of my ability.
Yes, just the last one, ACJ. I've looked at your profile, which is quite impressive, including your qualifications and what you have written, and the fact that some of your judgments have been reported. But at this stage, given what I see and what I hear, do you think that you are ready, no longer fit and proper? You are ready to ascend? Given these concerns and the anxiety that I have about what I've just painted to you, do you think that you are ready?
Commissioner Dodo, how different is that question from your earlier one?
It's okay. It's okay. It's okay.
Okay.
With humility.
It was a devil's advocate. It's okay.
Yeah, okay. Judge President Mlambo.
Thank you very much, Acting Chief Justice. Ms. Andrews, good afternoon.
Good afternoon, CJ.
No.
Oh, sorry, JP.
Yeah.
Freudian slip. It wasn't meant to be.
Ms. Andrews.
Yes, JP.
I just want to follow up on the question the JP raised with you about the matter that he referred to. I just want to know whether you informed the parties before you had the matter or when you started the matter that you were related to one of the parties.
Thank you for the question, JP. First of all, the parties that were named wasn't related. There isn't on the papers. There is no name therein that says this is my cousin. None of the litigants was Dalen Mitchell. The parties were different named parties. The only reference that could have perhaps alerted me to a connection to a political undertone would have been the 8th respondent as the Beaufort West municipality. But I didn't even know that that was his constituency at the time. So I believe I was naive. Perhaps maybe I should have looked at it more carefully, but nothing on the paper suggested that this matter is something that I should have dealt with in a different way. The parties, before the matter commenced, I remember coming into chambers to greet. They came in very late. We were pressed for time. They'd barely come in. I asked them were they ready to proceed.
Ms. Andrews, can I just stop
yes.
you there? I just wanted a simple answer.
Sorry.
Are you saying is it your cousin?
That's right.
Was not named?
Not named on the papers,
Right.
JP, at all.
But his counsel was named.
Well, I later learned that was his counsel. I wasn't even aware at the time that was part of his counsel. I believed that his counsel was in Tilburg, and I stopped following what he was doing. I really had no idea.
Okay. Had you known beforehand when the matters allocated to you, can you tell us what a responsible judicial officer would have done?
A responsible judicial officer, JP, would have recused him or herself. I do understand what the requirements are and what threshold needs to be met, the double reasonable test set out in the seminal judgment of SAFU, and I can assure the commissioners here that I did bring an impartial mind to bear.
My last question, Acting Chief Justice, how do you approach, as a judge, a situation where you have irreconcilable versions in action proceedings?
Thank you for the question, JP. This would be where the Plascon Evans rule would be applied, and it serves as a guideline to determine which party's version should prevail without the need to refer matter to oral evidence. So you would basically be able to deal with the matter, the arguments on the papers. But there is a proviso.
I said action proceedings.
Oh, the action proceedings. Yes. Oh, sorry, the action proceedings, when there are irreconcilable differences.
Versions, yeah.
Versions. In a matter, thank you for that. I just needed to recollect my thoughts. In some instances, you may have to grant absolution where you can't make a decision.
Thank you very much, Acting Chief Justice.
Thank you. What is the misdirection, Ms. Andrews, in the context of a judgment?
A misdirection, ACJ, would be where it has to be, first of all, it has to be a material misdirection that is startlingly or disturbingly or shockingly inappropriate, where the court may have misdirected in terms of a decision or coming to a decision. It could have been on a jurisdictional perspective, it could have been on a point of bias, and various other considerations, ACJ.
You are not helping me, Ms. Andrews.
Okay.
If I ask you what a misdirection is, and you say a misdirection is where you have misdirected yourself.
No. Where you've erred, where somebody has made an error by not applying the correct legal principles, or have maybe dealt with the matter and applied the wrong law or the wrong legal principles in a certain circumstances. So it could range, as I say, it could be a misdirection on jurisdiction or just a wrong decision.
Commissioner Jesse.
Actually, good afternoon.
Yes.
No, I'm following up from the questions by Judge President Mlambo.
Yes.
Your answer to his question, which is, in situation where there are irreconcilable versions in an action, your answer is that you must grant an absolution.
I said you could grant an absolution.
No, that's not a question what
Yes.
could, but is what do you do? So it's either a question is that you grant an absolution or you give us an answer of what you must do.
The parties make out their matter in their pleadings. Their pleadings must speak to, and it needs to be backed up with the evidence. And if the pleadings and the evidence do not meet, then...
You must, I'm sure you want to, we don't want
Yes.
to be detailed on this. The question is simple. Evidence has been given, but the versions are irreconcilable. These are mutually
Indestructible versions.
The question is, what do you do? Your answer is you grant absolution. That's what I want to follow up. Can I?
Yes. No, you don't always grant it. You can also just...
But what do you do?
You can dismiss the action.
Just because this version, the plaintiff saying, I gave you money, this one saying, you never gave me money. So your next step is to dismiss that action.
It doesn't always have to be that either. It depends. It's a very vague and broad question.
What is vague? This is straightforward. Plaintiff has given a version as a plaintiff, as a witness. Defendant gives a version. You are a judge, you must decide this matter.
You decided on a balance of probabilities.
How do you do that?
You weigh up the evidence and you see which version is more probable.
My point, just at the last point, is I mean, when you give your answer, I just have to understand. Have you presided over a trial?
Yes, I have.
But you don't know the basic rule of dealing with evidence in a trial. Thank you.
Just a follow-up.
Thank you.
Just a follow-up.
One sec. Do you want to respond to that last part, Ms. Andrews, or not?
ACJ, I think it's just the nerves. I have dealt with many, many matters, and I think, in fairness, I would certainly consider those the matter before me. I will consider the legal principles. It goes just beyond just a very clear-cut answer in my view. It really depends, and for me, I would do the research and then come up with a just resolution in the end.
Okay, I'll take Commissioner Madonsela's question, and then I'll go to the commissioners on the virtual platform, and then we'll not take further questions from here. Okay, Commissioner Madonsela.
Thank you, Acting Chief Justice, and good evening. Good afternoon, ma'am.
Good afternoon, Commissioner.
Can I, just to assist you, can I ask you to go to Book 1 and go to page 191. Paragraph 64. Can you see that paragraph?
Yes.
Why are you smiling?
Because I remember. I think it was the nerves, and I thank you for that. I think that the judgment speaks of my ability to be able to discern and to give the correct answer, because the outcome was, I believe, correct. I do appreciate the assistance.
Thank you.
Thank you. Commissioners on the virtual platform, any questions?
Yes, please, Acting Chief Justice, it's Glynis.
Yes, please go ahead.
Thank you. Good afternoon, ma'am.
Good afternoon.
Could you tell me, in your view, what you think the most important attribute of a judge is?
The most important attributes of a judge, in my view, would be judicial integrity. Judicial integrity would...
That's fine. That's the answer. Thank you.
Thank you. Thank you.
Thank you, Acting Chief Justice.
Thank you. Nothing further from the virtual platform. I think we have...
Thank you.
Thank you. We've come to the end of this interview. Thank you once again, Ms. Andrews, for availing yourself, but you are now excused.
Thank you, Acting CJ, and thank you to the commissioners.
Thank you. Next candidate. Good afternoon, Mr. Lekuleni.
Good afternoon, ACJ.
How are you this afternoon?
I think I'm good.
Good, good.
Thank you.
Welcome to this session of the Commission's interviews.
Yes.
And thank you for making yourself available for consideration for appointment as a judge to the Western Cape Division of the High Court.
Thank you, Acting Chief Justice.
I see that you have quite a string of degrees. You've got a BProc degree, LLB, 2 LLMs, and an LLD. And I understand, I can see you are doing a third LLM.
That's correct, ACJ.
Yes. And you obtained your BProc in June 1992.
That's correct.
And then you obtained your LLM before you obtained your LLB.
That's correct.
You obtained your LLM in September 2004.
That's correct, ACJ.
And your LLB in September 2008.
That's correct, ACJ.
And your LLD in September 2012.
That's correct, ACJ.
And the second LLM in April 2016.
That's correct, ACJ.
Yes. But you also served your articles from 1992 to 1994, is that right?
That's correct, in Polokwane, Peters, which was then known as Petersburg.
Yes. And then after that, you were a legal advisor to Ikageng Legal Course. Is that right?
That's correct. After completing my articles, I was still writing the board examination, and I went to work for Ikageng Legal Course assistant as a senior legal advisor.
Yes. And then you worked as a public prosecutor?
That's correct, in Bushbuck Ridge,
yes.
where I come from.
And you practiced as an attorney for James Lekuleni Attorneys from February 1999 to 2004, is that right?
That's correct, until the 31st of October 2004.
Yes.
Yes.
During your time when you practiced during that period, what types of cases did you handle in your practice in terms of different branches of law?
Yes, thank you, ACJ. I was privileged to do different types of cases. I did civil cases, I did criminal cases, and I also had an opportunity of doing labor matters. And as you'll have seen, before I became an attorney, I went to work for LegalWise as well. And after working for LegalWise, I left and I went open my practice, and they gave me a lot of instructions. In fact, I was their own attorney, if I remember correctly. I was the only person who was doing their cases in Polokwane. Now they had a variety of clientele, and I had to do all their cases, and that exposed me to different fields of law: civil, criminal, divorce matters, and labor law.
Okay. And during that time, did you appear in court and did your own trials yourself and argued matters by yourself?
That's correct. In fact, I was almost in court every day. I appeared in the district court, the regional court, and of course in the high court I briefed counsel, but I also appeared in the labor court.
Yeah.
Yes.
And then you served for some time as a reserve force military judge.
That's correct. When I was an attorney, I went to study military law at Tabatswana School of Military Justice, and I got an opportunity to act as a military judge in Limpopo, Nelspruit. Yes, that's correct.
And you were appointed an additional magistrate in November 2004, and that went on until sometime in 2013.
That's correct. In fact, yes, I was appointed district court magistrate in Cape Town on the 1st of November 2004, and I then acted in the regional court since 2010, and up until I was permanently appointed in 2013.
And you acted as a regional magistrate from July 2010 to October 2013. And then you were appointed as a regional magistrate from November 2013 to date.
That's correct. When the regional court was given civil jurisdiction in 2010, the then regional court president called me because of my civil court experience to the regional court, and up until that I was appointed in November 2013, yes.
And how much civil work have you done as a regional magistrate?
Yeah, as a regional magistrate, I did various types of cases. I did contractual dispute, I did delict, I did default judgments. I did various cases. I must say that I was not even confined in one place. As I've indicated, I was called to the regional court to implement the civil jurisdiction. In fact, I did cases all over the Western Cape. All over the Western Cape. I was not only confined to Cape Town, and that gave me a very good exposure to civil matters.
Yes. And you have acted as a judge in the Western Cape Division.
That's correct. In fact, I've acted consecutively from October last year, the last term of 2020, and I'm still acting even this year, even in this term.
That must have been given you quite a lot of experience, because it means that you are about to finish the fourth term acting.
That's correct, ACJ. It gave me a very wealth of experience and a wealth of knowledge to act in the High Court. As you'll understand that the jurisdiction of the Magistrates Court is a bit limited. Some of the cases you don't get exposed to, you don't get to do them because the jurisdiction of the Magistrates Court is a bit limited. But in the High Court, I got to be exposed to different types of cases. I had happened to do constitutional matters. At some point, I was also exposed to administrative law matters, which I never had an opportunity to deal with them in the Magistrates Court. And it really, really gave me a very good exposure to various fields of the law.
Okay. Judge President.
Thank you very much, Acting Chief Justice. Dr. Lekuleni, you have acted in the Western Cape for a while.
That's correct.
Let me ask you one question. What is your understanding of the rule of law?
Yes, JP, the rule of law, in my view, it indicates that the law is supreme, the law is sovereign, and there's no one who's above the law. In fact, the rule of law is one of the founding values of our Constitution. When you look at Section 1E of the Constitution, it makes it very clear that the Republic is founded on the supremacy of the Constitution and the rule of law. In my view, the rule of law entails that the law, it's sovereign, and we are all equal before the law. And it also echoes the provisions of Section 9(1) of our Constitution, which provides that everyone is equal before the law and that we all enjoy the right to full benefit and protection of the law.
Just one last question, CJ. One of the problems that we have in the High Court, and you should know this as a judicial officer and someone who has acted as a head of court, is forum shopping.
Yes.
Lawyers, especially white male advocates, run away from certain judges, especially those judges who are not white.
Yes.
How can we deal with this in a real effective manner, and how can we eliminate it?
Yeah, I think it can only be dealt with in the allocation of the cases. In my view, it's very important that the attorneys or advocate need not know who's going to be allocated a case on a specific date. as the head of court, let's say for instance, me as the head of court acting in the regional court, I'd ensure that if let's say for instance, I have to allocate cases, the members of, let's say the people who will be appearing before a particular magistrate, they will not know who the magistrate is going to be, who's going to take that dealing with the matter. And I think the same thing should happen with, like we do in the High Court, that advocates don't know who is going to be presiding in the matter, because if they know who's going to be presiding in the matter, if it's me, they will say that, no, look, the matter is settled, or they will say that, no, look, we're negotiating settlement. But if it's another person, look, if it's maybe a person belonging to the other race, then the matter proceeds. Now, I think it's a question of allocation, that in the allocation of cases, it should not be known as to who's going to be presiding, in order to, we can avoid that forum shopping, in my view.
Thank you. I will now give the opportunity to Ms. Stewart. If you have questions for the candidate, this is the opportunity.
Thank you, Acting Chief Justice. Dr. Lekuleni, I have two questions for you. One of them is personal and the other one is a general legal question.
Yes.
Your CV says you went and did a stint as a military judge, and I'm just interested what caused you to do that. Quite an unusual step. Okay, how did you find it and why did you do it?
Look, I was still practicing as an attorney when I went to be a military judge. I wanted to exercise judicial discretions. And unfortunately, I never had the opportunity of exercising judicial discretions. And when I saw that there was a post of a military judge in the army, a reserve force post for a military judge, I thought that this was an opportunity that I should grab with both hands, and I went to study military law. And over and above, I'm a committed citizen of the country who also wants to ensure that there is discipline also in the army. As you know, that in terms of Section 200 of the Constitution, we need to have an army that is very much disciplined, so that in times of war, they can defend us. That's one of the reasons why I also went to study military law and became a military judge.
Thank you. And my second question is, it relates to the distinction between a review under PAJA and a review under the principle of legality. I see that you have done a review. In your CV, you say you've done a review under Section 6 of PAJA.
Yes.
Can you explain for me how you understand the difference between a review under PAJA and somebody who brings a review under the principle of legality, and why we have that distinction?
I'll try to explain that also based on case law. Section 6 or PAJA, when you look at it, it's giving effect to a right in the Bill of Rights, which is Section 33 of our Constitution. Whilst a review in terms of the principles of legality, it's based on the common law. Now, the Constitutional Court has made it very clear that an organ of state, let me put it this way, the Constitutional Court has made it very clear that Section 33, a review in terms of Section 6 of PAJA, which is giving effect to Section 33 of our Constitution, it's applicable to private individuals and not to organs of state where they're applying for review of a decision of their own decisions, because they are the bearers of obligations. Now, if they want to make an application for a review of their own decisions, they have to do so in terms of the principle of legality, which is based on the common law. Whilst a review in terms of Section 6, it's statutory. It's based on the statute. And I was just referring to you to the case of CETA versus Mgijima Holdings. That's where that principle was raised. I don't know whether I answered your question.
Acting Chief Justice, that's perfect. I don't have any more questions. Thank you.
Thank you.
Thank you very much. Commissioner Moiman.
Thank you, Acting Chief Justice. Good afternoon.
Good afternoon, Commissioner.
Just educate me on one of the areas that has been on the table of Parliament on two issues. whether to have a ballot, whether to have an open ballot, is that a motion or a secret ballot? Can you just educate me in the latest case that you had?
Yeah, look, it was an ATM matter, I think you must have seen. I must say that it was a very complicated matter, and it raised the constitutional issues because it dealt with Section 102 and Section 167 4E of the Constitution. I don't know, do you want me to just to explain to you about the secret ballot or not? Maybe let me put it this way. In that case, briefly, the Speaker of Parliament made a decision that the secret ballot, which was tabled, rather no, the motion of no confidence, which was tabled by ATM, was going to be had by open ballot. And ATM was not happy with that. They brought an application to review that decision, saying that the Speaker was wrong in his decision to decide that the motion of no confidence against the President should be held by open ballot, especially taking into account the decision of the Constitutional Court in the UDM matter. But what happened in that case was that the jurisdiction of the High Court was impugned, in a sense that they said that the High Court does not have jurisdiction to deal with matters arising from Section 102 because in terms of Section 167 4E, it was a matter that falls exclusively within the jurisdiction of the Constitutional Court. And I must say that when I read case law and I realized that the Constitutional Court left that question very much open in almost 3 cases, whether the High Court has jurisdiction to deal with a motion of no confidence in terms of Section 102 of the Constitution. But after considering the matter, I realized that I found that the High Court does have jurisdiction to deal with a motion of no confidence against the President. In this case, in the sense that, because the argument was that when the Speaker decided to order that the motion of no confidence against the President should be by open ballot, it was Parliament having failed to fulfill a constitutional obligation, triggering Section 167 4E, the exclusive jurisdiction of the Constitutional Court. And I said, no, that cannot be. Because it cannot be that when a Speaker of Parliament decides and say, or rather makes an irregular decision, then we can say that Parliament has failed to fulfill a constitutional obligation. It was on those bases that I said that the Speaker exercised his right. In any event, in terms of Section 59 of our Constitution, the business of Parliament should be open. And the Speaker was right in a decision. Maybe something that I can also indicate, which I think was very much of interest to me, was there was a question as to whether does a person who, let's say a party that presents a motion of no confidence in Parliament, does it bear the honors to prove to the Speaker that it should be, the procedure should be secret, by secret ballot, or it should be by open ballot? And I found that, no, look, as I said, there is no honors. There is no honors as far as that is concerned. The only question.
Thank you, Advocate. Thank you, Acting Chief Justice.
Thank you.
Thank you.
Commissioner Amatolo Lepu.
Thank you, Acting Chief Justice. Good afternoon, Dr. Kennedy.
Good afternoon, Commissioner.
Mine is just a simple one. You seem to be very energetic, very. But I just wanted to find out from you. You became you were practicing on your own account from 1999 to 2004. At the same time, you ventured into that military judge issue. But I just wanted to know what made you leave private practice before to go to the magistracy?
What made me?
What made you leave private practice?
Yeah, look, as I said, I think I tried to explain that from the beginning. It was my desire to exercise judicial discretions, and I cannot do so as an attorney. That is why when I was practicing as an attorney, I went to study military law because I saw a position of a military judge, and I applied and I was taken. And I then was appointed as a reserve force military judge. And as a reserve force military judge, I had an opportunity of exercising my judicial discretions without fear, favor, or prejudice as entrenched in Section 165 of our Constitution.
What do you mean you you wanted to exercise judicial discretion?
Oh. Yeah, judicial.
Yeah. Let the candidate explain himself, please.
Yeah, well, I think they've already said it. The judicial power to decide, to
Oh,
decide
okay.
the case, is a judicial discretion. Yes.
Okay. No. There's nothing wrong with wanting to exercise judicial power. There's nothing wrong.
Yeah, it's a bit too strong.
It looks like there are no questions. Let me check with the. Oh, there are still. Oh, yes. Judge President Labo.
Thank you very much, Acting Chief Justice Doc. Good afternoon.
Good afternoon, JP.
The Magistrate Lukuleni in Mpumalanga, are you related to him?
Magistrate? No, I don't think I maybe with our fathers, but I'm not aware. I don't know him. Thank you.
Okay. When you were a reserve force military judge, did you have a rank?
Yes.
What was your rank?
I was a lieutenant colonel.
Oh, okay.
I was a lieutenant colonel.
Okay.
JP.
That means we have to salute each other.
Yeah, you have to salute.
Thank you very much, Acting Chief Justice.
Thank you. Thank you.
Since you're already a judge, why do you want to be another judge?
I want to exercise judicial discretion at another level.
Thank you.
Commissioners on the. Commissioner Schlemmer. Oh, I wrote you down.
Thank you, ACJ. Dr. Likuleni, I would just like to know from you, what is your judicial philosophy when you exercise your judicial discretion?
My judicial philosophy is fairness and justice, which derives its authority from the Constitution. I believe that we need to start from the Constitution. If you are sitting in a criminal court, you have to start from the Constitution because we are dealing with Section 35(3) of the Constitution. When you are sitting in a civil matter, you have to still start from the Constitution because we are dealing with Section 34. And I believe that when you are interpreting any legislation, you have to look at the provisions of Section 39(2). When you are dealing with the interpretation of any Bill of Rights, you have to look at Section 39(1). Now, it is on those bases I say that my judicial philosophy is constitutionally inclined. Thank you.
Thank you. Actually, I think Commissioner Schlemmer is right. You are Dr. Lukene. Yeah, you have earned it. You have got your doctorate.
Yes, no, thank you. Thank you, ACJ.
Now, during your acting stints in the High Court, did you do criminal trials and civil trials? Did you do both of those?
Yes, and I'm very much thankful to the JP of the Western Cape because he exposed me to criminal trials, he exposed me to civil trials. In fact, I can also indicate that I'm faced with a matter which involves 20 accused persons who are facing 145 charges. In fact, I'm busy with that matter currently, and I was informed that almost 250 witnesses are going to testify that, but I expect that maybe by the end of term, I will have made inroads in that matter. I've dealt with also with the civil trials as well, and I've written judgments in civil trials as well.
And have you also done motion courts?
Yes, I've sit in motion court. In fact, the practice in the Western Cape is that at least in a week, the whole week in a term, you have to sit in the motion court.
Yeah.
I've sat in the motion court almost all the terms that I sat in the High Court.
Yes.
Yes.
Thank you. Commissioner Pofu?
Yes. Good evening, Doctor, Professor.
No, Mr. Lukuleni suits me fine too.
Modesty will not get you. And anyway, I want to ask you about that. Do I understand that you have an LLD already?
Yes, I have an LLD.
And you also have a PhD? Or are you doing a second doctorate?
No, I did an LLD and then I'm doing a master's in international criminal law.
Oh, I see.
Yes.
Okay.
He's doing a third LLM.
Yeah. And towards another doctorate. Okay, thank you. All right. No. Look, I think I will not ask you a content question because it's clear. So I just wanted to ask you if there's, particularly with the division that you are applying to,
Yes.
there are some serious challenges of transformation, probably more than anywhere in the country. Is there a particular reason why you applied in the Western Cape? And linked to that question, what has been your experience acting in that court around the issues that I've just raised?
Yeah, look, the reason I applied for the Western Cape, I've been in the Western Cape since 2004 when I was appointed as a magistrate. I have a house, my family are there, my children are there attending university there. And it is for those reasons that I applied in the Western Cape. Yes, I agree with you that there are dynamics in the Western Cape, and there are those issues that I think we need to deal with them head on, and we need not sugarcoat them. Yes, we need to attend to that. Yes, I think I choose to be brief, and I don't know what I answer your question.
No, it's fine. It's understandable.
Yes, no, thank you.
I would answer like that if I was from the Western Cape.
Yeah. Yes, thank you.
Dr. Lekuleni.
Yes, thank you.
What is your understanding of a misdirection by a lower court when you are sitting on appeal?
Yeah, a misdirection of the lower court may happen where the lower court made a finding on the facts which conflict which was presented, made an incorrect finding on the facts that were presented, or made a finding on an incorrect application of the law. For instance, where there are substantial and compelling circumstances in a murder case, and you find that the court did not depart from the prescribed minimum sentence. In that event, that's a misdirection. In other words, or making a finding which is not supported by the facts. Yes.
Thank you. I think we have come to the end of this interview. Thank you very much. I already gave the commissioners on the virtual platform, I think. Thank you very much for making yourself available, Dr. Lekuleni. We appreciate it. You are now excused.
Thank you very much, ACJ, and thank you very much to the commissioners. Thank you.
Next candidate. Good afternoon, Ms. Nziweni.
Good afternoon, Acting Chief Justice.
How are you this afternoon?
I think I'm well.
under the circumstances.
Okay, all right. And which ones are the circumstances? Is it being before us?
Yes, indeed.
Okay. Welcome to this session of the interviews of the Commission. And thank you for availing yourself for consideration for appointment as a judge of the Western Cape Division of the High Court. You hold a BPROC and an LLB, is that correct?
Indeed so, Acting Chief Justice.
Please bring your mic closer to you so everybody will hear you. Okay. And you got both degrees from the University of Fort Hare.
Indeed.
You got your BPROC in 1997 and your LLB in 1999.
That's correct.
Yes. And you started your working career as a maintenance clerk in the Department of Justice, that is in the courts, is that right?
Yes, and that was a vocational work which I did.
I'm sorry?
It was a vocational work which I did.
Oh, okay. And then you were a commercial law tutor for 6 months at Fort Hare.
Indeed, that's correct.
And then you became a public prosecutor in July 1999.
Yes.
And in 2001, July, you became a junior state advocate up to April 2003.
Indeed, at Grahamstown DPP's office.
Yes. And then you were appointed as a district court magistrate in July 2003.
In Somerset West, yes.
And you worked as a district court magistrate from July 2003 to October 2013.
Yes.
And then in January 2011, you were given an opportunity to act as a regional court magistrate up to March 2012.
Yes, indeed.
And then in 2013, you were appointed as a regional court magistrate.
Correct.
And that's the position you continue to hold.
Indeed.
Okay. Tell me, have you done civil cases as a magistrate?
Quite a lot.
Quite a lot.
Indeed.
And that started from when you became a district court magistrate?
No, in 2009.
In 2009.
Correct.
And in 2009, you were were you no longer a district court magistrate at that time?
I was still a district court magistrate.
Yes. So you didn't do civil court matters from the commencement of your appointment as a district court magistrate,
No.
but you started doing them in 2009.
Correct.
And when you became a regional court magistrate, did you continue to do civil matters as well?
I was actually appointed at a seat which did not do civil matters. I then approached the regional court president and I asked him if he can afford me the opportunity to continue with civil work.
Yes. Let me just double check. Is everybody able to hear her well? Okay.
Oh.
Yeah, there is something wrong with my ears. Okay, all right. So, and then the regional court president allowed you to do them?
Indeed, because of my reputation in civil.
Yes. Now, so that means that you have been doing civil cases as a district court magistrate and as a regional court magistrate over a period of about, what, 11 years, 12 years?
Pretty much.
Yes.
I actually juggled two courts.
Yeah.
I was doing an exclusively criminal work court simultaneously with the civil court.
Okay. And what branches of law would the civil cases that you have been doing in the magistrates court and regional court fall under?
Various branches. I did delict, contract. I was fortunate to be at a court which was very busy, Somerset West. If I may say that the litigants there, they are very litigious. They like to litigate. So I was exposed to various branches of civil work.
Yes.
Yeah, it's quite a busy court.
Yes. Do you enjoy civil work more than criminal work, or not really?
It's actually my passion, acting Chief Justice.
Yes. And did the Magistrates Court and the Regional Court have motion court as well?
Yes, quite a lot.
And you were involved in that as well?
Indeed.
Okay. Now, in paragraph 8 of the questionnaire, you were asked to furnish particulars of membership of a political party, past and present. You said none.
Yes, that's
correct. You confirmed that.
Indeed.
And you, in paragraph 9, you were asked to furnish particulars of community and other organizations of which you are or have been a member in the past 10 years. You said none.
That's correct.
Yes. Now, have you had the chance to act in the High Court?
I was fortunate enough to be invited by the Judge President at the beginning of this year.
Yes.
And I'm still there.
And so far, have you done both civil and criminal trials at the High Court?
I did only one criminal trial, and fortunately, the bulk of the work which I did was civil work.
Yes. And you have done motion court as well?
Yes, quite a lot.
Yes. Judge President?
Pass, CJ. Nothing at this stage. Thank you very much.
Okay, thank you. Ms. Stewart, if you have questions for the candidate, I now give you an opportunity to put questions to the candidate.
Thank you, Acting Chief Justice. Can I ask two questions, please? The first is pertaining to your judgment of the Epstein judgment, which was, as I understand it, an urgent interdict.
Yes.
I'm just trying to understand, in paragraph 25, you deal with the apprehension of irreparable harm, and you find that if the interdict to stop the building work is not given, the applicants will suffer irreparable harm.
Indeed.
And on paragraph 26, you then state that the construction is not at an infancy stage, and the applicants have made an application to not oppose the occupancy certificate, which implies that the building work was finished at the time that you gave the judgment. So I'm just trying to understand why an interdict would be granted when building work was finished, or I'm not understanding it correctly.
It was not quite finished. There were aspects of the building work which were still had to be done.
And that was sufficient to still consider ongoing irreparable harm?
Indeed so, indeed so. Because the courts are not really inclined to grant orders, because there was also part B of the matter which the court still had to decide on.
Which was a review, is that correct?
Yes, yes, indeed.
Okay, thank you. And then turning to the question of review, as you know, most government matters in courts are often reviews where decisions of the organ of state are taken on review. And in that regard, there's two different ways which reviews can be brought. One is under PAJA, the Promotion of Administrative Justice Act, and the other is under the principle of legality. Can you just tell me your understanding of the difference between those two types of review and how it came about?
PAJA is statutory, yes, and then the other one is in terms of the law. It can be brought, for instance, a review can be brought from the Magistrates Court to the High Court.
And a review under the principle of legality, in other words, not a judicial review, but a review for administrative action, but not under PAJA. Have you any experience of those?
Not at all.
Thanks, Acting Chief Justice.
Thank you. I'm told that your voice is Soft is too low.
Oh, I'm sorry for
you
that.
are asked to speak up, so at least I'm not the only one.
Okay.
I
No,
understand.
I'm sorry about that.
Yes. Okay, all right. Thank you. Commissioners, Judge President Lambo.
Good afternoon, Ms. Nziweni.
Good afternoon, Judge President.
It's just as a basic question I want to ask you. There is a circuit of the division in the Western Cape. Am I correct?
Indeed.
Yeah, it does both civil and criminal.
Indeed.
So, you're sitting in Cape Town, you're approached by, one of your matters is from a financial institution that seeks to foreclose on a property located in an area under the circuit.
Mm-hmm.
And the value of the claim is 100,000 rands. And the homeowner is unrepresented.
Mm-hmm.
How would you deal with that matter?
Currently, there is a decision from the Supreme Court of Appeal, which has decided that a high court cannot refuse to hear that particular matter because the high court enjoys concurrent jurisdiction with the magistrate's court. So I'm now bound by the high court, rather by the Supreme Court of Appeal decision.
Sorry, you meant inherent jurisdiction.
Concurrent jurisdiction, because now the High Court enjoys jurisdiction and the Magistrates Court also enjoys jurisdiction.
Now, what about the fact that the homeowner is unrepresented?
With inherent jurisdiction, I can step in and say it's going to be unfair for a person from George to come to Cape Town.
So you would send the matter to the Circuit Court?
Indeed.
Okay. Thank you, Acting Chief Justice.
Thank you. Shabangu, Commissioner Shabangu Ndawe.
Thank you, ACJ. Good evening, Mrs. Nziweni.
Good evening, Commissioner.
Mrs. Nziweni, the ACJ asked you about paragraph 9, in which you responded that your answer was none there. I don't know whether, can you share with the commission in what extent are you involved in assisting the community with regard to transformation? As we all know that this subject is one of the subjects that is very key, especially in the province that you are coming from.
Fortunately, I am a member of the Association for Regional Court Magistrates of Southern Africa, and I happen to be the secretary of that organization provincially. As such, we get involved in various matters which are of charity work. We do a lot of charity work. For instance, we've done a drive with the Boys Town in Cape Town. We also did some charity work with elderly people, so I am involved.
Thank you. Thank you, ACJ.
Thank you, Commissioner Mtolo Zlepu.
I'll pass. I wanted to.
Okay, all right. Commissioners on the
I thought you recognized me, Acting CJ. I'm not on the list.
I'm sorry.
Yes. Oh, okay.
You have the floor.
Yeah, thanks. Thank you very much, Acting
Commissioner
CJ.
Tlaba, yeah.
Yes, and good afternoon, Ms. Nziweni.
Good evening, Commissioner.
I just want to test you on your understanding of the character of our democracy. They say it is both participatory and representative, and on the basis of it, of which a few pieces of our legislation were overturned by the Constitutional Court. And can you elaborate on that? What's the meaning of it?
Participatory democracy.
Yes, the character of our democracy being representative and participatory. What does that mean in actual effect?
I won't venture an answer on that. I haven't done lots of constitutional matters. As such, I'm not quite aware of those concepts.
That's fair. Thank you so much.
Have you had the opportunity of dealing with a matter where you are asked to declare a piece of legislation unconstitutional and decide on appropriate relief?
No, not yet, Acting Chief Justice.
Yes. When you sit in criminal appeals and you are asked as a panel of a full bench, for example, to deal with, and you deal with an appeal against sentence, what room do you have to interfere with the sentence given by the court? Are you free to interfere if you think it was a wrong sentence, or what constraints are there?
I cannot interfere merely because I am of the view that it was wrong. I can only interfere if I'm of the view that it was harsh and inappropriate.
And can you share with the commissioners your understanding of the doctrine of separation of powers?
It's a very important doctrine in a constitutional democracy. What it means, it entails that the different spheres of the state cannot interfere with one another. For instance, the executive cannot interfere with the judiciary.
But where the Constitution allows that interference, then it would happen?
If the Constitution allows the interference. Of course, we live under the rule of law. And we know that the Constitution is supreme. If the Constitution says it can be done, then it can be done.
It can be done. And if it's legislation that allows it to happen, what would you say?
Then,
if Parliament passes legislation that allows that to happen, what would you say about that?
Then that particular legislation will be contrary to the values of the Constitution. So that piece of legislation cannot be sustained.
Yes. Any further questions? It looks like Commissioner Schlemmer.
Thank you, ACJ. Good evening, ma'am.
Good evening, Commissioner.
Could you just share your judicial philosophy with the Commission?
Mine is predicated upon the principle of justice. I happen to be a daughter of an interpreter. As such, I had the opportunity to be exposed to court hearings. And I was still very young. Then I would notice this particular person who's unrepresented. And then there and there, I told my father that I wanted to be the person who would represent that person. I believe firmly in justice, and I believe that justice is the vehicle to protect people particularly the most vulnerable people.
If I may, ACJ,
Uh-huh.
and how do you apply that principle of justice in a civil court?
You have to be fair to all the parties who are appearing before you. You have to dispense justice impartially. You have to listen to litigants.
Thank you.
ACJ, may I ask my question, please?
Yes, please go ahead, Commissioner Kane.
Thank you very much. Could you please just further the conversation you've just had with the few commissioners that have asked you about the application of those principles to the example that JP Malambo gave you? You ended up saying to him that you prefer the case in
Yes.
question where the financial institution was suing a debtor to the George Regional Court. What is the principle behind that?
Access to justice. It's a very important principle because the further you take the litigation from the litigant, essentially you are closing the doors of the court. So the principle for me, which is more important, is the principle of access to justice.
Thank you. Thank you, ACJ.
Thank you. I think we have come to the end of the interview. The commissioners who are on the virtual platform, I think I had given them a chance. I hope I'm not mistaken, apart from Commissioner Kane. Yes, we have come to the end of the interview. Thank you very much for availing yourself. You are now excused.
Thanks to you, Acting Chief Justice, and the commissioners.
Thank you. Next candidate. Okay, commissioners, let's start. Good afternoon, Mr. Tulare.
Good afternoon, ACJ and the commissioners.
How are you this afternoon?
I'm trying my best.
You're trying your best.
Thank you.
Okay, all right. Welcome to this session of the Commission's interviews, Mr. Tulare. And thank you for availing yourself for consideration for appointment as a judge of the Western Cape Division of the High Court. You hold 3 degrees, is that right?
That is correct, ACJ.
It's a B.Juris degree, it's a Bachelor of Law, and a Master of Laws. And you got all of them from UNISA?
That is correct, ACJ.
Yes. You got the B.Juris in 1996, you got the LLB in 1998, you got the LLM in 2002.
That is correct.
I see that you said the LLB is a Bachelor of Law. It didn't say it's a Bachelor of Laws. Is that because it's not the normal LLB?
It's a Bachelor of Laws.
Plural.
Yes, in the plural.
Yeah, because I think a Bachelor of Law would be a B.Juris.
That is correct.
Yes, okay. But you got your LLB within 2 years after your B.Juris. That was pretty fast, isn't it?
That is correct.
Wouldn't an LLB normally take longer if you are not full-time, or were you full-time?
No, I studied part-time throughout.
Yes. When had you started studying for the LLB? In 1997?
Immediately after my B.Juris, I commenced with my LLB. And immediately after my LLB, I proceeded with my LLM.
Sure, that was quite, because UNISA's LLB used to take quite some time for people who were not, who were working. So you did it quite quickly.
Thank you, ACG.
Yes, okay. Now you have been to this commission for interviews a few times, is that correct?
This is my third time, ACG.
This is, oh, okay. It's not many times, it's just at that time. Yeah, okay, no, that's fine. That's fine. Now, you started your working career as a general laborer at SA Breweries, is that right?
That is correct.
In 1989?
Yes.
In 1989. And you remained in that company up to 1991?
Yes.
And then in 1991, you were appointed as an interpreter in the Department of Justice?
That is correct.
And you continued in that position until 1996, when you decided to go and do articles, is that right?
I became a prosecutor from being an interpreter, ACJ, between 1996 and 1999, and then I went to serve articles in 1999.
Oh, you're in the questionnaire. You, after interpreter, you indicated that you were a candidate attorney from 1996 to 1999 at Dupree and Goes Incorporated.
If it reflects so, it must be a mistake, I have to say. But you'll see through the attachments that yes, I was a court interpreter, and then I became a public prosecutor, and I went to serve articles, and then I became a magistrate. That's the path of travel.
Oh, okay. And yeah, you didn't put the prosecutor here. You must have forgotten, but you say in the attachments, there is something that indicates.
Yes, attached to my application, the path of travel, I made sure that I make copies of the documentation that I have, supporting documents, ACJ.
Yes. And then you were appointed as a magistrate in 1999, is that right?
That is correct. I started acting in 1999. I was appointed permanently in 2000.
Oh, okay, yeah. Okay, well, here it reflects magistrate from 1999 to 2005.
Yes.
Yes. Okay, and then you were appointed as a senior magistrate from 2005, and you held that position until 2016.
That is correct.
And you appointed chief magistrate from 2016 to date.
Yes.
And in the different levels as a magistrate, were you exposed to civil work?
Yes.
Adjudication of civil cases?
That is correct. When I joined the magistracy, I was appointed as the magistrate for Johannesburg.
Yes.
Now the magistrates courts for Johannesburg has got what one may call specialist functional areas. When you work in the civil courts, you do exclusively civil litigation. And that's why I started.
Yes.
Subsequent to that, I also got involved with judicial training. I trained other magistrates in civil litigation. The commissioners should also recall that I also mentioned that when the Department of Justice took a decision in the project that they called Taking Justice to the People, converting courts in townships which dealt exclusively with criminal law to introduce civil and family, I went to establish those courts. In particular, Soweto, Davidton, and Mamelodi. I trained magistrates in civil and family and also recommended their appointments to the minister. And they are, as we speak, courts that do all services of a magistrate's court.
Now, in terms of branches of law, the civil work that you were exposed to as a magistrate would have included what branches of law?
Contract, delete, motion court, almost everything that a magistrate's court does, including disputes relating to human remains. You know, on a Thursday afternoon, when families fight over where a person should be buried, in terms of the regulations to the National Health Act, magistrates do those disputes. Yes.
Okay, in paragraph 8 of the questionnaire, you were required to furnish particulars of your membership of any political organization, past and present, and you indicated ANC and that you were a member from 1990 to 2006, is that correct?
That is correct.
But from 1999, you were already a magistrate. How did it happen that you continued to be a member of the ANC while you were a magistrate?
We grew within a judiciary in the lower courts that came with its own baggages. And magistrates ordinarily, when at the time that I was an interpreter, I'm talking about before 1994, soon thereafter, magistrates participated in that space. And until the Magistrates Commission took some resolutions, and then we stopped. Yes.
Now, when you say magistrates, I guess what you are simply saying is for a certain period, magistrates, it was common for magistrates to be members of political parties.
Exactly. I can just give you an example, ACJ. During the referendum, whether South Africa should go into a constitutional democracy and what, magistrates openly wore Conservative Party and National Party colors to courts. That's the space in the magistracy that I observed.
Yes. Would this phenomenon of magistrates being members of political parties have been confined to white magistrates before 1994, for example, or was the position that even black magistrates also did the same?
It was across the board. And that's why when we started moving to the realization that we are a part of the judiciary and we can't do that, we got rid of those practices that are antithesis to judicial office.
And did you say that this stopped only when the Magistrates Commission intervened and made a ruling or something?
And the debates within the organized profession of the magistracy, yes.
Okay, and when was that?
I have to say, some of the resolutions that I recall of the Magistrates Commission were specifically in 2005 in relation to in which areas magistrates should participate. Yes.
Okay, and you have been acting in the High Court for some time, is that right?
Yes. As of now, for both Johannesburg and Cape Town, I would have acted, I'll be in my 10th term because now I'm acting currently in the Western Cape. I'll be in my 10th term.
You have been acting continuously for quite some time, is that right?
Except for 2019 and 2020 and this year, it wasn't continuous. The only time that I acted for a full year for all the terms was 2018.
Okay. Judge President.
Thank you very much, Chief Justice. Mr. Tulare, there are two problems in my view which confront judicial officers in the Western Cape. One is racism, and the other one is forum shopping, whereby if a case is allocated to a black judge and we have these high-powered counsel, particularly white male advocates, they would find excuses to run away from that black judge to whom the matter has been allocated. How do you think, do you have any suggestions as to how we can minimize or eliminate or eradicate forum shopping?
I think case management, it's necessary in that my own sense is once a matter has been allocated to a judge, I would enjoin that judge presidents return that matter to that judge whenever it is placed on the roll again. That's one of the strategies, because what happens is there would be one or more reasons as to why parties would seek a postponement. Sometimes they would say we are trying to talk settlement, and then the case gets postponed because they are talking, and then they would try to re-enroll it, hopefully with the idea of getting another judge. But I think if we get a system in terms of which once you allocated a matter, you are deemed to be seized with that matter, it will mitigate.
Any other views in that regard?
I think there should be a way of calling out this council. I'm just not sure yet on how we should do it, but I think sometimes naming and something with its true name makes sure that things do not fall in the cracks, because people realize that you are being noticed. Yes.
Thank you, Judge President. Ms. Stewart, I give you the opportunity now to put questions to the candidate if you wish to.
Thank you, Acting Chief Justice. Hi, Mr. Tulare. I have two questions for you. The first is, in the comments by the General Bar Council, they mention a matter of yours that has gone on appeal, which you don't mention in your list. They cite it as S versus Cooper. It's quite oddly, it's got an odd citation and I couldn't find it. Do you know of another case of yours, S versus Cooper, that went on appeal and it seems it was successfully appealed?
It was a petition, if I recall correctly. Yes, it's a matter. It was a full bench matter. I sat with. I'm trying to remember the name of the judge because I am used to referring to him as Braden, Judge Dlodlo. All right, I sat with Judge Dlodlo in that matter. He was the senior judge. We agreed on what the position was. If I recall correctly, it's a matter that dealt with the maintenance of a child. It went to the SCA, and indeed the SCA found otherwise. That is correct. I have to say that I became aware later because sometimes we do struggle, especially if it's not a full written judgment that comes back. Sometimes it becomes difficult for one to trace these judgments whenever they go for higher relief.
Okay, thank you for that. And the second question I have is, in the realm of administrative law, there's a difference between an appeal under PAJA and an appeal under the principle of legality.
It would be a review.
Sorry, not an appeal, a review. And I'd just like your understanding of the difference between the two types of review and how that difference came about.
One always visualizes, a big coat covering a number of children underneath it when one speaks to PAJA, because remember, organs of state and officials, especially officials of the state, took an oath of secrecy in the old dispensation. And as a result, the general public and ordinary men and women would not have access to the information that functionaries of the state would have had and the decisions that they made. It is against that background that I think the founding fathers of the Constitution decided that we must have a different approach and philosophy in relation to how we deal with administrative acts of organs of state. And that's how I understand the review under PAJA, to say it must be a lawful a decision, it must follow a particular process, it must be reasonable and fair. That's the review under PAJA. And then you have other decisions, like one state department against the other, or decisions of the executive, for argument's sake. Those who are not organs of state, but you need to have those decisions revisited, and that's the other review.
Okay, thank you, Acting Chief Justice.
Thank you, Commissioners. Commissioner Nyambi.
Thank you, SCJ. Evening, Mr. Tula.
Good evening, Commissioner.
I have just one question. As SCJ has indicated that we have interviewed you 2 times in the past, probably something that you think is significant that we must consider that might have happened then and now that will make you to be one of those to be recommended this time around?
You grow as a person and you learn, all right? And you can assess from the questions that the commissioners are asking areas of concern, and you work very hard towards improving yourself on those questions. I do not regard myself as a person who's beyond correction. And there are lessons that I have learned from the questions, some of them critical, that have come across through the past 2 interviews. And I have grown as a person. I have grown as a judicial officer. I have grown as a state official.
Thank you, Mr. Tulara. Thank you, SCJ.
Just as a follow-up on that, on Commissioner Nyamba's question, I would encourage you, if you are comfortable with this, that where you think you may have done something that deserves correction, and you think you have realized it, that you feel free to share that with the Commission. I say that because although I wasn't here in the April interviews, I've read a part of the transcript. So I'm not asking you to do anything you are not comfortable to do, but I'm just saying if there is something that you might have looked at and said, look, maybe this I could have handled differently. I just want you to encourage you to consider doing that. You understand that I'm not saying do anything you are not comfortable to do.
Yeah, no, I'll touch on one thing which is very important for judicial office, and which I gathered was an area of concern, and that is the speed with which one delivers judgments, especially in urgent matters. I do not want to sound to justify the judgment that was the subject matter of discussion, but I approached, for instance, the position from the fact that degrees of, insofar as I understand the law, there are degrees to agency. In the example that I gave, where parties come and argue over who should bury, you can't take a month to decide. You have to decide within a short space of time. And I had occasion to deal with a matter which came, it was property that was seized related to allegations of proceeds of crime. And the matter came before me because the person whose property was taken claimed that they want access to some of the funds to deal with, to cover their maintenance needs, as well as funds for litigation, including provision for the possibility of an appeal to the Supreme Court of Appeal, including to the Constitutional Court. And because this was, the maintenance part didn't give me problems, but the area related to whether funds should be released, and if so, at what quantum and what criteria one should follow in determining that, I took time around that. And that related to the criticism that was leveled against me in relation to that. And I've learned from that to say, look, an urgent matter is urgent, and perhaps one should reflect on these matters and make sure that it is a concern. I've also watched some of the interviews, not only during this session, but in the previous sessions, and I've seen that it is a theme of the commissioners that judgments should be delivered expeditiously. And that got to me. I got the message loud and clear, Acting Chief Justice.
Thank you. Minister?
Yeah, no, thank you very much, Magistrate Tulare. Good evening.
Good evening, Mr.
Yeah, for sure you have seen that we have been here since Monday, and today it's a Friday evening. Seeing you coming at this time excited me, because in the last interview I heard for the first time that you can sing very well. So I thought we will be woken up. My question, Magistrate, is my question relates to, I see that one of your stints you worked for the South African breweries.
Yes.
And during this period of COVID, as government, we had a lot of back and forth with the liquor industry.
Yes.
What is it that you think, if you are brought into the judiciary, you will be able to help this country with, in terms of your interpretation in relation to responsible drinking of alcohol, and the manner in which you will deal with matters that might relate to this industry that will promote responsible behavior with regards to alcohol, because most of the social ills, it has been proven, does come from this. And I'm sure when you work for the breweries, you have some, you may not be having an expertise, but some general knowledge, and you might still be interested in this industry.
Minister, one observation that one makes in relation to alcohol and to an extent also drugs generally is that the criminal justice system's response, in my view, tends to be inappropriate. And I think there's one judgment that forms part of the pack where I hold this view that whenever a person comes to court and the person is convicted of what one may call a social ill, and or perhaps an illness, a punitive sanction does not help, in my view. So you need to put in programs in place, psycho and social interventions to deal with the abuse of alcohol and drugs. And noting that government ordinarily does not have loads of cash to deal with that. In my view, it is those who benefit financially from exercises that avail these substances that leads to problems, who must then make some form of a contribution in the programs that we put in place to assist those who are struggling. Because if I have worked in a court, the magistrate's court, which deals with persons who have got problems with the drugs. What I have learned is that, and even abuse of alcohol, what I have learned is, in the main, there's always an underlying psychosocial, if not a psychiatric problem. So we are not addressing the real issue by sending the person to Portsmouth for 6 months. We are not addressing the underlying problem. And that's where we should dig. And in that digging, these institutions that then derive an income from providing these substances must be engaged to provide resources for the programs.
Thank you, Acting CJ.
Thank you, Minister. Commissioner Totovu.
Thank you very much, ACJ. Good afternoon, Mr. Tulari.
Good evening, Commissioner.
I'm closely observing you, and I'm thinking of what happened during the April interview. I see much difference. I'm inspired by your articulations and even how you respond to questions. And for me, this is quite important. It shows some improvements in that respect, because personally, I didn't like that singing and all of those sorts of things. With that in mind, do you understand the principle of, or the doctrine of double jeopardy?
Yes, I do.
Well, what does it mean in the context of this commission and what happened in April?
Can I ask your protection, ACJ?
In that sense, I meant that let bygones be bygones.
I was not in April.
It's okay, you can't be punished 2 times for the same crime. All right, thank you.
Thank you.
It's okay. Sorry, SCJ, that is on condition that he gives us a live performance.
Commissioner Mpofu.
Thank you, DCJ. If you want a lawyer, I can represent you. If there's any double jeopardy, you are not involved. Yeah, thank you. Mr. Tulare, I just wanted to ask you, There's one curious fact about the Western Cape bench, which is this, I don't know what you call them, two bench sittings in civil matters.
Yes.
Which we don't do here. So I want to ask you firstly about that. Well, let me ask it like this. Here we develop skills to ask two questions and make it look like one so that the DCJ doesn't detect it. So, so I want to ask you that question in relation to the difference between the magistracy and the bench, because obviously as magistrates you always sit alone.
Yes.
So how for a person who has been in both systems, how do you deal with that difference, and what does it really signify for you, or rather, what are the characteristics of this two bench thing, particularly in relation to the following issue? What happens when you differ, if the two persons hold a different view? Because we know that one of the reasons for the odd number configurations, full bench 3, SCA 5, Concord 11, theoretically, is to use that for the tie breaking, as it were. In the two judge bench, how do you deal with those?
Look, let me start by saying the difference of opinion between judges should not be viewed negatively. It is quite enriching, not only for the judges themselves, but for our jurisprudence. So what happens is, let's say for argument's sake, the JP allocates a matter wherein I sit with him. I would read the papers, and once I have formulated a view, I inform him as the senior judge to say, JP, I'm ready. And then we engage. He obviously leads the discussion, but the crux of it is to determine what my view is and whether in fact we agree. Now, where there's a difference of opinion, there is engagement first. All right, it's not a question that I stand by my position and he would stand by his position and that's it. We try to see if actually I can understand the world from the doorway he's standing, and whether I can take him to the window where I'm standing and he can see the view, because the views are different. It is only in instances where after that engagement and that exercise, we can still not find each other, that he will have to make a decision on the way forward, whether to constitute an entirely new bench altogether or to add another judge so that we are three, and then we'll go through this same exercise. If it's an additional judge, we'll give the judge an opportunity to read, and once that third judge has made up a view, and then we come for the conference, we discuss, all right. And obviously, there's generally no third view. There are only two views to a question. So one of us would be outvoted, and that would be the decision. And then it goes to the writing then. If I feel strongly about my view, I'm obviously going to write a dissenting judgment on the understanding that the other judge agrees with the JP. So they would write their view, and I would also write my view. And that, as I say, difference of opinion between judges should not be viewed in a negative light, to say they don't know what they are doing. It's actually enriching, and it's a setting. It's a demonstration to South Africans that we actually apply our minds and think independently on the papers before us.
And yes, the follow-up is the experience of coming from a bench where you always sit alone versus sitting in a panel. How do you transition between those two?
Yeah, in the beginning, it's a little bit strange, especially where you find that it's easier where you agree with the judge. But when you hold a different view, and especially as a junior judge, sometimes you reflect and reflect. It's only when you have written the third draft, personally, it is only when I have my third draft and I still cannot agree that I would stand by my position.
Okay, thank you, Chair.
Thank you. Commissioner Mpofu, is a follow-up another way of disguising two questions?
To get a third question.
Commissioner Nochesi.
It's just a follow-up. Tell me on this, there's something that traveled. Is it permissible for judges to then, in the context, to discuss matters among themselves?
There is nothing. I have to be very careful here, I think, in the context of the climate where I find myself. But let me say, discussions amongst judges, in my view, should be encouraged. It shouldn't be discouraged. Because as I say, it helps a lot. Let me not speak about the judges. Let me take you to the scene of the magistrates' court. The tea room is a learning center. The tea room of a magistrate's court, it's basically a workshop session, all right? When I'm sitting with a matter and there's an argument by Mpofu SC on a particular point, and I've got a particular view on it, I bounce it with my colleagues in the tea room during tea break. There's nothing untoward about that. All right. Yeah, let me rather stick there at the magistrate's court and not come to the High Court. Thank you.
Thank you. Thank you. Commissioners on the... Oh, I'm sorry, and you. Mlambo JP, I didn't put you down, but you can go ahead and then... Oh, I've got, yeah. Mlambo JP?
Acting Chief Justice, I think Commissioner Tsepe was before me long time. So
Yes.
I'll ask her to speak before I speak.
No,
Can I continue?
This side of me is confusing me. No, it's fine. Let's go to her. Commissioner Tsepe.
Thank you, Acting Chief Justice. Good afternoon, Mr. Tilari.
Good afternoon, Commissioner.
Mr. Tilari, I'm sure you would have been provided with the comments from various law bodies,
Yes, I have.
including that of the General Council of Bar.
That is correct.
In paragraph 15 of their comments, under the heading, the candidate judicial temperament,
Yes.
they raised issues regarding your judicial temperament, and they referred to 2 incidents in that regard. Would you care to comment on those issues and discuss? Did you have an opportunity to look at that?
Yes, I think I've provided a written response as well to the commissioners. But let me say, the matter was in what we call the 3rd division in the Western Cape. That is the unopposed role. All right. Now you sit generally with around 60 or more cases during that time, 2017. All right. So it is a debt of a credit card incurred by the mother of the house. ABSA approached, issued summons against the mother. They came to court. What they claimed was foreclosure of the property owned by the mother. And the issue of the father not being there and being a joint owner arose. That was before I became engaged. I'm just setting for you the background. Then the father gets joined. Then he gets served with the process. And then there is no notice of intention to defend file. The matter comes before me on the 31st of October 2017. It is a request or a prayer that I must declare the property of the family specially executable so that they can sell their home to recover a debt of around 160,000 or just over 160,000 of monies owed. All right. Now, in ABSA's own papers, they indicate in an affidavit that 2 days prior to that, 3 days, on the 28th of October, there's an attorney who contacted ABSA's attorneys of record and indicated to the attorneys of record to say, I do not have instructions to enter an appearance to defend and join issue because the family says they do not have money for high court litigation. They are prepared with what they have to settle the debt. All right? That's an affidavit that's on the papers. I come into court, counsel rises when the matter is called, husband and wife rocks up. Now, immediately you can, with regard to a default judgment, there are those two legs, absence and a defense, right? The absence is already doubtful because husband and wife are physically inside the courtroom, but there is no notice of intention to defend filed, all right? Against this background, I engage counsel to say, but where the parties indicate that they are willing and able to settle or make a payment rearrangement, is it not proper that we give them the opportunity to engage with your attorney? All right? And it is that which led to the undertaking by counsel, amongst others, when the matter gets postponed, because I postponed that matter for that very reason, that the parties then need to talk. All right? I postponed the matter to a date. Counsel undertakes in open court that they will provide the details of the attorney to husband and wife. That's the end of the matter. They leave the court. Now, understand the setup at that time. As I say, you have around 60 matters. You first deal with removals and strikes offs, and then you start with these default judgments. So it's very early, and it's the unopposed roll. The courtroom is full. Remember, on my roll, there are divorce matters, there are Rule 43s, all these other matters that are dealt with in the division. So the courtroom is still full by that time. Counsel undertakes in a full courtroom that they will provide, and the matter is postponed. I've dealt with that matter, that's it. Soon after they've left, husband and wife comes back. And you can see that they're upset, and you can see that they need the attention of the court. All right? I give the attention to them after I dealt with the matter that I was dealing with then. And then I get advised that when they left, counsel did not want to talk to them. He simply left them and walked away. All right? And it is against that background that it is happening in open court. And remember, we are in the Western Cape. All right? The family is black. You have a black judge. Counsel is white. All right? And this is the treatment against the background of South Africa. All right? I know, and that is why I made a comment to say the legitimacy of the court processes, the decorum of the court, and the trust of court officials, it's bigger than Daniel Tulare and Lauren Bosman. So I indicate to them to say, if that's what you have experienced, I do not expect what you are reporting to me from an officer of the court. And I apologize to you if that is what you have experienced. But what I can suggest to you is the matter stands postponed to the 31st, or I think it was the 10th of December or somewhere around, to say the matter stands postponed to that day. Make an effort to first go to the bank, and the bank will indicate to you who their attorneys are if they can't help you themselves with your offer. And also go back to the attorney that you had talking to APSA's attorneys so that the matter can be taken forward. That was the end of the matter, all right? The next day, I got to know through the registrar that Van Rooyen SC wants to see me and she wants to come with Advocate Bosman. And it's in relation to discussing what happened the previous day. I did not understand that to be a complaint against my conduct, because I can tell the commission now to say, had I understood that I was actually the subject matter of that meeting and my conduct for doing what I did, I would have said, well, I've got a leader. I want the judge president to know. But because for me, it was something that happened outside the courtroom, and the advocate wanting to explain to me what had happened in the presence of a senior counsel who's involved with training, I didn't even deem it made to inform the JP about it. We spoke about it, and for me, that was it. And that is why I was taken aback about what was then narrated. But that's the context of what happened. It is unfortunate that I went back to, you'll see from my response that I actually wanted the transcript of the record, because it wouldn't have been a long transcript. It was short proceedings. But unfortunately, I couldn't get that. But that's what happened.
Thank you. Thank you. Commissioner Schlemmer.
Thank you, Chief Justice. Good evening, sir.
Good evening.
I just want to ask you about something that you said when I think it was Commissioner Dudor who asked you whether you have kind of reflected on everything that went past in the last two interviews. And then concerning the delayed judgments, you said that you looked at some of the previous interviews and you realized that it is important for the commissioners. Is that the only realization that you have? I would like to know what you think about the fact that we do feel it is important that judgments should be delivered on time. I just want to know what your sense of that is, because your answer didn't tell me that you really reflected as to what the meaning is of delivering judgments late.
No, I have accepted the sense of agency, and I've learned from that. That's what I conveyed to say. I had moved, as I indicated, to say I had moved from the premise that there are degrees of agency. You know, there's something immediate, and with a matter that's a little bit that needs some time, because I have to state this. I wrote a full judgment on it. I just didn't give an order to say I'll write reasons later, which is a practice that I don't necessarily like, which is perhaps what I ought to have done, to give an order and then provide the reasons later. All right, I wrote a full judgment, and the judgment was accepted because it was never taken anyway, which means I explained the position as I understood it. But the point that I was trying to make was to say, I have taken note that judgments should be delivered expeditiously. And that message got across loud and clear.
It's because justice delayed is justice denied, sir.
Yes, that's true.
Judge President Mlambo.
Thank you very much, Acting Chief Justice. Good evening, Mr. Tulare.
Good evening, JP.
Just a basic question, if you don't mind. You're sitting in the Western Cape Division of the High Court, you're doing a trial, and you're confronted with irreconcilable versions. How do you approach the matter? How do you deal with it?
If it's two irreconcilable versions,
yes,
then I go on to assess the truthfulness of the versions and the credibility of the witnesses. And if I find that on the balance of probabilities, the plaintiff has proved their case, I will find in their favor. If I find that they didn't, I dismiss.
Thank you.
Commissioners on the virtual platform, any questions?
Thank you, SCJ. I'm covered.
Thank you. Nobody else? It looks like, thank you. It looks like we have come to the end of this interview. Thank you very much, Mr. Tulare. You are now excused.
Thank you, SCJ, and good evening to everyone.
Next candidate. Commissioners, let's start. Good evening, Mr. Saleh.
Good evening, Acting Chief Justice and other commissioners.
Welcome to this session of the Commission's interviews. Thank you for making yourself available for consideration for appointment as a judge of the Western Cape Division of the High Court.
Thank you.
I see that you hold a BA degree and an LLB degree, and that both of them were obtained from the University of the Western Cape.
Indeed so.
And you got your BA in 1981 and your LLB in 1983.
Indeed so.
Thereafter, you served articles as a candidate attorney 1983 to 1984, actually up to 1985, is that right?
Yes, the 2-year period of articles.
Yes, and you were admitted as an attorney in 1986.
Indeed so.
And you practiced as such in different law firms. Well, you started with, is it Gataka and Sally? You must have been a partner there.
Indeed so.
And after some time, you went on your own and practiced under M. Sally and Associates from 1990 to 1995.
Indeed so.
And in 1997, you were director at Myers Incorporated.
Indeed so.
Was that a law firm?
That's a law firm with 5 directors, and 2 years there, and I went to the bar in 1999.
There is a gap here. What were you doing in 1996? Or did you take a gap here?
No, there's no gap, Acting Chief Justice. I was continuously practicing as an attorney.
Well, on page 18 of this bundle, you wrote that from 1990 to 1995, you were at M. Sally and Associates. And then the next item below that says from 1997 to 1998, you were a director at Myers Incorporated.
No, it should be 1996 onwards
So
for the
there's a gap
directorship.
of 1996.
No, that's an error. It should be right through then as a director from 96 onwards.
Yes. In 1999, September, you admitted as an advocate and you joined the Cape Bar.
Indeed, sir.
And have you been practicing as an advocate since then?
Indeed so, Acting Chief Justice.
And when did you take silk?
I was conferred silk in 2013, and in 2015, the conferral became through via the President's office.
Yeah.
We waited for 2 years almost.
Yes. Now, what types of cases as your practice concern? I mean, what types of cases have you been doing in your practice as an advocate since you, well, starting from when you were an attorney? Let's start with that first.
Yes.
What types of cases were you handling?
Chief Justice, when I started and commenced at the sidebar, I did criminal law virtually every second day. I did civil trials probably twice a month. I appeared in a motion court on the third level of the Wynberg court, in other courts as well. And similarly, when I went to the bar, I continued to be a practicing lawyer. It was a trial, my practice was based on a trial practice.
And in terms of branches of law, as an attorney, when you are not dealing with criminal matters and you are dealing with civil matters, what kind of branches of law were involved in your practice?
There's limited extent of admin law, contractual law, insolvency, liquidations. It's a middle of everything.
Yes. And then...
I must, sorry, I apologize.
Yes, just if you want to complete that
We're
answer.
obviously not exposed to acquisitions and all this other high-level commercial work.
Yeah. And in your practice as an advocate, what branches of law were involved in the matters that you have been handling?
Again, criminal law. My first brief when I joined the bar was a murder trial. So I commenced with conducting criminal law, criminal trials, civil trials, motion court, again, the odd civil application, liquidations, sequestrations, but not the high mergers, etc., etc.
Yes. And you have acted in the High Court as well, isn't it?
Indeed so, Acting Chief Justice.
How many weeks have you accumulated in acting stints?
Acting Chief Justice, when I took silk to 15, I was invited by the JP to come and act. To 17, I acted half term. To 20, I acted two full terms. And this year, I acted full term, a full term as well.
Okay, okay. And during your acting stint, you did both civil and criminal trials?
Indeed so.
Yeah.
Indeed so.
Judge President.
Thank you very much, Chief Justice. Mr. Sally, are you related to any judge in the Western Cape who sits on the bench?
No.
I'm asking you this because one commissioner asked me if you are not related to Judge Sally. All right. Let's talk about Rule 46A applications. There is a practice in the Western Cape whereby when a judge fixes a reserve price in respect of property that should be declared executable, an attorney would depose to an affidavit and say, no, we have not been able to secure this particular amount. which was set by the judge as a reserve price. And then they would bypass that particular judge, take the file to another judge in third division, which is unopposed role. Do you have any views in respect of that practice? Is it not deplorable?
JP, my view is that that's highly unethical. And that particular counsel, whoever he or she is, must be reported, and no further allocation should be made in respect of that particular matter. Thank you.
Still on Rule 46As, would you take a sheriff seriously if the sheriff in his return of service says, I knocked on the door, there was an elderly lady who opened the door, I asked for Mr. Hlophe or whoever as the case may be, and this lady said, Mr. Hlophe does not live here any longer, and therefore this is not a primary residence, and therefore, so runs the argument, the reserve price must not be fixed, which is common in the Western Cape. Would you take that sheriff seriously?
No, not at all.
Thank you. Ms. Stewart, I now give you the opportunity to put questions to the candidate, if you would like to put questions to him.
Thank you, Acting Chief Justice. Hi, Advocate Sali. I have two questions for you. The first is pertains to a comment by the General Bar Council at paragraph 15.1. I'm sure you're aware of it.
Yes.
Where they mentioned that some of their members have commented that you become easily abrupt and annoyed, and they made a curious comment pertaining to the fact that they think you have not the ideal judicial temperament, but sufficiently appropriate judicial temperament. I was wondering what your comments are about being sufficiently appropriate but not ideal. You can just let us know what you think.
Commissioner, I find that anomaly striking. In the one breath, it has been contended that I become annoyed, but in the same breath, I've been told that I have sufficient judicial temperament. You either have it or you don't have it. I believe that comment, secondly, is misplaced. I can't respond to that comment meaningfully because I don't know under what circumstances that comment had been made. My practice is trial-based, and sometimes you get to the nub of the matter. And of course there will be debates, and serious debates about the matter. To what extent that is annoying, I don't know. But in the absence of a meaningful averment or assertions, I really can't respond to that. It is, I think, very, very naughty on those who decided to make that comment, because the GCB says, if appointed, you will have a sufficient judicial temperament, ACJ.
Well, Mr. Sully, I'm not sure if it helps your case to respond like that. Here is a comment that has been made about your temperament, and Ms. Stewart gives you an opportunity to comment on it. And your comment, certainly to me, your response or comments or remarks on it appear to reflect that you get worked up. So I'm just saying, I'm not sure if it helps you if you don't deal with it properly.
Yeah, very well, ACJ. What I'm submitting is, it is unfortunate, as I alluded to, there is the trial issues at hand, and there are certain debates that goes hand to hand, and it becomes sometimes, I don't say abrupt, but it's a debate between the parties.
You see the comment they make. It could be a genuine comment. And if it's a genuine comment, you could deal with it. They could be mistaken. And your answer could be, well, I don't know the factual basis, but here is how I deal with matters, and I believe that there is no basis for criticism if that is the case.
Thank you, ACJ. I believe there is no basis, really. I felt, and I thought long and hard about this issue, and I can't pinpoint where and how this could have come about.
Yes. Questions, commissioners?
Sorry, Acting Chief Justice, can I ask my second question just for the
Oh, okay. Yes, yes. Mm-hmm.
Advocate, sorry, I've asked this question to all our candidates, so I'm going to ask it to you. I'd like to know your understanding of the distinction between a review under PAJA and a review under the principle of legality, and how the distinction came about. It's obviously very close to the organ of state that I work for, so I'd like to know how you understand.
Commissioner, pursuant to PAJA, an organ of state's discretion or decision can be challenged under PAJA. However, the very state entity who wants to collapse its own award, that particular basis must be the principle of legality. Insofar as the executive or the executive powers are concerned, I'm of the view, again, that's founded under the principle of legality. Section 2 is obviously the supreme law of our land. All public power must be valid to be lawful. And Section 2 is obviously the constitutional imperative from which our entire system is based.
Thank you, Acting Chief Justice. I'm covered.
Thank you, Ms. Stewart. Commissioners, Commissioner Nyambe.
Thank you, ACJ. Evening, Mr. Saleh.
Evening, Commissioner.
Should you be given the opportunity to join the bench in Western Cape Division, what do you think are the immediate challenges facing that division that you have to assist the JP and the entire division in addressing them?
JP, Commissioner, obviously the case management system at the moment is working fine. The issue raised by the JP regarding shopping and foreign shopping, that obviously needs to be worked on. And at the moment, I think the system is working well.
Thank you, Mr. Saleh. Thank you, SJ.
Thank you, Commissioner Tudovu.
All right, thank you very much, ACJ. Good evening, SC.
Yes, Commissioner, good evening to you.
What do you think are the impediments to the transformation of the judiciary in the Western Cape? And if you are part of the judges of the bench, how can you contribute to the alleviation of those impediments?
As far as transformation is concerned, Commissioner, I can assure you that I, in my own personal capacity, nominated and endorsed the appointment of black practitioners to the bench. That is so. It is on document. I've also written notes to this commission when ladies had applied, and I'm the view that there must be transformation on the bench.
What are the impediments to that transformation?
The impediments, I can see that junior counsel must be empowered. And I can assure you, I have done my duty to empower junior counsel throughout my tenure at the bar.
And you said, I didn't hear that well.
I have.
You said if you are afforded the opportunity, what contribution can you make in ensuring that there is a realization of transformational goals in the bench?
Well, I will promote the transformation of the bench clearly, and I will proclaim that to other colleagues, and of course, by endorsing and empowering Black counsel at the bar.
My last question in that respect is a follow-up, ACJ. I read an article some few years back where an author was arguing that there ought to be a special dispensation, which means special rules for the interviewing of judges in the Western Cape, specifically in the Western Cape, not in the country. What is your view on that?
Yeah, I'm of the view that judges must be interviewed through the commission as per statutory proclamation.
All right, thank you very much. Thank you, ACJ, and I beg your indulgence on that.
Thank you, Commissioner Dodo. You first said my last question, then you said follow up. Which one? Give me an honest answer. Commissioner Mtolo-Lepu.
Thank you, Acting Chief Justice. Good evening.
Good evening, Commissioner.
You know, I'm listening to you when you say the previous Commissioner Dodogo asked what do you think can be done to transform the judiciary in the Western Cape? And somehow I feel that that answer is incomplete. Because for me, if you say junior advocates must be given briefs, it's quite abstract. I think what I wanted to hear is to say what are you actively going to do or to encourage if you are being appointed, and what mechanisms you may encourage maybe the minister to put in place, or I'll say the acting CJ, because he still is acting, and the JPs. I think it can't be the JP only, but what other judges, how are they doing things to make sure that transformation is happening?
If I'm appointed Commissioner, it is obvious that I will ask the JP's office perhaps to get gatherings going, female advocates convening and imparting certain lectures to them where they may be lacking in specific periods or issues, to empower them to become and realize their potential on the bench.
Chief, it's the first time I say follow up. Okay. Chief, I'm just thinking that it seems where I'm sitting, it seems transformation in the judiciary in the Western Cape is quite different from transformation in the judiciary from other divisions. There must be something extraordinary that needs to be done, because we cannot be talking about transformation in the judiciary in the Western Cape and things are not improving. Other divisions are improving, we can see that, but I think even the judges there need to actually actively promote transformation. And I will appeal to you, because we have, it's not you, I'm not talking about you. There's a tendency we appoint you, then you relax. So I'm appealing to those who we appoint to take this fight forward. Thank you.
Thank you, Commissioner. I'll take that point.
Thank you, Commissioner Schlemmer.
Thank you, ACJ. Good evening, sir.
Good evening, Commissioner.
Could you share your judicial philosophy with the Commission, please?
Commissioner, I grew up in a place called
Don't move away from the mic.
I grew up, sorry.
We won't hear you if you move away from the mic.
I grew up in a place called Elsie's River. It's a sub-economical area. I went to school there at Elsie's River High. I engaged with the communities throughout my schooling career. I went to UWC. I engaged and traveled distances to get to campus. So it was a battle, a struggle. That's the one front. We know during the 80s, there was a deprivation, there was the elimination of dignity, equality, and freedom. Come 94, 96, those particular qualities were restored in us. So my judicial philosophy, once the Constitution came into operation, it's the supremacy of the law. We apply the Constitution, we develop the common law in accordance with the Constitution, with our Bill of Rights, dignity, equality, freedom, and this is my judicial philosophy. The supremacy of the Constitution Commissioner. Thank you.
Thank you. Commissioners on the virtual platform, is there anybody who has a question there?
No, thank you, ACJ.
Thank you.
If I may ask, ACJ?
Yes, go ahead, Commissioner Barnett.
Thank you. Good evening, Acting Justice. When it comes to judicial temperament, it's really a follow-up from previous questions and so on. What are your strong points and what are your weak points?
I believe that I'm a good listener. I can accord the parties the hearing, ad alteram partem. Rule is obviously of paramount importance. Having listened both parties, I will then obviously look at the argument and adjudicate on the matter. The weak points perhaps is, in order to clarify certain issues, I would interrupt perhaps counsel to get clarity going. And I'm of the view that given what the GCB has said, obviously it will be in the forehead that just be careful and listen out and bear out the parties completely and adjudicate on the matter.
Thank you. Thank you, Acting Chief Justice.
Thank you. I think we have come to the end of this interview. Once again, thank you for availing yourself, Mr. Sally, but you are now excused.
Thank you so much, Acting Chief Justice.
Thank you. That was our last candidate. Not so bad.
Please make sure that
Let's get to deliberations, commissioners. Let's deliberate, let's deliberate. Or are too many out? Let's have deliberations. How the JP has gone out there as well. Or maybe we should take a 5 minutes break and then come back. Oh, or are they back? It will end up being